ಹೇಳ್ತೀನಿ ಏನಂತಾರೋ ಇಲ್ಲ ನಾ ಅದು ಮಾಡ್ತಾರೋ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ರಿ ಬರ್ರಿ. ಬೇಡ ಬೇಡ ಹಂಗೆ ಬರೋದಿಲ್ಲ. ಆ ಜಜ್ಮೆಂಟ್ ಆದಂದ್ರೆ ಈಗ ಜಜ್ಮೆಂಟ್ ಆತಂದ್ರೆ ಮುಂದೆ ಅದು ಇದು ಆಗೋದಿಲ್ಲ. ಅದು ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ. ಬಟ್ ನಾನು ನೋಡ್ತೀನಿ ಬರ್ತದೆ ಏನು
ಮತ್ತೆ ಹ್ಯಾಂಡಲ್ ತಗೊಂಡಿಲ್ಲ.
ಫೈಲಲ್ಲಿ ಕೇಳು.
ಇಲ್ಲ ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ಹಾಕ್ಕೊಂಡು
ನಿಮ್ದೇನು ಹೇಳಿದ್ದೇನೆ ಬ್ಯಾಂಕ್
ಹೇಳಿದ್ದೀನಿ 130 ಬರಬೇಕು.
ಇದೊಂದು ಫ್ರೆಶ್ ಇದೆ.
ಸ್ವಲ್ಪ ಹೋಗ್ತೀರಿ
ಮಿನಿಮಮ್ ಕೇರ್ ನನಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಕ್ಕೆ ಇದನ್ನ ಮಾಡ್ಯಾರ ಹೊಸದೊಂದು ಏನೋ ಮಾಡಕ್ಕೆ
ಹಂಗೇನು ಬಂದಾಗ ಇಬ್ರು ಕೋರ್ಸ್ ಮಾಡೋಣ.
ಅಪ್ಲೈ ಮಾಡೋದು ಆಗೋದಿಲ್ಲ. ಸಾಹೇಬ್ರು ಬಂದ್ರೆ ಅಲ್ಲಿ ಎಷ್ಟೊತ್ತಾಗ ಇರ್ತಿದ್ದೆ ಏನು ಮಾಡೋದು ಕೆಲಸ ನಾ ಏನು ಮಾಡ್ಬೇಕು ಹಿಂಗೆ ಹೇಳ್ಬೇಕಾ? ಹಲೋ, ಪಾಲಿಸಿ ಅಂತ ಏನಾಯ್ತು ಅದನ್ರಿ 1436
ಮೇಡಮ್ 230 ಇಲ್ಲ ಹಂಗೇನಿಲ್ಲ, ನಮ್ದೇ ಹಂಗೆ ಸಮಸ್ಯೆ ಇಲ್ಲ ಮೇಡಮ್. ನಂಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ, ನಾನು 230
ಸಬ್ಮಿಷನ್ ಮಾಡೋದಾ? ನಮ್ಮ 12 ಇದನ್ನ ಎಷ್ಟು ತಾರೀಕಿಗೆ ಹಾಕ್ಸ್ತೀರಿ ಇದನ್ನ? ನಾಳೆ 230 ಇಲ್ಲ ಫ್ರೆಶ್ ತೋರ್ ನಾವು ಮತ್ತೆ ಬೇರೆ ಕೊಟ್ಟು
ಇದು
ಮಂಡೇ
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್.
Fresh matter. Monday.
ಇಲ್ಲ ಅದಕ್ಕೆ ಸರ್. Madam, serial number 53 withdrawal.
Madam, memos.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮಂಡೆ. ಒಯ್ ಅದು ಕಾರಣ ಅಲ್ಲ. ಕಾರಣ ಏನು? ಅರ್ಜೆನ್ಸಿ ಹೇಳು. ಎರಡು ದಿನ ಲಿಕ್ಕರ್ ಮಾರದೆ ಹೋದ್ರೆ ಏನಾಗಲ್ಲ. ಯಾವತ್ತು ಎಲೆಕ್ಷನ್? 2:30. ಅದೇ ಎಷ್ಟಿದೆ? ಕೊಡಿ ಕೊಡಿ. ನಾಳೆ ಬರ್ಲಿ ಬೇಡವಾ? ಆಯ್ತು, ಮಂಡೇ ಬರ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. All 23 on Monday.
But 2 matters not yesterday dispose of not being spoken to. But the 13D compliance ಅಂತಿತ್ತು. But my lord judgment ದಲ್ಲಿ by excluding petitioners vote ಅಂತ the word ಬಂದಿಲ್ವಾ? ಅಲ್ಲ, ಅದು ನಾನು ಇದರಲ್ಲಿ ನೋಡಿದೆ. ಅಷ್ಟೇ ಇಲ್ಲ. ನಿನ್ನೆ ಎರಡು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ರಿಲೀಸ್ ಆಗಿಲ್ಲ, ಮತ್ತೆ ಹೆಂಗ್ ನೋಡಿದ್ರಿ?
ಇಲ್ಲ, ಅದು ಇದ್ರಲ್ಲಿ ಯೂಟ್ಯೂಬ್
ಯೂಟ್ಯೂಬ್ ಪ್ರಾಬ್ಲಮ್ಮೇ ಅದು. ಯೂಟ್ಯೂಬ್ ಯಾಕೆ ನೋಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀರಿ?
ಅದೇನ
ಕೊಡಿ ನೋಡಿ, ವಿಲ್ ಸಿ. ಅದು ಏನ್
ಪ್ಲೀಸ್ ಅಷ್ಟೇ ಇದೆ ಅದರಲ್ಲಿ. 13D ಕಂಪ್ಲೈಸ್ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಏನಾಗಬೇಕು ಅದು ಬರ್ದು ಕೊಟ್ಬಿಟ್ರೆ
ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಮಂಡೇ.
ಇಲ್ಲ,
ಇಂಟರ್ ಮಾಡಲ್ ಏನ್ ಕೊಡಲ್ಲ, ಕೊಡಿ.
ಅಲ್ಲ, ಇಂಟರ್ಮ್ ಅಲ್ಲ, ಕವರ್ಡ್ ಬೈ ಲಾಸ್ಟ್
ಮಂಡೇ
107
ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್
My lord, 2:30.
ಏನು?
Suspension of an ESCOM officer. Suspension of ESCOM officer.
ಓಯ್ ಆಗೋಗಿದೆ. ಯಾವತ್ತು ಮಾಡಿದ್ರು ಆರ್ಡರ್?
24th ಸಸ್ಪೆನ್ಷನ್ ಆಗಿದೆ.
24th ಆಗಿದೆಯಾ? ಮಂಡೇ.
This is one matter pertaining to Bangalore bench.
Two similar matters are posted today, item 49 and 50 of list 1. There are two similar, same SSC's case at 2:30.
ಕೊಟ್ಟಿರಿ. Yes.
Please.
This one matter pertains to Bangalore bench, my lords. May I seek on 11/12? The issue is, my lords, regarding that senior citizen matter where arrears of rupees 30 lakhs is required to be paid. Matter has to come up before your lordships. Madam Rupa Rohn at 11/12, may I request, my lords?
My lords, Bangalore bench matter, my lords. Bangalore bench matter, my lords. It has to come up before my lords, my lords.
482 ನಾ?
Please, my lords.
ಸಕ್ಸೆಸಿವ್ ರೇಟ್.
Successive rate.
ಏನು?
My lords, CC is stayed, my lords.
ಯುವರ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
Please, my lords.
12th.
Please.
ಬೆಂಗಳೂರದೆಲ್ಲ ಸಕ್ಸೆಸಿವ್ 12th ಹಾಕ್ಸಿ.
Please.
One matter at 2:30. What has happened is execution ನಲ್ಲಿ warrant has been issued, my lord. Same check amount, it is settled, but
ಚೆಕ್ ಅಮೌಂಟ್
ಹೌದು, ಚೆಕ್
ಮತ್ತೆ ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು?
ಇದು ರಿಟ್ ಅವರು ಇನ್ನೊಂದು ಆರ್ಬಿಟ್ರೇಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸ್ಟಾರ್ಟ್
ಅಲ್ಲ, ಆಯ್ತು, ಇಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅದು ಅವಾರ್ಡ್
182 138 ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಅಲ್ಲ 138 ಅಲ್ಲ, ಅವಾರ್ಡ್ ಅನ್ನ ಎಕ್ಸಿಕ್ಯೂಷನ್ GMCPC ಮ್ಯಾಟರ್
ಅಲ್ಲಿ ಡಿಸೇಬಲ್ಡ್ ಅಂತಾರ.
2:30 please.
Not for tomorrow, my lord. For tomorrow, my lord, I am, my lord.
ಅವಿನಾಶ್, KNL ಮ್ಯಾಟರ್ಗಳಿದ್ದಾವೆ. ವಾಟ್ಸ್ ಟು ಬಿಟ್ ಇದು ಅವ್ರ ಗವರ್ಮೆಂಟ್ ಇದಾರೆ ಅದರಲ್ಲಿ.
We are sailing together, we are supporting.
ಸೇಲಿಂಗ್ ಟುಗೆದರ್ ವಿತೌಟ್ ಮೇಕಿಂಗ್ ಯು ಪಾರ್ಟಿ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಎಲ್ಲರ ಸರ್ವ್ ಆಗಿದೆ ಬೆನಿಫಿಷಿಯರಿ.
ಒಂದು few cases it has been served. ಒಂದು 6 ಕೇಸಲ್ಲಿ ಉಳಿದಿಲ್ಲ, ಆಗಿಲ್ಲ.
6 ಕೇಸ್ ಮಾತ್ರ ಆಗಿಲ್ವಾ? ಯಾವ್ದು ಸರ್ವ್ ಆಗಿದೆ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಬೇಕಾ?
Please.
ಸರ್ವ್ಡ್ ಅಂಡ್ 100%
ಇಲ್ಲ, ವಕಾಲತ್ತು ಹಾಕಿದ್ದಾರೆ.
ವಕಾಲತ್ತು ಹಾಕಿದ್ರೆ
ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ ಆಗಿಲ್ಲ.
ಐ ಟೇಕ್ ಇಟ್ ಅಟ್ 2:30.
Regarding remand is concerned, my lord, but only question is about they should not claim the interest, my lord. Because it is
without making you party ಎಲ್ಲಿ it's not possible even.
That observation is required, my lord.
Yes.
Because otherwise they will claim.
ಇಲ್ಲ ಅಂದ್ರೆ ಇದೇ ಆಟ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
Please.
ಬೆನಿಫಿಷಿಯರ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಸಿಕ್ಕ ಅಮೌಂಟ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್ ಏನ್ ಬೇಕಾಗ್ತದೆ?
These periods should be excluded for all practical purpose. Please, grateful.
Tomorrow at all.
Please.
So one read, my lord, for tomorrow.
In 2 matters, my lord, I have filed wakalat.
2:30 ತಗೊಳ್ಳ.
Objections ಹಾಕ್ಬೇಕು sir.
Objections ಹಾಕ್ಬೇಕಾ? ಅದ್ರಲ್ಲಿ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ?
ಅಲ್ಲ, they are neither a beneficiary nor the, my lord, interested person, party.
ಯಾವ್ದು KNN ಅಲ್ಲ?
ಹೌದು, KNN ಅಲ್ಲ, KBJNL. KBJNL.
ಅವ್ರ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಪಾರ್ಟಿ ಅಲ್ವಾ?
ಬೆನಿಫಿಷಿಯರಿ ಅಲ್ಲ. ಅವಾರ್ಡ್ ಕಾಪಿನೂ ಏನು ನೋಟಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ರಿಟ್ ಜೊತೆ. I'll produce the 4-1
ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
Next other 9th
ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ. ಐ ಟೇಕ್ ಇಟ್ ಆನ್ 10th.
Please.
Yes, my lord. I'll file
ಅಷ್ಟರಲ್ಲಿ
objection.
ಹಾಕಿ.
Yes, my lord.
ಇದ್ರ ಜೊತೆಗೆ ಯಾವ್ಯಾವ್ದಿದೆ ಎಲ್ಲ ಲಿಸ್ಟ್ ಕೊಟ್ರೆ ಅವಿನಾಶ್?
2:30, my lord.
But for
On behalf of KBJNL, my lord, Senior Counsel PP Hegde sir is coming. He is already there.
All right, I'll take it at 2:30. ಬಂದಿದ್ದಾರೆ ಅಂದ್ರೆ
ಬಂದಿದ್ದಾರೆ sir.
ಅಲ್ಲ, but for KBJNL other matters we are the beneficiary, so in that
ಯಾವ್ದು ನೀವು ಯಾರು? KNN ಅಲ್ಲ?
KNL, my lord.
KNN ಎಷ್ಟಿದೆ? KBJNL ಎಷ್ಟಿದೆ?
KBGNL ಮಾಹಿತಿ ಇಲ್ಲ. KBL have given the
KBNL beneficiaries,
Please, my lord. That is admitted. fact.
respondents are served in that?
They are yet to be served in.
Please. We'll see, all PP Hegde ಬರ್ಲಿ ಮಧ್ಯಾಹ್ನ
Please,
ಮಾಡಿ.
please.
One matter for tomorrow, my lord.
ಏನದು?
Challenging a notice, my lord, issued by the DCRE police, my lord. For tomorrow.
DCRE?
DCRE, my lord. There is a separate, my lord. Now, my lord, it has been declared as a police station, DCRE.
Oh, notification ಮಾಡಿ.
Yes, my lord. Only two, my lord, register cases under, my lord, Atrocity Act.
ಯಾವಾಗಿಂದ?
It's almost 2 months, my lord.
Oh, then I didn't know that. Kodi.
It's
It was now declared a police station, is it?
Please,
Kodi.
tomorrow.
Your Lordship,
Tomorrow fresh
My
matter.
lord, CPL number 2 for a second list, my lord, will file the objections in that and engage
ಆಯ್ತು
the
ಆಯ್ತು, ಅದು
senior.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇವತ್ತು ಯಾವ್ದು ತೀರ್ಮಾನ ಮಾಡಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಕ್ಕೆ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ವೇಟ್.
Lord, one matter for 2:30.
ಒಂದ್ ನಿಮಿಷ ಸಂದೀಪ್. ಎಸ್.
It's a dated matter that's not.
Dated matter, there is no dated matters here.
My lordship had passed an order to have it listed as.
Tax matter,
ಇಲ್ಲ, my lord. This is case which is.
ಬಾರ್ ಕೌನ್ಸಿಲ್ ಯಾವ್ದು? ಯಾಕೆ ಬಂದಿಲ್ಲ ಮೇಡಮ್? ಓ ದಟ್ ವಾಟ್ಸ್ ದಟ್ ಸಿರಿ ಎಜುಕೇಶನ್. ಓ ಬಂದಿಲ್ವಾ? 4 PM ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ನಲ್ಲ ನಾನು. ಏನ್ ಮೇಡಮ್, ವೈ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ? ಏನು ಆರ್ಡರ್ ಶೀಟ್ ಯಾಕೆ? ಒಂದು ವಾರ ಆಗಿದೆ ಹೋಗಿ. ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲಿ ಹಾಕಿ. ಎಸ್, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಬ್ರಾಕೆಟಲ್ಲಿ ಪಾರ್ಟೆಡ್ ಅಂತ ತೋರಿಸಿ. ಹಿಂಗೆ ಎಸ್ಕೇಪ್ ಆಗ್ಬಿಡುತ್ತೆ. One modification of enter matter, CC number wrongly typed. ಆಯ್ತು, ನಾಳೆ being spoken. ನಾನೇ ಸರಿ ಮಾಡ್ತೀನಿ ಬಿಡಿ. being spoken to but.
Your Lordship, matter for tomorrow. I was working as a lecturer. My retirement benefits have been withheld, Your Lordship.
Why withheld?
Your Lordship, I was terminated. Thereafter, that order was set aside by EAT. Other side has challenged it before this court. I requested.
Other side has challenged.
Your Lordship,
We'll take it on Monday. Give it.
yes.
Two petitions challenging external order.
Could 2:30.
Monday.
2:30. Justice Suraj ಅವರು ಕವರ್ಡ್. ಪರವಾಗಿಲ್ಲ, ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇರ್ಲಿ ಇದು ಕೊಡಿ ಮೇಡಮ್. ಅದೆರಡು ಪೋಸ್ಟ್ ಮಾಡಿಸಿ ಸೂರಜ್ ಸಾಹೇಬ್ ಆರ್ಡರ್.
Tomorrow.
ನೋ ಸರ್, ಟುಮಾರೋ ಆಲ್ ರೈಟ್.
Tomorrow.
Cell number 59. Cell number 59 filing ವಕಾಲತ್ 6 for.
ವಕಾಲತ್ತು ಇಲ್ಲಿ ಹಾಕ್ತಾರ, ರಿಜಿಸ್ಟ್ರಿ ಹಾಕ್ತಾರ? ಎಲ್ಲಿ ಹಾಕದ ಹೇಳಿ ವಕಾಲತ್ತು? ಅಲ್ಲ ಹಾಕಿ, ಅಲ್ಲೇ ಹಾಕಿ.
50.
ಕೌಂಟರ್ ಏನಿಲ್ವಲ್ಲ.
53 withdrawal, lordship.
53 ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Withdrawal you have for.
ವಿಡ್ರಾಲ್. ಥ್ಯಾಂಕ್ ಯು. ಎಸ್,
I sought for the liberty, lordship.
ಆಮೇಲೆ
Matter 2:30 minutes regarding. That's in my property minutes, the highway authorities are laying the road.
ಮಂಡೇ
May I say?
2:30
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, temporarily they are using my road, there is no objection. Now Millers, by virtue of that using the road, without Millers proceeding with the road which is sanctioned.
ಏನ್ ಮಂಡೇ
ಕಾಂಕ್ರೀಟ್ ಅಲ್ಲ, ಕಾಂಕ್ರೀಟ್ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಮತ್ತೆ ನನ್ನ ಜಾಗದಲ್ಲಿ.
ಡೆಮಾಲಿಷ್ ಮಾಡ್ಸೋಣ ಕೊಡಿ. ಎಸ್, ಗಿವ್ ಇಟ್.
May I say? 2:30.
ನೋ ಸರ್, ಮಂಡೇ.
Tomorrow.
ಮಂಡೇ ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ. ಹೆವೆನ್ಸ್ ಆರ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಫಾಲ್.
2:30 minute ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ ಮೇಲೆ
ಮಂಡೇ
ಅಕೌಂಟ್ ಬ್ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ತುಂಬಾ ಸಂತೋಷ. ಮಂಡೇ. ಎಸ್.
One matter for 2:30, my lords. Sandeep Patil sir will make.
ಎಸ್ ಸಂದೀಪ್, ಏನು?
My lord, day after tomorrow, 11 o'clock, there is a protest which is organized in Haveri city. We have been, the protest is regarding the conduct of Hori Habba, which has been almost prohibited in the district by the district administration. We had filed a requisition that peaceful protest we are going to hold on 6th. But till now, we have not received any communication. On the other hand, the police authorities.
2:30.
2:30. Oblige.
ಗವರ್ಮೆಂಟ್ ಇಲ್ಲಿ 2:30 ಕಾಪಿ ಮುಂಚೆನೆ ಕೊಡ್ಬೇಕು ಗವರ್ಮೆಂಟ್ಗೆ, ಅವ್ರ ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ಹೂಎವರ್ ಇಸ್ ಅಪಿಯರಿಂಗ್. ಡೋಂಟ್ ಗಿವ್ ಇಟ್ ಅಟ್ 2:30. ಐ ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಎನಿ ಆರ್ಡರ್. ಆಮೇಲೆ ವೈಭವಿ, ಗೆಟ್ ವಿಠಲ್ ಥೇಲ್ yesterday's matter.
Lordship, in that matter, I also wanted to make submission.
Submission ಇಲ್ಲ.
ಇಲ್ಲ, submission ಇಲ್ಲ. Today we have paid the amount from 25 April to.
ಕೊಟ್ಟಾಗಿದೆಯಾ?
Today morning we have paid.
Check your instructions and get Vital thing.
Yes, we have paid already.
You get him, I'll tell him. ಇಲ್ಲೇ ಇರ್ತಾರಲ್ಲ.
List 1, serial number 1, Ms. Salma.
I filed application for my lords recalling of the order. She is close associate of Bannaje Raja.
Bannaje Raja.
Yes. He is a resident of Uttar Pradesh.
Your Lordship, already co-accused has been granted bail, parole in the year 2024, and he went back to the goal
Your Lordship,
Very good,
on
madam.
time.
Be in the,
Annexure B
be
is
in the
the
goal.
order, Your Lordship.
The petitioner is, this court on
Your Lordship.
27th October 2025 had passed the following order. The learned AGA on the said date did not have complete information. Today, the state has filed an application. Recalling hakidira?
Recalling.
Filed an application, madam. Recalling hakidmal being spoken to get has filed an application seeking recalling of the order on the score that the information that they have now received is that his going out on parole will cause severe problem as several offences under the COCA and others have been invoked against the petitioner and is the close associate of another accused in the accused another accused
Gangster.
Another accused hyphen gangster. Therefore, the gangster. In that light, the order dated so and so stands recalled. List the matter on 12th to hear further.
Please.
I will hear and grant.
Please.
Yes.
Okay. Okay, sir.
Yes. Yes. Next.
Number 2, Mohan A.
They are seeking pension benefits, Your Lordship, from the date of appointment, not from the approval, Your Lordship. They are working in
That
the
is
private
covered, madam.
institution.
Covered.
Please, Your Lordship. for them.
KB Nayak and others are equal. The petitioners are before this court seeking the following prayer. The petitioners heard so and so. The petitioners are appointed on 6/6/1990 at the private aided Urdu primary school as teachers in the respective discipline. The petitioners have retired on attaining the age of superannuation. Pension is not paid to the petitioners on the score that they have not completed the requisite qualifying service for the purpose of consideration of their cases for pension, on the ground that at the time when the petitioners joined the institutions, the college was yet to get itself admitted to grants at the hands of the state. Therefore, the pension is not granted. In all identical cases.
From the date of appointment.
Correct. From the date of initial pension and matra.
Please.
From the date of initial appointment. This court, the coordinate benches of this court and this court have in umpteen number of cases directed that the period spent by these petitioners during the time in which the aid was not granted to the said institution should be reckoned for the purpose of pension and not any other benefits. The said finding has attained finality by the judgment of the Apex Court, by the Apex Court dismissing the SLP filed by the state, the 26616 of 2004 or 2008, 26616 of 2008 SLP. So in that light, the petition deserves to succeed by a mandamus directing the state to refix the refix the pensionary benefits to the petitioner, taking the service that they have rendered in the institutions during the period in which the institutions were yet to get itself admitted to grant in aid. The action shall be taken within 4 months from the date of receipt of the copy of the order. Any information required from the hands of the petitioners shall be solicited from their hands by the state. Yes. Order according.
Number 3, Prasad Patil, MA Boyar, J. Rachinman.
Appear for respond number 5. After 30 years, land acquisition is challenged. Thus, layout is formed. They have taken the compensation. Son files a suit for partition.
This court, the perusal at the order sheet would indicate it has travelled larger than the main petition, as umpteen adjournments are sought at the hands of the petitioner. This court on 2011-2025.
This case, my lord, may I request, my lord?
Which matter, sir?
This matter, serial number 3.
ಹೇಳಿ sir.
Yes, sir. This matter,
Judgment ಕೊಡಿ Selvan.
my colleague, earlier he was, my colleague he requested me to appear and instructed me, my lord. In fact, after going through the papers, you will ask what is pointed out.
You
in
got
my-
to know there is no case.
That's why to explore the possibility of settlement, you last may kindly accommodate a date. I instructed him to explore
No
the possibility.
exploration of possibility of settlement.
And I do agree.
He saw the objection. No, he saw the objections here, read the objection, and now my lord say.
I do agree.
Nothing remains in the decision.
I do. That's why I instructed. That's why to explore the possibility of settlement in this matter, my lord. That's all I can. My humble submission is accommodate for a date in the next week. I requested my colleague to go for a settlement if at all possible.
Learned Senior Counsel DL Jagadish is candid in making a submission that on going through the papers, what is possible in the case at hand is only exploring possibilities of a settlement. In the event the settlement would not be arrived at, he would leave the decision to the court. List the matter in the light of the said submission and appreciating its fairness. They list the matter on 15th in the fresh matters list.
Obligement.
Yes.
Obligement.
ಆ ತರ DL Jagdish sir will not case ಇದ್ರೆ ಕೇಸ್ ಇಲ್ಲರ ಇಲ್ಲ ಅಂತಾರೆ ಅವರ. Yes.
Please, my lordship. Lordship. Petitioner is cook, my lordship. Regularization of service, my lordship.
ಕೊಡಿ. Yes, madam.
He's a cook, your lordship.
Cook. ಅಡಿಗೆ ಸರಿಯಾಗಿ ಮಾಡ್ಲಿಲ್ವಾ? You're still cooking? You're still cooking?
She has been reinstated, your lordship, subsequently. Earlier, she was terminated on 10/3/97, your lordship. And in 2001, your lordship.
4 ವರ್ಷ outside. Reinstatement with continuity of service?
ಆಗಿದೆ sir. Back wages, 25% back wages.
25%.
ಆಗಿದೆಯಾ? This court has confirmed it? ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
ಇಲ್ಲ sir.
ಹೇಳಿ ಸಾಕು. ಯಾಕೆ? ಹೇಮಂತ್ ಕುಮಾರ್ ಹಿಂಗೆ ಹೇಳ್ದೆ ಹೋದ್ರೆ ಹೆಂಗೆ?
Sorry.
The petitioner is before this court seeking the following prayer. The petitioner is a daily wage
retired. He is retired.
The petitioner, a daily wage employee, now retired on attaining age of superannuation, is at the doors of this court seeking regularization of her services that she has rendered from 1982 till the date of retirement in the year 2017. 2019 in the year 2019 petition ಮುಂಚೆನೇ ಹಾಕಿದ್ರಾ?
ಅಲ್ಲ ಸರ್ 2017 ಗೆ ಹಾಕಿದ್ವಿ ಸರ್.
ರಿಟೈರ್ಮೆಂಟ್ 19 ಆಗಿರೋದ?
ಆಗಿತ್ತು. ಅದು is at the time of filing
in the year 2019. the ಇದ್ಯಾಕೆ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಯಾಕೆ petitioner belongs to so and so?
Sorry.
ಅದೇನು ಇದಾ?
Sorry.
ಅವೆಲ್ಲ ಮಾಡಬಾರದು. The petitioner is appointed as a cook in the backward class hostels at Yelaburga Taluk with effect from 26/6/1982. The petitioner, owing to certain allegations, had been terminated from service in the year 1997. The said termination was called in question before the Labour Court. The Labour Court allowed the reference and set aside the order of termination with the directing reinstatement with 25% back wages. The petitioner was taken back to duties in the year 2001. After taking back to duties, the petitioner then claims, registers her claim for regularization of her services. The same is not considered. Therefore, the petitioner had approached, ಮುಂಚೆ ಹಾಕಿದ್ರ ಒಂದು?
ಇಲ್ಲ sir.
Therefore, the petitioner is before this court seeking a direction to consider her case for regularization owing to the fact that the petitioner has rendered service for over 82 in the 82 and 19 over 36 years with the respondent BCM hostel as a cook and has retired without regularization. The learned counsel Hemant Kumar Havargi, appearing for the petitioner, who take this court through the documents appended to the petition to demonstrate that the petitioner was appointed against a sanctioned post and has continued in the said post for over 36 years. And in the light of the said continuance, the petitioner becomes entitled to be considered for regularization. The non-regularization of the petitioner would be contrary to plethora of judgments rendered by this court, by the apex court from time to time. The learned HCGP, on the other hand, would submit that the petitioner's services stood terminated in the year 1997. Up to 2001, she has not worked, and therefore the said service should not be taken. The service should be taken note of only from 2001. And if it is taken note of from 2001, he had not completed 10 years of service, as on the date of the judgment of the apex court in the case of Uma Devi, which was rendered on 10/4/2006. The learned HCGP would thus seek dismissal of the petition and dismissal of the petition.
One more submission, Your
Indian
Lordship. There were no appointment letter is not there, Your Lordship. Only on oral basis she has been.
The appointment,
joined.
the learned HCGP would further emphasize on the fact that there was no appointment letter issued to the petitioner, but admits that she has continued without an appointment letter for 37 years in service. I have given my anxious consideration, so and so. The aforenarrated facts are not in dispute. Vittal. ನನ್ನ ಕಾಸ್ಟ್ ವೇವ್ ಆಫ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಸುಮ್ಮನೆ ನಿಮ್ಮ ಮೇಲೆ ಯಾಕೆ ಅದನ್ನ ಹೇಳಕ್ಕೆ ಹೇಳಿ ಕಳಿಸ್ತೆ ಅಷ್ಟೇ. ಐ ವಿಲ್ ವೇವ್ ದಿ ಕಾಸ್ಟ್. ಇವ್ರ ಮೇಲೆ ಹಾಕ್ಬೋದು ಕಾಸ್ಟ್, ಗೌರ್ಮೆಂಟ್ ಮೇಲೆ, ಅವ್ರ ಮೇಲೆ.
ಅದಕ್ಕೆ ವಿ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಪೇಡ್ ದ ಸ್ಯಾಲರಿ ಅಂತ, ಅದಕ್ಕೆ ನಾನು ಬೆಳಗ್ಗೆನೆ ಸಬ್ಮಿಷನ್
ಕಾಸ್ಟ್. And give that regularization judgment. Hemant Kumar idea ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ.
ಅದು take that. Yes. The so and so. The learned, I have given my anxious consideration to the submissions made by the respective learned counsel and have perused. So the aforenarrated facts are not in dispute, but the link in the chain of events, the dates, require certain reiteration. The petitioner admittedly is taken into service as a cook in the BCM hostel at Yelaburga Taluk. ಇದಲ್ಲ salary idalla, regularization ಬೇರೆ. Appointed as a cook in the BCM hostel at Yelaburga Taluk, and since then has been serving as a cook, since then served as a cook till the date she was terminated from service in the year 1997. The termination comes to be challenged. Which page?
Annexure, my lordship. J, my lordship, page number 34. Typed copy of the.
Oh, ಇದು ಕೇಸ್ ಹಾಕ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, reference ಆಗಿ ಅಲ್ಲೇ continuation service ಆಗಿ.
The termination was challenged before the appropriate authority, and on conciliation and on the conciliation being on the conciliation between the wings of the state and the petitioner and the labor department, the 96 ಇದು 2001 ಅಲ್ಲಿ ಹೇಮಂತ್ ಕುಮಾರ್ 2001 ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ, ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ. ಅವಾರ್ಡ್ ಆಗಿದೆಯಲ್ಲಪ್ಪ, ಏನಿದು ಕನ್ಸಿಲೇಷನ್ ಬಿಡಿ. The matter was referred by the state government to the industrial tribunal, and the award was passed on in reference number 120 of 1998.
18/3/2000.
1998, directing reinstatement with 25% back wages and continuity of service. The award reads as follows, page 44. After the award, the state state reinstates the petitioner as a cook, and the petitioner then continues as a cook for 17 years thereafter, and retires on attaining the age of superannuation in the year 2019. The submission of the learned HCGP that there was no appointment order, and therefore the petitioner should not be regularized into a direction should not be issued to regularize the service of the petitioner, is noted only to be rejected, as without the appointment order the petitioner continues in service up to the date of termination in the year 1997. The termination is questioned, award is passed, award is accepted, and she is reinstated and continues in service again up to 2019, all without an appointment order. Therefore, the submission that since there is no letter of appointment issued in the year 1982, the petitioner should be left in the lurch is sans countenance. The jurisprudence is replete with the judgments of the apex court on the issue in the aftermath of Uma Devi, all of which bear consideration at the hands of this court in so and so.
Number
Adala Vaibhavi Kotra. Yes, so and so. In the light of the said judgment, judgment which considers the entire spectrum of the law as it has flown from the hands of the apex court, right in the from the apex court till the judgment in the case of Dharam Singh versus so and so 2025 SSC online SC 1725. The petition deserves to succeed. With the direction to the respondent to regularize the service of the petitioner from the date on which she completed 10 years of service from the date of her initial appointment would be in the year 1982.
Excluding the,
1982, but I'll continue to quote we can't do that. Yes, 1982. And it is made clear that the petitioner would not be entitled to arrears of salary on the regular pay scale, but the said period shall be taken note of for the purpose of all terminal benefits, and it said terminal benefits shall be worked out and disbursed to the petitioner all within an outer limit of 4 months from the date of receipt of the copy of the order, ordered accordingly. Yes.
Number 5, Arun and Nilopan, AP Murari.
Regularization.
Partly employees membership.
LIC matter.
LIC matter.
LIC employees membership.
ಏನು ಇಷ್ಟು ದೊಡ್ಡ ಆರ್ಡರ್ ಇದೆ ಪ್ರಭಾಕರ್ ಶಾಸ್ತ್ರಿ ಸಾಹೇಬ್ರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಒಂದ್ಸರಿ.
It was membership DNP
ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ಅದಕ್ಕೆ 5 ಪೇಜ್ ಆರ್ಡರ್ ಇದೆ.
Well, immediately after this particular the judgment of the Honorable Supreme Court, the judge bench in Raghuvir's case, Raghuveer Miller, Ranbir Singh, SK Roy Miller. That particular case, I filed under the additional objections and to dispose of this particular matter. Subsequently, the matter went on, and they did not turn up. Matter came to be dismissed. Amele restore ayadmela. It is covered by this particular judgment between LIC and Ranbir Singh's 3-judge bench, my lord.
So what? Subsequent judgments of the apex court considering this 3-judge bench also.
Subsequent judgment, my lord, that is Justice Vikramnath's judgment.
Adu Sripalu, Jaggo,
yeah,
then Dharam Singh.
Yes, my lord.
Ellide ella.
This is another between LIC and this one.
Maybe
covered judgment.
Maybe inter parties.
Covered.
It is not inter parties. LIC may be an employer there. Ranveer Singh ಯಾವಾಗಿಂದದು?
Ranbir Singh Ballad
2020. ಈ against employees ಇರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಗೊತ್ತಿರಲ್ಲ ನಮಗೆ ಕೊಡಿ.
ಅಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ ಬಲ್ಲ. I will another just
ಎಲ್ಲದಕ್ಕೂ
it is another
pro employer judgment
page 75. Some particular committee is appointed. Page 75 may kindly be seen. Our compensation ಕೊಡಬೇಕು ಎದುರು ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲ ಇದೆ my lord.
That was the law then. No doubt about it. The law was, see, it is Uma Devi is followed and nothing else.
ಅಲ್ಲ Uma Devi ಇದೆ my lord. ಅದನ್ನು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
ಅದನ್ನೇ ಫಾಲೋ ಮಾಡಿರೋದು.
Yes my lord.
Uma Devi ಆದ್ಮೇಲೆ ಏನಾಗಿದೆ ಗೊತ್ತಲ್ಲ?
ಅದಾಯ್ತು.
ಗೊತ್ತಿಲ್ವಾ?
Much water has flown under the bridge.
Water, much streams have flown.
Well, 75 may kindly be seen.
I am there only.
75 ದಲ್ಲಿ fresh verification. May I read, my lord?
The dispute is now of an antiquity.
The dispute
back
is
to
now.
decades. Finally rung down the dispute.
An antiquity tracing back
ಆಯ್ತು
to nearly 4 decades, my lord. ಆಮೇಲೆ ಲಾಸ್ಟ್ ಇಲ್ಲಿ ಹಾಕ್ತಾರೆ.
Yes, madam. When were you appointed?
That, sorry, my lordship.
Sorry.
That date is not mentioned.
Sorry, we'll dismiss it.
No, lordship, that date itself is not mentioned, my lordship. I'll contact the parties. my lordship.
Then it straight away covered by this judgment. ಇದು ನೋಡಿಲ್ವಾ ನೀವು?
In yesterday, the file is handed over to me, my lordship, but in that.
Yesterday.
my lord, objection statement
thing
ನಾವು
is
extract ಮಾಡೇನ ಅದನ್ನ.
In the petition itself, the date is not mentioned, my lordship. If I'll have to inquire with the parties because there are 106 members in this one petition, my lordship.
ಆಮೇಲೆ it has been followed by the coordination bench of this honorable court.
ಎಲ್ಲಿದೆ ಅದು? Which one?
My lord, this one. ಇಲ್ಲಿ ಕೊಡಿ. ಇದನ್ನೇ ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ. In respect of the very same employees of Bangalore division, my lord.
ಆಯ್ತು.
Bangalore division.
ಹೇಮಲತಾ ಮೇಡಮ್ ಹಾಗಾದ್ರೆ ಕಷ್ಟ.
Bangalore division, my lord.
Madam would have written proper.
So we are not denying them.
Hemlaka madam the other will follow it. Should have considered everything. You are to approach the committee for claiming monetary benefits.
Yes, my lord.
Note, madam, note bidi.
Please.
Don't take the risk.
Please.
No, let her go through the.
Yes, sir.
Mangalore hakla? Budwar hakla?
Budwar.
10th.
I take.
10th in the fresh matter.
Please, please.
Grateful manager.
Please.
Dear Lord Khan, then ready go get.
My lord, the petitioner is no more. May I see?
Case is no more?
No. He died.
Close the case agara.
My lord.
The case ಏನು ಉಳಿತು? ಏನಿದು?
ಅಲ್ಲ, the case of the petitioner is that he was not given the regular salary.
Oh, ಇದು
ಪಂಚಾಯತಿ
ಯಾವ
ಗ್ರಾಮ ಪಂಚಾಯತ್.
When did the petitioner die?
2023 ಅಂತ ಏನೋ ಹೇಳಿದ್ದಾರೆ. I am yet to get the details with respect to that.
Regular employee. What?
ಹೌದು, regular appointed.
What is the issue?
The issue is that, my lord, there are certain allegation against the petitioner that he.
Allegation ಆಯ್ತು ಬಿಡಿ, is no more. ಆಮೇಲೆ ಬೇರೆ issue ಏನು?
ಅಲ್ಲ, he was regularly appointed by a resolution and thereafter appointment is confirmed by the Jilla Panchayat.
Minutes here, minutes.
ನೀವು ಯಾರಿಗೆ? ಎಂಪ್ಲಾಯಿಗ?
Please notes, I beg to for response number 3 minutes, the Taluk Panchayat. Notes, what happens is, notes, since 2012, he has not at all, minutes, joined the services. Notes, the petitioner here, in minutes, I have produced notes the entire documents to show that. I did it notes.
Terminate ಆಗಿತ್ತಾ?
ಇಲ್ಲ.
Please notes.
Terminate ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ. Minutes, what has happened?
For a notice ಯಾವಾಗ ಕೊಟ್ರಿ?
Notes, notice is notes, we have produced notes, it starts minutes from annexure minutes R4 at page number 9. Notes, there are two allegations against him. One is notes of, he is a bill collector. The bills notes, the taxes which were collected were not notes repaid back, and to that effect notes, he had notes given an endorsement.
ಯಾವಾಗಾರು ಕೆಲಸ ಬಿಟ್ಟಿದ್ದೀರಾ ಬನ್ನಿ ವಾಪಸ್ ಅಂತ ಎಲ್ಲರೂ ಒಂದು ನೋಟಿಸ್ ಇದೆಯಾ?
Notes, notice is issued notes stating that notes you have to pay the amount to that notes.
Where is, which annexure R?
Notes R4 minutes.
Date ಏನದು?
Notes, that is notes 27/7/2012.
27/7/2012. R4.
R4 at page 9. There are two allegations against him. One is in alcoholic condition notes, he goes notes to the.
ಈಗ ಸದರಿ ನಡತೆ ಸರಿಯಾಗಿಲ್ಲ, ಅನಧಿಕೃತ ಗೈರು ಹಾಜರಿ ಆಗಿರುತ್ತಾರೆ, 8 ದಿನಕ್ಕೊಮ್ಮೆ ಬಂದು ಹಾಜರಿಗೆ ಸಹಿ ಹಾಕಿರುತ್ತಾರೆ, ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಬರದೆ ತಮ್ಮ ವೈಯಕ್ತಿಕ ಕೆಲಸಕ್ಕೆ ಕರ್ತವ್ಯ ಸಮಯವನ್ನು ವ್ಯರ್ಥ ಮಾಡಿಸ ಕರ ವಸೂಲಿಗಾರರ ಮುದಗಲ್ಲ.
And amount to the tune of 1,52,000 minutes was retained by him. The tax amount which he was supposed to minutes give back.
ಆಮೇಲೆ 12 ಇಂದ ಬಂದೇ ಇಲ್ವಾ ಕೆಲಸಕ್ಕೆ?
ಬಂದೇ ಇಲ್ಲ. Minutes, in fact, minutes, may I take minutes for a moment at page 15 minutes.
ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ತಂದು ತಹಸೀಲ್ದಾರ ರಾಷ್ಟ್ರೀಯ ಮಧ್ಯಾಹ್ನ ಸೇವೆ ಮದ್ಯಪಾನ ಸೇವೆಯನ್ನು ಮಾಡಿ ಲಿವರ್ ಪ್ರಾಬ್ಲಮ್
ಇಲ್ಲ our allegations.
R8, for a moment, R8 is a notes bond executed by him stating that yes, I have misappropriated, give me some time, I will pay the entire amount. R8 minutes. This is the bond executed by him minutes in favor of Gram Panchayat.
2017
ಅಲ್ಲಿ.
And so for a salary is concerned notes, I am told that not still 2012 minutes, I have produced notes the entire document. Till he was present, entire salary was paid. I don't if that notes he had even not tampered with the document also. Notes he had produced two documents.
A petitioner is before this court. Seeking, no sir.
I shall file an application for bringing LRs.
No sir. Don't worry about that.
Please.
The petitioner himself has no case. Where is the LRs coming in here? The petitioner.
May I request your lordship?
No sir. Yes. Heard the learned counsel appearing for the petitioner and the respondent. The petitioner today is no more. The learned counsel Lord Khan submits that the right to sue would survive if this court would render the reason that that the petitioner was entitled to some monetary benefit. Therefore, the matter is taken up. So you don't worry. Yes. The petitioner, the husband of the petitioner during his lifetime was appointed as a bill collector in Talugera Panchayat, Kushtagi Taluk, pursuant to a process of recruitment. The petitioner served the Gram Panchayat up to 2012. In 2012, began to remain unauthorizedly absent. Owing to the unauthorized absence of the petitioner, a communication is made on 21/7/2012 to the petitioner. The communication reads as follows. Annexure R4, page 9. The reason for this communication is that the petitioner was alleged misappropriation of funds. Is a notice prakatane ಏನು ಪಂಚಾಯತಿಗೆ ಸಂಬಂಧಿಸಿದ ಡಿಮಾಂಡ್ ರಿಜಿಸ್ಟರ್
Not Sadhu with in intoxicated condition. Not he had visited mini Vidhan Soda to that. Not seen.
He was deputed to work at the mini Vidhan Soda for the public work. It is the case of the respondent that he was intoxicated.
Of course, yes. The be that then better bit. So and so.
Thereafter, notice was issued. The legal notice was issued to the Gram Panchayat.
You don't worry. ಇಂಥವೆಲ್ಲ ಇರಲೇಬಾರದು. Yes. The communication reads as follows. The communication is indicative of the fact that the petitioner had misappropriated certain amounts and was regularly irregular to his work and did not and was attending the office 8 days once at his whim and fancy and marking attendance 8 days once. The petitioner was issued further notice on 29/6/2012. It reads as follows. After issuance of plethora of notices, the petitioner is said to have appeared before the authority and gives an undertaking that he would repay the entire amount. The undertaking is as follows. Neither the amount is paid nor the petitioner returns back to duties. Therefore,
30,000 rupees is recovered.
30,000 kotra. Out of which the amount of misappropriation was at 1,41,617. Out of which, in terms of the agreement, the petitioner is said to have repaid 30,000. After the repayment, the petitioner is said to have remained again absent. And idenidu.
2016 Taluk Panchayati office refers a letter to the Gram Panchayat to take him to services.
It transpires that in the year 2018, the Taluk Panchayat communicates to the Gram Panchayat to take the petitioner back to duties. Then he serkondralva.
There is a letter issued by, now they create
the respondent.
2018 letter, my lord.
The contention of the petitioner is that they never took the petitioner back to duties. The contention of the respondent is the petitioner never appeared before the Gram Panchayat for him to take back to duties. These are all in the realm of seriously disputed questions of fact. To thrash out today, the employee himself is not there. The bringing in the family into these proceedings in the aforesaid facts would be neither here nor there, as the petitioner admittedly is not entitled to any relief for his conduct throughout his service, as it was a case of misappropriation, in misappropriation and always being in the office in an inebriated state and not performing his duties. With all these allegations, though, inquiry ought to have been conducted, but in the case at hand, nothing has been done and nothing has been lost by the petitioners. In that light, petition does not deserve any indulgence. Petition lacking in merit stands rejected. The rejection of the petition would not come in the way of the wife submitting representation to the Gram Panchayat to seek any terminal benefits. Representation, the dismissal of this petition will not come in the way of the wife submitting a representation seeking the terminal benefits accrued to the hands of the husband, who is now no more, to be paid to the wife. The dismissal of this petition will not influence the Gram Panchayat to disburse any terminal benefits that the wife or the legal representatives of the petitioner would be entitled to. The same shall be considered in accordance with law and dispersed to the wife in the event of claim being made.
Please.
ರಿಕ್ವೆಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ರೆ
Time, first kodi.
ಅಲ್ಲ ಇವತ್ತೇ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಇವತ್ತೇ ಕೊಡ್ತಾರೆ.
ಕೊಟ್ಬಿಡ್ತಾರೆ.
In the event such a representation would spring from the hands of the wife of the petitioner, the Gram Panchayat shall consider the same in accordance, is the wife of the petitioner within 4 weeks from today.
In accordance with.
Obviously. The Gram Panchayat shall consider the same within 12 weeks thereafter, strictly in consonance with law.
Please.
Great.
ಅಷ್ಟೇ, ನಿಮ್ಗೇನ್ ತೊಂದರೆ ಆಗಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ,
ಅದು ಇಟ್ಟೇನೋ ಉಪಯೋಗ ಇಲ್ಲ.
ಅಲ್ಲ, ಅದು
ಅಷ್ಟೇ.
only for the technical purpose. Please.
Yes.
Few documents, my lords, are filed along with the memo by the petitioner.
ಏನಿದು?
Some documents are filed, the charge sheet and other things. This is, my lords, regarding the fake certificate submitted to the corporation and obtained a job.
ಯಾವಾಗ ಏನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನು?
Trade certificate. Trade certificate.
ITI. Annexure D, my lord, page number 19 is the show cause notice.
Inquiry?
No inquiry.
No inquiry has been conducted, but since he was appointed on my lord's probation, he was still a probationer. When the certificate was sent for verification, it was found out that it's not genuine. Then my lord's charge sheet was filed, complaint was filed, criminal investigation had taken place, charge sheet was filed, and then in the charge sheet, my lords, the concerned department, my lords, taking it as a special case, because a lot of certificates were, my lords, not genuine. That was the report. It was, my lords, converted. It was regular. The certificate was regularized.
It was
Regularized. Thereafter, my lords, that is in 2024. The charge sheet says that. But we will, my lords, as far as my lords,
reinstate ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
there are another issue, my lords, because there is a report which says that he has never attended the college. There are two things: one, genuinity of that certificate; second, my lords, whether he had attended that college and then obtained the certificate.
Certificate is genuine.
Now, my lords, it has been regularized. Please.
Certificate ಲೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
ಇಲ್ಲ.
ಇವ್ರ ಜಾತಕ
ಅಲ್ಲ, ಇನ್ನೊಂದು ರಿಪೋರ್ಟ್ ಏನಿದೆ ಅಂತಂದ್ರೆ that whether he has.
Why do you want whether he has attended attendance register certificate ಕೊಟ್ಟಾಗಿದೆ ತಾನೆ?
Certificate ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. How you will go behind the employee like this?
My lords, what has happened, my lords, this particular college.
ಎಲ್ಲರಿಗೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈ ತರ?
What has happened, my lords, with this particular college?
Or you don't like his face?
Nothing like that, my lords. This particular college, my lords, for that particular academic year, my lords, they have not sought permission from the concerned department for issuance of, my lords, for admissions, other things. The, my lords, information is this, my lords, that he has given admission to a lot of people. Most of them have not attended the college, and he has issued certificate. But those certificate, because there were ಇದ್ರ ಮೇಲೆ ಅಷ್ಟೇ ಇದೆ. But now, my lords, the certificate is held to be genuine. We'll have to, my lords.
You have to raise. Certificate is held to be genuine.
Yes.
You can't go to that.
No, we'll.
ಇನ್ನ ಬಿಟ್ರೆ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹೋಗ್ತೀರಾ?
No, but now, my lords.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
My lords, I'll get instructions next week. Any date, my lords, I'll get instructions.
On 10th.
Please.
In the fresh matters list, the petitioner is before this court calling in question an order of dismissal on account of alleged fake trade certificate submitted to the petitioner at the time of employment in the corporation. The corporation appears to have verified the said certificate and found verified the certificate and found that the certificate is genuine. In the light of this finding, without much ado, the corporation ought to have reinstated the petitioner, as the termination was only on account of a fake certificate which is now found to be genuine. The learned counsel Prashant Usmani submits that he would seek instructions and make his submissions. Backwages bitpudi.
In fact, lords, in a similar case, the division bench of this honorable court, lords, has said that inquiry has to be conducted because dismissal is without inquiry. So inquiry has to be conducted.
Reinstate ಮಾಡಿ whatever you want to do, you do. But hangare arrears of salary ಎಲ್ಲ dependent on the inquiry.
Inquiry. That is what.
Thursday, Wednesday.
Next week.
Fresh matters.
Please, great.
Next.
Please.
Yes, Pawan.
One Adivappa Lakshmappa Lords Kalloli had expired on Lords 25/11/2018. Thereafter, Lords, the petitioners and petitioners who were the wife and children, they applied for death certificate and survivor certificate.
Puttilva.
They have been issued as per Annexure B and C. Lords, that was disputed by respondent number 5 to 8.
Who is respondent 5 to 8?
They claim that they are the wife and children.
My lord,
Lords, the assistant commissioner, without there being jurisdiction, he hears the appeal and Lords, the set aside the survivorship certificate and the death certificate and order for
How does he get jurisdiction?
Under section 49, he has got the jurisdiction.
What jurisdiction?
my lord,
operative person will be kindly.
Lala, they are relying on only one word, my lords. Actually, they have got the jurisdiction under section 49.
There is a circular issued by the government. It says that Lord, if the survivor certificate is disputed, the parties have to approach the civil court. Please, that is.
Where is the assistant commissioner getting jurisdiction?
My lords, now the-
No.
my lord.
ಬಿಟ್ರೆ ಅಷ್ಟೇ ಎಲ್ಲ ಮಾಡ್ತಾರೆ AC.
May I?
Yes,
how the
sir.
suit is filed.
ನೀವು ಯಾರು second wife?
Allah, we are the first wife.
They claim that they are the first.
You are the first wife.
And now the suit is also pending filed by them, my lord, and there is a
This will
issue.
be set aside subject to the suit.
Please,
Development that has taken place.
Please.
They don't make us as parties and they obtained a partition decree.
I'll-
And we have now filed.
ಅದೆಲ್ಲ ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅದೆಲ್ಲ ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ
Now we
ಏನೇನ್
have
ಮಾಡ್ತಾರೆ
filed a partition decree.
now
Partition suit.
ನೀವು
the
ಇದೇ ತರ ಎಲ್ಲದಕ್ಕೂ ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತಾ ಇದ್ರೆ ಥರ್ಡ್ ವೈಫ್ ವಿಲ್ ಕಮ್.
My lords, now the suit is filed. The
suit
my lords,
is filed
first
by
issue is
the
with respect of
petitioner
that one.
itself, my lord.
Suit ಎಲ್ಲ ಎವ್ರಿಥಿಂಗ್
Please,
We have made a-
ರಿಸಲ್ಟ್ ಆಫ್ ದ ಸೂಟ್ ಸರ್ ಐ ವಿಲ್ ಸೆಟ್ ಇಟ್ ಅಸೈಡ್ ಸ್ಟ್ರೈಟ್.
Please.
ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ಏನು ಸರ್?
My lord, let me, my lord.
ವಾಟ್ ಸರ್?
My lord, we have filed appeal under section 13 and
This is
49.
dangerous even to you. Tomorrow he will tinker with your certificates also.
Please, my lord,
If assistant commissioners are permitted like this,
please. The heirship certificate is issued by Tahsildar, my lord. It is rightly set aside by the AC. The only difficulty is, my lord, without jurisdiction, he has referred.
difficulty ಅಲ್ಲ.
Allah, ಅವರು enquiry ಮಾಡಂದಿದ್ ತಪ್ಪು. He has rightly set aside when there is a dispute that some other are claiming to be legal.
It is all right. If Tahsildar's order was incorrect, he should have directed them to go to the civil court, not himself conducting inquiry.
ಅಲ್ಲ, enquiry ಆಗಿಲ್ಲ. ಆಮೇಲೆ ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ದಾರೆ. He has only set aside the
ಮಾಡಕ್ ಬರಲ್ಲ.
now
May I make one submission? Page number 35, may kindly see. My lords, impugned order. The assistant commissioner has remanded again to the my lords, the
ತಹಸೀಲ್ದಾರ್ಗೆ
Tahsildar for
ಇಷ್ಟೊಂದು ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟು
re-enquiry, only for re-enquiry.
ಎಲ್ಲಿದೆ jurisdiction
ಅಲ್ಲ,
ಇಲ್ಲ ಆದ್ಮೇಲೆ ಹೆಂಗ್
And
ಮುಟ್ಟಕ್ಕಾಗುತ್ತೆ?
now suit is pending. my
What
lords.
is this?
ಅವ್ರದೇ circular ಇದೆ. They don't want to produce that circular before the court.
ಎಲ್ಲಿದೆ?
Please, my lord, I will produce it tomorrow.
ಅಯ್ಯೋ
We have.
I don't want to produce and ನೀವು produce
ಅಲ್ಲ, ಅವ್ರಿಗೆ
ಮಾಡಿದ್ರೆ
ಗೊತ್ತಿದೆ ಅದು. They have the information about it. They don't want to produce
Now
it.
the suit is my lords pending. First issue is my lords with respect of my lords.
legal.
correct, no problem. Why did the assistant commissioner take upon himself?
ಅಲ್ಲ,
ಇಲ್ಲೇ
ನಾವು
ಅದು ಕೊಡಿ.
Please.
ಇನ್ನೊಂದ್ಸರಿ ಮುಟ್ಬಾರ್ದು.
Lord, pass on. Lord.
ಪಾಸ್ ಓವರ್ ಇಲ್ಲ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Please.
please.
ಇಲ್ದರೆ ಬಿಟ್ರೆ ಬರೀದೆ ಹೋದ್ರೆ ಇದೇ ಆಗೋದು. ಎಸ್
Till 9.
The rest list, my lords, it may be listed. It may be listed.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರೆ
Please. It may be listed in fresh matter only.
10:30 ಮುಂಚೆ ಬೇಕಾ? ಇಲ್ಲ ತಾನೆ.
Please.
Fag end of service, my lord, he gets a certificate, birth certificate.
ಇದು ಕವರ್ಡ್ ಸರ್.
I need to produce documents, my lord.
ಹೌದು
But
ಸರ್. ವಾಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
those are in Marathi language, my lord. For
ಮರಾಠಿ
translation copy.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಇಲ್ಲಿ ಯಾರಿಗಾರ ಮರಾಠಿ
My
ಗೊತ್ತಿರುತ್ತಲ್ಲ.
lord, only 2 days accommodation, my lord. Only
yes.
2 days.
Lord, order sheet may kindly be seen, my lord.
ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ನಿಮ್ಮ ಮರಾಠಿ ಬರುತ್ತಾ? ಇಲ್ವಾ?
My lord, only 2 days accommodation, Monday it may.
Order sheet may kindly be seen.
ನೋ ಸರ್, ಮರಾಠಿ ಪರವಾಗಿಲ್ಲ ಹೇಳಿ. ಫ್ಯಾಗ್ ಅಂಡ್ ಹೋಗಿ ಮಾಡೋಂಗೆ ಇಲ್ಲ. ಸರಿ ಸರ್ವಿಸ್ ಸರ್, ನೀವ್ಯಾರ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲ?
Institution, my lord.
ಎಸ್.
1960 he was born.
ಹೌ ಮಚ್ ಯಂಗರ್ he wants to become now?
4 years. No, 6 years. 1966 is the another certificate. He gets a fourth certificate, annexure H1. Page.
ಸಿವಿಲ್ ಸೂಟ್ ಆಗಿಲ್ವಾ? ಸಿವಿಲ್ ಸೂಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ. We have filed this proceedings before education officer are pending. Annexure H1 may kindly be seen.
What is under challenge? What is under challenge? What is under challenge?
Lok Adalat order.
Lok Adalat.
Lok Adalat. He has settled in Lok Adalat without making us the party, and he says it is for passport. In the petition, I have produced the petition also. Page 32, he reasons it as for passport. 32. Lord, the
Oh, it
reason
is
in last two lines.
Before the
For
births
the
and
pa-
deaths, under the births and deaths.
Birth and death.
Ah.
Annexure C may kindly be seen, page 30. There, the birth certificate, there the school certificate, my lord, it's 1/6/1960.
Yes.
Thereafter, my lord, annexure H may kindly be seen. Bona fide certificate issued by the school. The school is also party to the writ proceedings now.
ಆಯ್ತು ಇದು annexure H ಯಾವ್ದು ಹೇಳಿ.
Page 41.
1960.
1960. This is issued by the school.
ಯಾವ ಸ್ಕೂಲ್ ಇದು?
Respond number
Jawahar
5.
Vidyalaya.
Page 42 is the
Kolhapura.
Gorambe.
Translated copy is page 42. Then he produces annexure H1. 1964 is the.
My lord, H1 is not belonging to the respond number 6, my lord.
That's what, my lord. He has produced the 4
My
certificate.
lord, I have not produced this.
Kamble Sitaram. Bona fide certificate ಇದು.
Bona fide certificate. He has produced this certificate. Obtained.
ಇದು 1964 ಆಗ್ಬಿಟ್ಟಿದೆ.
1964 they have put. And this is not issued by the school.
My lord, I have not produced this document, my lord.
Forget it, sir.
Yes.
ಈಗ issue ಏನ್ ಹೇಳಿ.
Issue, my lord, at the fag end of service, he gets it, says it is for passport, gets the birth certificate. His wife is the principal, gets it corrected in the service records, and he extends his service, and thereafter retires.
Service also.
Completed service. Now he is taking pension.
My lord, he has taken
And
VRS, my lord.
proceedings
Service
are,
ಮುಗಿಸಿದಾರ?
service
Oh,
is
my lord, he has
over.
taken VRS, my lord, on 31/5/2023, my lord.
2023,
my lord.
VRS.
Yes, my lord.
23 is the.
one ನಿಮಿಷ. 31/3.
31/5, my lord.
31/5/2023 VRS.
Yes, my lord.
1960 date of birth.
1968.
one ನಿಮಿಷ. ನಿಮ್ ಪ್ರಕಾರ 1960?
66, my lord.
1966.
Yes, my lord.
ಸೊ ನಾವು ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿದ್ರಿ? 34 + 23. 1966 ಆದ್ರೆ
Yes, my lord.
ಎಷ್ಟಾಗುತ್ತೆ? 34 years.
Yes, my lord.
Plus 23 years.
61.
34, 23 ಎಷ್ಟಾಯ್ತು?
57, my lord.
50 ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿದ್ರಾ?
No.
ಅಲ್ಲ, ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಸರ್. ಸರ್ವಿಸ್ ಸೇರಿದ್ ಯಾವತ್ತು ಸರ್?
One date of joining, my lord.
13/6/1994. He joined this service.
My lord.
57 years you have taken voluntary retirement.
Yes.
According to you.
Yes.
All right. But if it is 1960 andre, you had to retire when?
2017.
6 years, correct, 6 years ಮುಂಚೆ. ಎಷ್ಟು ಏಜ್ ಆಫ್ ರಿಟೈರ್? 58 ಇಲ್ವಲ್ಲ? 58, 60 years ಅಲ್ವಾ?
60.
ಮತ್ತೆ 2017 ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ, 2017 is what my instructions.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಬರಲ್ವಾ?
ಇಲ್ಲ,
ಅದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಡ್ಬೇಕಾ?
ಇಲ್ಲ ಇಲ್ಲ.
1960 ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಆದ್ರೆ 60 ವರ್ಷ ಎಷ್ಟು ಸರ್? 2020. ಅದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬೇಕಾ? 2020. ಸೊ 2020 ಆದ್ಮೇಲೆ ಏನಿಲ್ಲ, ಪೆನ್ಷನ್ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ವಾಟ್ ಎವರ್ ಅಮೌಂಟ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ಫ್ರಮ್ 2023, give it back. Your wife is principal?
Was.
ಅವ್ರು ಯಾವಾಗ VRS ತಗೊಂಡ್ರು?
I don't know that.
ಆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಎಲ್ಲ ತಗೋಬೇಕು ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
My lord, only 2 days accommodation, my lord.
ಆಯ್ತು, will
I
give
will
you.
produce documents, my lord. On Monday.
ಮರಾಠ ಮಂದಿರ, ಸಾರಿ, ಮರಾಠ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಇದೆಯಾ?
Only to delay, my lord.
No, my lord, only 2 days. Monday it may be.
ಬಿಡಿ. Only to delay what?
ಅಲ್ಲ, proceedings are stalled because the order is
ಜನವರಿಗೆ ಆಗ್ತಾ ಇದೀನಾ? ಎಸ್. ಫಸ್ಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಪೂರ್ತಿ ತಗೊಂಡ್ಬಿಡಿ ಏನೇನು. ಲಿಸ್ಟ್ ಆನ್ 9th. Please, fresh matters list.
Please, please.
It is made clear, no further adjournment would be granted to the respondent on any ground whatsoever.
Yes.
ಅಂದ್ರೆ ನಿಮಗೂ ಕೊಡಲ್ಲ ಅಂತ ಅರ್ಥ.
ಆಯ್ತು.
10, Rajendra R. Patil.
Seeking compassionate appointment not in the Gram Panchayat.
On behalf of Bhushan Kulkarni, not yesterday he had called, he is suffering from typhoid. Not next
2 weeks biಟ್ಟು
two.
No, no, it's compassionate appointment is there. Next week, no, sir.
ಎಷ್ಟು ಡೇಟ್ ಆಫ್ ಡೆತ್?
It is the grandfather of the Lord, the petitioner. He initially working as a Lord, the peon in the Gram Panchayat, Lord. After his death, his elder uncle was working. Thereafter, Lord, he has no issues. And he petitioner has been taken into Lord, said
Adoption.
adoption ಅಲ್ಲ ಪಂಚಾಯತ್ ಕೆಲಸಕ್ಕೆ.
ಸರಿ.
Thereafter, Lord, he was removed, Lord. The resolution also passed.
Compassionate appointment ಎಲ್ಲಿಂದ ಬಂತು?
In the village office, Lord, the
ಮುಂಚೆನೆ ಆಗಿತ್ತಾ?
please, Lord. Next week.
The council for the respondent submits that Council Bhushan Kulkarni is unwell. Therefore, list this matter on 18th in the fresh matters list.
Please.
Film 11, Vidyavati.
I appear for petitioner.
Land acquisition,
Please, my lord.
ಏನ್ ಮೇಡಮ್ ಇದು?
Earlier, my lord, I have challenged the consent
Indoor
award.
development ಏನೋ ಅವ್ರ covered ಅಂದ್ರಲ್ಲ
No,
ಅದೇನಾಯ್ತು?
no, it's not the case, my lord. This is the consent award, my lord. They have passed an consent award. That is questioned in the petition. Now, subsequent development, my lord, last occasion I filed a memo. The government issued an order fixing the 40 lakhs per acre, my lord. For that, our parties are ready to accept the consent award. I
The
filed a memo also, my
Petitioner
lord.
is before this court seeking the. ಅದೇನು? Withdrawal.
Similar set of circumstances. But insofar as my petition is concerned, petitioner number 4 is concerned, plus he is agreeable for consent award. Others I have to secure instructions.
ಅವ್ರದ್ದು ಮುಗಿಸ್ತೇನೆ ಬಿಡಿ, ನಿಮ್ಗೆ ಯಾಕೆ? Yes. The
In
petitioner
the
is
present
dealing
petition also, your
11.1.
lordship, in present petition, your lordship, serial number 11 ಅಲ್ಲಿ, as per my instructions, your lordship, he has received the consent award amount ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ನಾನು ವಿಡ್ರಾ
If not-
ಮಾಡಿದ್ದೀನಿ, ಇಬ್ಬರಿಗೆ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀನಿ.
If
It is
not
an
already.
order.
Please, your lordship.
If not already.
Please, your lordship.
The petitioner is before this court seeking the following prayer. Learned counsel, Srimati Vidyavati.
Filed an amendment application also.
Vidyavati Kotur Shettar would submit that during the subsistence of the subject petition, the state has issued a circular.
Government order, my lord.
State has issued, a government order is notified by the state on
9/10/2025.
on 9/10/2025. The order reads as follows. ಬರೀ ಇಷ್ಟು ಮಾತ್ರ ಮೇಡಮ್, ಫುಲ್ ಅಲ್ಲ. The order reads as follows. In the light of, the learned counsel would now submit that the petitioners are agreeable for what is depicted in the government order, and therefore would seek a direction for payment of compensation and a consent award in terms of the government order dated 9/10/2025.
Rupees 40 lakhs, my lord. in
ಅಲ್ಲಿ
respect.
ಏನಿದೆ ಅದು?
Please.
In terms of the government order 9/10/2025. The learned HCGP submits that she has instructions that the petitioners have already received the amount in terms of the government order dated 9/10/2025.
The consent award.
Amount
Earlier
in
consent.
already received the amount, que the consent
There
award.
is a stay. Please.
Que the consent award, be that as it may, the benefit of the government order dated 9/10/2025 shall be afforded to the petitioners in accordance with law. If not already paid. ಈಗೇನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ?
No, my lord. They have not paid them.
9/10/20, in terms of 9/10/2025 with an outer limit of 8 weeks from the date of receipt of the copy of the order.
Pay the amount also because it's a consent award, my lord.
Amount ಏನು?
Amount ಕೊಡಲ್ಲ ಅವರು. Award pass ಮಾಡ್ಬಿಡ್ತಾರೆ, amount ಕೊಡಲ್ಲ.
Pay the amount in terms of the government order dated 9/10/2025 by drawing a consent award.
Please.
Que the petitioner.
Please.
Within an outer limit of 8 weeks.
4 weeks. Everything is ready. Draft award ready ಮಾಡಿಟ್ಟಿದ್ದಾರೆ.
Award will
ಎಲ್ಲ
be ready, your
ಗೊತ್ತಾಗಿದೆ.
lordship, but amount will be not there. ಅದಕ್ಕೆ
ಆಯ್ತು, 8 weeks ಇರ್ಲಿ ಬಿಡಿ, ಕಂಟೆಂಪ್ಟ್ ಆಗ್ತೀರಾ ಇಲ್ದೇ ಸುಮ್ಮನೆ.
Please.
8 weeks, if not earlier. Yes.
So far as WP 102960.
Dealing. Yes.
Please.
Dealing and Tuesday. Yes.
Actually, ಅದು memo for withdrawal of the petition ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ.
Was agreeable for the consent award.
ಅವ್ರದ್ದು ವಿಡ್ರಾ ಆಗಿದೆಯಾ?
ಅದರಲ್ಲಿ
Petitioner
number 4 millions.
Petition number 4. Withdrawal of petition ಅಂತ ಇದೆ?
He is agreeable for the consent award as per the
Government order.
ಮತ್ತೇನು?
Insofar as petitioner number 4, others I have no instructions.
Petitioner, ಅದು withdrawal of petition ಇದೆಯಲ್ಲ, the counsel for the petitioner submits that the petitioner is agreeable. Petition number 4 is agreeable for the consent award, consent award in terms of the government order dated 9/10/2025. In that light, the same reasons rendered in the companion petition would become applicable to petition number 4 in the subject petition. Ordered accordingly. Yes.
15 also same.
ಯಾವುದು?
15 also
Same.
15.
Same government order.
Same close ಮಾಡೋಣ on same grounds, Chetan?
Please, Your Lordship, Sanal village.
15 ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ. ಯಾವುದು ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ಮಾಡಿದ್ವಲ್ಲ 15 ಸೇಮ್. ಇನ್ಯಾವ್ದಾರು ಇದೆಯಾ ಆ ಥರ?
Your Lordship, kindly pass or Your Lordship, ಅದು Sanal village ಇದ್ದು. ಅಲ್ಲ,
ಯಾರು? ಅನಿಲ್ ಕಾಳೆ ಅವ್ರದ್ದು?
ಏಜ್ ಅವ್ರು ಹೇಳಿದ್ರಂತೆ ಸರ್.
Similar order to be passed.
ಹೌದು, same.
ನೀವೇ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಾ, ಅವ್ರು ಕೊಡ್ತಕ್ಕಂಥ ಅದಕ್ಕೆ ಏಜ್ ಬಂದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ಕೇಳ್ತಿರೋದು ಅವರು. ಅದು ಎಂಟೈಟಲ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ, ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ತಾನು ಹೇಳಿರೋದು. ಎಸ್
Please.
ಎಸ್ ಮೇಡಮ್.
And landowners may not be permitted to appear because in a division bench, the honorable my lord division bench has ordered the owners to appear and fixed a specific date for appearance. And SLO is directed to receive the.
ಅದು ಹಾಗೆ ಮಾಡುವ.
Yes, my lord.
ಅಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಕವಿತಾ ಮೇಡಮ್ ಒಂದು ಬರ್ಕೊಳ್ಳಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ಅದರಲ್ಲಿ. Therefore, the petitioner shall now appear before the SLAO.
Please.
Concerned SLA.
Concerned SLAO, and on the appearance of the petitioner, the concerned SLAO shall act in accordance with the government order dated 9/10/2025 and disburse the award amount hyphen the consent award amount. Please. Petition number 4 ಮಾತ್ರ ಅದು. ಈಗ ಏನು ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ಅಲ್ಲಿ ಇದೊಂದು ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಹಾಕಿ, ಅನಿಲ್ ಕಾಳೆ ಸರ್ದು ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ, ಆಮೇಲೆ ಅರವಿಂದ್ ಕುಲಕರ್ಣಿದು ಪೆಟಿಷನ್ ನಂಬರ್ 4 ಮಾತ್ರ ಈ ಆರ್ಡರ್ ಮಾಡಿ.
ನಂದು 2 petitions.
ನಿಮ್ದು 2.
Let's say in serial number 15 is concerned, let the direction be to concerned SLAO, because ಯಾಕಂದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ಮೇಲೆ tomorrow
ಕನ್ಸರ್ನ್ಡ್ SLAO ನೇ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀಗ ನಾನು.
ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಆಗಿದೆ.
ಇಲ್ಲ ಕನ್ಸರ್ನ್ಡ್ SLAO appear before the respondents ಅಲ್ಲ, appear before the concerned SLAO
and he may be directed notes.
ಓನಸ್ ಅವ್ರದೇ.
I am beneficiary tomorrow. Let's
ನಿಮ್ಮನ್ನ
contempt ಅಲ್ಲಿ already I am driven into contempt.
I don't think contempt ಪ್ರಮೇಯ ಬರುತ್ತೆ ಅಂತ.
Contempt is pending. ಇವತ್ತೇನೋ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಅದಕ್ಕೆ.
Yesterday they were listed.
It is tomorrow, my lord. Affidavit.
ಆಯ್ತಲ್ಲ ಇವತ್ತು.
Please.
Number 12, Nagaraj Estimate.
Applying for petitioner, my lord.
I am for the respond number 2 and 3, my lord.
In this matter, my lord, the order passed by the appellate tribunal in my favor, my lord. However, the liberty given by the appellate tribunal to hold de novo inquiry is being challenged in this petition, my lord, on the
in
ground
your
that,
favor.
my lord,
Which appellate, educational appellate tribunal?
appellate tribunal, my lord.
Karnataka appellate tribunal.
Karnataka appellate tribunal. It's relating to
Cooperative
Karnataka
society,
Cooperative Societies Act. Petitioner was working as a manager cum CEO in a respondent bank, my lord. On a peculiar allegation,
Pecuniary allegation.
Yes, very, my lord.
Pecuniary allegation.
Yes.
Ah.
Peculiar allegation. In the sense, my lord, he had allowed one of the directors to look into the loan records. Allegation that apart from that, taking letters for identical letters from customers, various customers, the inquiry was set up, my lord. So far as the director, even he approached when qualification issue came. The register of cooperative societies held that the directors was also member of the loan committee. There is no wrong in perusing the loan records. There is clear finding by the registrar. Then based on this, my lord, inquiry was set up. And totally there is even charge also very vague. And no charge at all, my lord, even particulars, and it is not distinct and determined charges.
ಇದೇನು 3 ನಾ?
My lord.
3 ನಾ ಇದು?
ಹೌದು.
3.
ಚಾರ್ಜ್ ಅಲ್ಲಿ ಏನ್
ಇಲ್ಲ
ಹೇಳ್ತಾರೆ?
3 ನಾ ಅಂದೆ.
ಅರ್ಥ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
The petitioner name.
ಪೆಟಿಷನ್ ಬರೋ.
ಅಲ್ಲ petitioner name.
Yes, my lord. He is Bahubali.
ಅದಕ್ಕೆ 3 ನಾ ಅಂತ ಕೇಳಿ. Yes.
Yes, my lord. Here, my lord, in that, my lord, the charge was even inquiry officer appointed. And he was not allowed to provide despite request documents.
ಟ್ರೈಬಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರಾ?
It is allowed, my lord. It is
But what
allowed
is your problem?
on the finding that there is a gross violation of natural justice, my lord.
ಮತ್ತೆ what is the problem?
Problem is that, my lord, liberty is given. My ground is that, my lord, that service law doesn't provide to hold inquiry after retirement, my lord.
ಈಗ ರಿಟೈರ್ ಆಗಿದ್ದು ಯಾವಾಗ ಸರ್?
All retirement, my lord. In fact, he was dismissed during 2016, 18, my lord.
Give me dates.
And the date, my
ನಾಲ್ಕು
lord.
ಡೇಟ್ ಕೊಡಿ ಸಾಕು. Yes.
My lord.
Date of joining.
Date of joining on 1/5/1997.
As what?
As a CEO.
As CEO, my lord.
CEO.
CEO.
Of what?
Bank.
That respondent bank, my lord. Yellapura Cooperative Bank.
ಆಯ್ತು, ಆಮೇಲೆ?
Then he was dismissed on 30th June 2018, my lord. Then he attains 60 years, my lord, on 31/5/2020. At the time of filing appeal before the learned tribunal, he was retired, my lord. Then the liberty is given, my lord, despite noticing that the inquiry was not properly conducted. Even charge was also not there regarding misappropriation and unauthorized absence. ಈಗ charge ಒಂದು ಹೇಳ್ತಾರೆ, even finding totally different, my lord. There was no charge of misappropriation and other aspects, my lord. ನಾನು lordship kindly see page number 50, my lord. So far as charge is concerned, my lord, may I read, my lord? Page number 50. Last line ಅಲ್ಲಿ
ಫೈಂಡಿಂಗ್ ಹೋಗಿ ಈಗ ಸೀದಾ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
They have not challenged, my lord.
All right.
Not
They have
challenged.
not challenged.
Tribunal order is page number 208, my lord.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ sir.
The petitioner is before this court calling in question an order passed by the Karnataka Appellate Tribunal.
One submission, my lord.
Yes, sir.
My lord, the petitioner has given a representation for settling the matter in 2021. My lord, the respondent was kind enough not to consider that and pass resolution. In spite of that, my lord, he did not come forward to receive the amount.
No, my lord.
You lordship kindly see, my lord, this is the letter submitted by these two letters which was submitted in 2021.
बैठिए sir.
In first letter, my lord, he claims
28 ಲಕ್ಷ ಹಣವನ್ನು ಬ್ಯಾಂಕಿನಿಂದ ನೀಡಿದರೆ ನಾನು ರಾಜಿ ಮಾಡಿಕೊಳ್ಳಲು
subsequently, my lord,
ಒಪ್ಪುತ್ತೇನೆ.
next letter, my lord, after considering, my lord, he agreed 22,99,900.
ನಾವು ಸದರಿ ಹಣವನ್ನು ನನಗೆ ಚೆಕ್ ಮೂಲಕ ನೀಡಬೇಕಾಗಿ
22,99,000.
28 lakhs.
Next, my lord, second.
ಅದೇ 22 ಲಕ್ಷದ
999.
999.
They were ready, my lord, they passed resolution. They requested no year to come and take the amount which he was agreed. And he did not come forward and prosecuted the appeal, and in appeal came to be allowed in his favor. And my lord,
but liberty ಕೊಟ್ಟರೆ ತಪ್ಪು. Runs contrary to law. I will.
If he is agreeable, my lord, I am.
My submission, my lord.
ಇದು agreeable ಇಲ್ವಾ ಅಷ್ಟೇ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ
ನೀವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನನಗೆ ಬಿಡಿ, ನಾ ಬರಿತೀನಿ. ಇದು agreeable ಅಲ್ವಾ ಅಂತ ಕೇಳಿ.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, even he is agree for 34, bank also had agreed. Later they have changed their version. Now ಈಗ 24, 25 ಅಂತ ಇದ್ದಾರೆ. The actually it comes
ಇಲ್ಲ,
around
2026 ಬರ್ತಾ ಇದೆ. 24, 25 ಆಗೋಯ್ತು.
ಈಗ 35 like that other, he can otherwise will proceed on.
Yes, sir. Ask him whether he is ready to settle it. Legally.
ಅದು agree ಆಗಿಲ್ಲ ಅವರು.
On 28th, my lord,
present in
the petitioner, he was present before along with this.
ಇಲ್ಲ, board ಅಲ್ಲಿ present ಇದ್ದು, they did not agree for that, my lord. He is also present, my lord.
ಬೋರ್ಡ್ ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ಅಂತ ಇಲ್ಲೂ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರೆ
ಅಲ್ಲಲ್ಲ, ಬಂದಿದ್ದಾರೆ. That's why.
The petitioner is before this court calling in question an order of the Karnataka Appellate Tribunal which sets aside the order of penalty imposed by the respondent. By the respondent, ಯಾವ ಬ್ಯಾಂಕ್ ಇದು?
ಯಲ್ಲಾಪುರ
ವಿಕಾಸ್
ಅರ್ಬನ್ ಕೋಆಪರೇಟಿವ್.
By the ಇಬ್ರು ಮಾಡಿದ್ದೀರಾ, ಯಾಕೆ? By the respondents 2 and 3.
President and general
imposing penalty of dismissal from service. Heard so and so, the facts in brief germane are as follows. The petitioner is said to have been appointed as a chief executive officer of the second respondent cooperative bank, hereinafter referred to as the bank for short. After rendering about 18 plus 3, 21 years of service, it transpires that the petitioner services comes to be terminated by the board of the respondent bank owing to certain omissions and commissions. The petitioner challenged the said order of termination before the, see the appellate tribunal ge hakodru munche?
No, joint registrar, my lord.
For the first
Arbitrator and
respondent, the
70.
joint registrar of cooperative societies. The joint registrar of cooperative societies negatived the challenge of the petitioner and rejected the claim. This was challenged by the petitioner before the Karnataka appellate tribunal. The Karnataka appellate tribunal by the order, ಯಾವ date ಅದು?
24th August 2023.
By the order dated 24th August 2020, Augusta.
Please.
By the order dated 24/8/2023 sets aside the order of dismissal from service on the score that there has been gross violation of principles of natural justice and directs reinstatement ilwala.
No.
But reserves liberty to the respondent to hold a de novo inquiry to be in consonance with law. The petitioner, the employee, is before this court on the score that on that being aggrieved by on that portion of the order that permits a de novo inquiry to be conducted against the petitioner. The learned counsel Nagaraj Jain, appearing for the petitioner, submits that the petitioner has retired on attaining the age of superannuation on 31/5/2020, and there cannot, and the regulations or even law does not permit holding of a de novo inquiry against an employee after his retirement. He would therefore seek quashment of that portion of the order which permits holding of a de novo inquiry against the petitioner. The learned counsel, appearing for the respondent, submits that they have not challenged the said order, but the board was willing to settle the dispute between the parties, and a settlement proposal was also submitted to the petitioner. The petitioner had in fact agreed for a settlement of a particular amount by his communication, but then chose to prosecute the appeal. Therefore, the learned counsel submits that if he is ready and willing, the bank is also willing to settle the dispute by on the aforesaid amount that was agreed to initially by the petitioner. I have given my sounds. Therefore, narrated facts are not in dispute. The petitioner's entry into the second respondent as the chief executive officer is on 1/5/1997. Owing to certain omissions and commissions, the petitioner was removed from service on 30/6/2018. The issue in the list does not pertain to the veracity of the removal from service. The petitioner challenges the said removal before the joint registrar of cooperative societies. The joint registrar of cooperative societies rejects the petition before him, holding the removal to be valid in the eye of law. This is called in question by the petitioner before the Karnataka appellate tribunal. The appellate tribunal, after a detailed order, allows the petition, sets aside the order of dismissal on the ground that it was in gross violation of principles of natural justice. The order of the appellate tribunal is as follows.
227, man.
The reasons rendered by the tribunal is as follows. Page 221 to 227. The tribunal, while doing so, while setting aside the order, directs that the third respondent bank is at liberty to conduct inquiry in accordance with law and the service rules. The service rules of service rules yavadu?
Yes, my lord. Bank service rules, right? Vikas Urban Cooperative Bank. Staff.
The bank,
rules.
the third respondent bank, the service rules which the tribunal refers to is the Vikas Cooperative Bank, Sibbandi Seva Niyama, idilva? ಆಂಗ್ಲ ಭಾಷೆಯಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
Yes. ಸಿಬ್ಬಂದಿ ಸೇವಾ ನಿಯಮಗಳು ಕನ್ನಡದಲ್ಲಿ ಹಾಕಿ ಮೇಡಮ್. The service rules, a perusal at the service rules would indicate nowhere the right of the employer to continue the inquiry or hold a de novo inquiry against an employee who has retired on attaining the age of super. Petition dismissed.
Sorry. Very sorry, my lord.
Yes. Finding no ground in the petition stands rejected.
Sorry, my lord.
Yes, next.
Apologize.
Who's attained the age of superannuation. Who's attained the age of superannuation. Admittedly, the petitioner has attained the age of superannuation on 31/5/2020, and the order of the tribunal is on 24th August 2023. The 2023, which sets aside the order of penalty but permits a de novo inquiry to be conducted. Whether a retired employee can be proceeded against by a court of law for conduct of a de novo inquiry is no longer res integra, as the apex court in the case of Anant R. Kulkarni versus so and so, 2013 6 SCC page 153, page 515, has held as follows. The last para 18 to 24. The apex court holds de novo inquiry against a retired employee is impermissible in law unless the service rules so permit. The service rules, as quoted herein above, on its perusal does not indicate any permission, does not indicate any liberty reserved to the employer to hold an inquiry, de novo inquiry, or any kind of inquiry against a retired employee. If no inquiry can be held against a retired employee, the tribunal ought not to have remitted the matter, ought not to have reserved liberty to the third respondent to hold a de novo inquiry. That portion of the order admittedly is contrary to law. Therefore, the petition deserves to succeed. For the aforesaid reasons, the following order. The petition is allowed that the clause 3 along the mark point, so and so of the order of the tribunal is set aside. The petitioner shall be entitled to all consequential benefits that would flow from the quashment of the order, ordered accordingly.
Including that.
ಅಲ್ಲಿ ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಅದನ್ನ? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ನೀವು?
ಅಪೀಲ್ ಅಲ್ಲಿ
ತಾನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು, ಅಷ್ಟು ಮಾತ್ರ ಸೆಟ್ ಅಸೈಡ್. Don't expand your brief. Petition is allowed for a change with exemplary costs of 25,000 for the mobile phone ringing in the court. Yes, please. ಫೋನ್ ಯಾವ್ದದು? ಐಫೋನ್?
ಅಲ್ಲ ಸ್ವಾಮಿ,
ಐಫೋನ್ ಆದ್ರೆ 1 ಲಕ್ಷ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ ಅಂತ.
ಏನಾಗಿದೆ, ಬೆಂಗಳೂರು ಬಿಟ್ಟು ಬಂದಿದ್ದೀನಿ, ಜೂನಿಯರ್ಸ್ ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಬೆಂಗಳೂರು ಬಿಟ್ಟು ಬಂದಿದ್ದೀರಾ?
ಇಲ್ಲಿ ಬಂದಿರೋದು.
ಫೋನ್ ಬಿಟ್ಟು ಬರ್ಬೇಕಾಗಿತ್ತು. ಎಸ್, ಬೆಂಗಳೂರು ವಾಪಸ್ ಹೋಗಿ. ಪ್ಲೀಸ್.
I'm sorry, my lord, in earlier serial number 11, my lord, the consent award, my lord, we have questioned, ಅದನ್ನ ಕ್ವಾಶ್ ಹಾಕ್ಬೇಕು.
Correct. ಅದರಲ್ಲಿ ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ರಲ್ಲಿ in the light of the government order dated 9/10/2025 and its acceptance as a matter of form FORM, the impugned orders stand quashed. ಅದರಲ್ಲೂ ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ ಇದರಲ್ಲಿ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಕ್ವಾಸ್ಟ್ ಕ್ವೇ ಫೋರ್ತ್ ಪೆಟಿಷನರ್ ಅನಿಲ್ ಕಾಳೆ ಅವರದನ್ನು ಕ್ವಾಸ್ಟ್.
ಅವ್ರದರಲ್ಲಿ
one submission. Already consent out earlier government order ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ದುಡ್ಡು. Now they don't have it to.
ಅದನ್ನೇ ಇವರೇನು ಹೇಳಕ್ಕೆ
They don't have right, my lord. It is revision, my lord. They have accepted the consent award 2 years before. Now it is revised. That will not confirm any right on them, my lord. Otherwise everybody.
That's what madam tried to tell.
Otherwise, my lord, if it is a larger implication.
If not already.
Please. If
not ಅಂತ ಮಾಡಿದ್ದೀನಿ ನಾನು.
Please.
See, if they have taken consent award earlier, this would not be.
ಅಲ್ಲ ಅವ್ರಿಗೆ consent award quashed ಆಗೋದು ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ. That should not be done. Consent, earlier consent award, my lord, this is a.
No, ಆಮೇಲೆ ತೊಂದರೆ ಆಗುತ್ತೆ. Correct, you are right.
1 ಲಕ್ಷ ಎಕರೆ ಸ್ವಾಮಿ ಅದು ಇರೋ ಟೋಟಲ್ ಪ್ರಾಜೆಕ್ಟ್ 1,20,000 ಎಕರೆ, ಕನಿಷ್ಠ ಒಂದು 3 ಲಕ್ಷ
74,000 ಎಕರೆ.
ಏನೋ ಒಂದು ಎಕರೆ.
The thing is, my lord, the
ಎಕರೆ is not the problem. ನೀವು ಮುಂಚೆ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ತಗೊಂಡಿದ್ರೆ I will observe, ಕ್ವಾಶ್ ಮಾಡೋದು ಬೇಡ. ಒಂದು ನಿಮಿಷ. The benefit of the government order shall be rendered to these petitioners in terms of the government order dated 9/10/2025, if not already granted.
Please.
If not already granted, for which purpose the impugned orders will not come in the way.
Please, grateful.
My humble submission. The question, the writ petition, filing of a writ petition itself is, my lord, challenging the consent award.
Minutes ಮೇಲೆ ಬೇಕಾದ್ರೆ ಬನ್ನಿ, I will answer. ನೀವೇ ಹೇಳಿದ್ರೆ government order 9/10/2025 government order ಪ್ರಕಾರ ಕ್ಲೋಸ್ ಮಾಡಿ ಅಂದ್ರೆ ಮಾಡಿದೆ ನಾನು.
Please, my lord, merits melene, there is a stay order from this honorable court for consent award, and their prayer is to pass an general award because the consent is
ಅದ್ರಲ್ಲಿ
taken.
award ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ
Yes, yes,
Madam,
sir. We have not.
it is clear. See, if you have taken the benefit of earlier consent award, if they have
Yeah,
paid
yes,
all the
that
amount.
observation. Yes, yes,
clarify
ma'am. That
ಮಾಡಿದಿನಲ್ಲ.
observation. If paid already, my lord, we are.
ಅದನ್ನೇ ಹೇಳಿದ್ದು ಮೇಡಮ್.
ತಗೊಂಡಿದ್ದಾರೆ.
ಅದನ್ನ
I
ನೋಡಿ.
have a documents ಎಲ್ಲ.
You look into the order.
And
If
that
there
is
is any
observed
problem, you
also.
tell me, I will correct it.
Please,
State
It
should
is
not be ending up paying double or triple ಎಲ್ಲ ಆಗ್ಬಾರ್ದು.
please.
We have not, they have not paid.
So ಅವ್ರದ್ದೇಂತು ಅನಿಲ್ ಕಾಳೆದೇಂತು ಅಂದಿಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಸ್ಟ್ರೈಟ್ ಅವೇ
Yes, ma'am.
ಇವ್ರದೇ.
Now we have, they have not paid a single pay,
ಕನೆಕ್ಟ್
my lord.
ಮಾಡಬೇಡಿ, ಅನಿಲ್ ಕಾಳೆ ಅವ್ರು ಸೆಪರೇಟ್ ಮಾಡಿ.
They have,
ಈಗ ಪಾಸ್ ಮಾಡಿದ ಆರ್ಡರ್ ಓನ್ಲಿ ಇನ್ ದಿ ಕೇಸ್ ಆಫ್ ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ಅಂಡ್ ಅರವಿಂದ್ ಕುಲಕರ್ಣಿ.
they have not paid a single pay to us, ma'am.
ನೋ ಪ್ರಾಬ್ಲಮ್.
Please, ma'am. Benefits we have not taken.
ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡ್ತಾರೆ,
Yes.
ಕೊಟ್ಟಿದ್ರೆ ಸಿಗಲ್ಲ.
ತಗೊಂಡಿದ್ದಾರೆ.
Yes.
Whatever, if not already paid ಒಂದು,
Please, your lordship.
ಆಮೇಲೆ for the impugned order will not come in the way to consider government order
Please.
if they have not taken.
If you're not.
ಅದು ಬರ್ದಿದೆ.
Please.
Yes.
Will it appear? This is a day before yesterday matter. The order under section
Will we take it
12(5).
Shall we take it day after tomorrow?
Section 12(5), my lord, I said, my lord, is covered by judgment of Justice Suraj Govindraj. He says 12(5), my lord, last date I have given, your lordship has also
Close Mana.
noticed.
That I have gone through, my lord, though, my lord, it covers the issue, but
Yes.
the impugned order, my lord, was, the order under challenge was, my lord, passed at the instance of, my lord,
Suraj Govindraj
reorganization
ಸಾಹೇಬ್ರದ್ದು ಅಂದ್ರೆ ಪೂರ್ತಿ ಡೀಟೇಲ್
reorganization of a taluka, my lord.
This is also.
ಏನು ಅದನ್ನ ನೋಡೋದೇ ಬೇಕಾಗಿಲ್ಲ, ಸ್ಟ್ರೈಟ್ ಅವೇ.
In this case, what had happened, my lord, a new taluka, Ratteli taluka was formed. Earlier, my lord, Hirekeru taluka was holding the one society. It is
ಇದು
because a new
appeal
taluka was
ಹಾಕಿಲ್ವಾ?
formed. ಆ ಹೊಸ ತಾಲೂಕ ಆಗಿದೆ ಅಂತ ಹೇಳಿ
ಇದು ಹೊಸ-
ಸೊಸೈಟಿಗೆ ಅದನ್ನ ಅಸೆಟ್ಸ್ ಅನ್ನು ಬಿಟ್ಕೊಡೋದ್ರ ಬಗ್ಗೆ
ಅದು
ಒಂದು
ಕನ್ಸಿಡರ್
amendment.
ಮಾಡಿದ್ದಾರೆ.
ಅದು
That is specific
that is,
point.
ಇದರಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಪ್ರೈಮರಿ
ಗ್ರಾಮ
ಕ್ರೆಡಿಟ್
ಪಂಚಾಯತಿ
ಸೊಸೈಟಿ ಇದು
ಅಂತ.
ತಾಲೂಕ್ ಪಂಚಾಯತಿ ಅಷ್ಟೇ.
ಇದು
This-
ಸಪರೇಟ್ ತಾಲೂಕ ಆಗಿರೋದ್ರಿಂದ ಅರ್ಲಿಯರ್ ಇಟ್ ವಾಸ್ ದಿ ಹಿರೇಕೆರೂರ್ ವಾಸ್ ಹೋಲ್ಡಿಂಗ್ ದಿ ಎಂಟೈರ್ ವಿಲೇಜಸ್ ಬಟ್ ನೌ ಮಲೆಡ್ ಇಟ್ ಈಸ್ ಸಬ್ಡಿವೈಡೆಡ್ ಇಂಟು ರಟ್ಟೇಳಿ ತಾಲೂಕು ಮಲೆಡ್ ಇಟ್ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಇಟ್ಸ್ ಓನ್ ಸೊಸೈಟಿ.
ಅದೇ ಬರ್ದಿರೋದಿಲ್ಲ ಇಲ್ಲೂ ಅಷ್ಟೇ. ಯಾವ ತಾಲೂಕ? ಬಾಚಿಹಳ್ಳಿ ಅಲ್ಲಿಂದ
ಗ್ರಾಮ
ಇ-
ಪಂಚಾಯತ್.
ಇದರಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ, ಫಾರ್ಮೇಶನ್ ಆಫ್ ನ್ಯೂ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಂಡ್ PCA, and this is ತಾಲೂಕ್
ತಾಲೂಕ್
ಪಂಚಾಯತ್, that's all. And both were
ತಾಲೂಕಾ
constitution.
Except ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಂಡ್ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ವರ್ಡ್ಸ್ ಡಿಫರೆಂಟ್ ಬಿಟ್ಟು ಬೇರೆ ಏನು
Effect of 12(5) and the area of operation.
ಜೊತೆಗೆ.
At wo-
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the issue in the list stands completely answered by what the coordinate bench has rendered in so and so. The coordinate bench has held as follows, para 13 in the issues in the, take it to the end. Now, the learned counsel appearing for the respondent would though submit that the order covers the issue in the first blush, but the issue is, it was a gram panchayat before the coordinate bench, and in the case at hand, it is the taluk panchayat. The said submission is unacceptable as it would
ತಾಲೂಕು
not.
ಪಂಚಾಯತ್ ಎಂಟೈರ್ ತಾಲೂಕ ಮಲೆಡ್
Taluka,
ಪಂಚಾಯತ್.
that is new gram panchayat, gram,
New taluk ಅಂತ ಹೇಳಿ.
that is new gram
Gram
panchayat.
panchayat.
Formation
The
of a
case
new-
before the coordinate bench was concerning a new gram panchayat. Here it is the case concerning a new taluk. Therefore, they would submit that the judgment is not applicable. The ratio that is laid down by the court is applicable whether it is for a taluk or a gram panchayat. In that light, the said judgment also having become final, as it is not challenged till date, I deem it appropriate to follow suit as as judgment rendered by the learned, by my learned brother is in great detail considering all the aspects of law. For the same reasons rendered in so and so, the petition deserves to succeed. Allowed, same order.
Lecture
One
G allowed.
submission,
Same order first in improved order first.
one submission on behalf of respond. At the instance of governmental reorganization of the talukas, Malad, that order was passed, Malad, to hand over the assets of the society to the new taluka.
No, that is worst.
to have its
There
own
is no
business.
power under the cooperative society. That is in worst, that is not there in present order.
ಅಷ್ಟೇ. Yes. Larger questions ಹೋದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ. 14, please.
Oblige.
Srinath.
Due to COVID-19 lockdown, the petitioner was unable to the report is a duty. For 34 days, the salary they have not paid. For that purpose,
petition ಇದು
please,
34 ದಿನಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ?
he is not, he is a retired person, retired employee.
34 ದಿನ.
He reported duty, my lord, after 34 days.
At that time,
ಡೇಟ್ ಒಂದು ನಿಮಿಷ ಸರ್, ಡೇಟ್ ಸೇರ್ಬಿಡಿ.
Electricity.
ಎಸ್ ಫಾಸ್ಟ್.
on 6/5/2021, my lord, the one B. Manjunath was transferred in the place of petitioner, my lord. On 7/5/2021, he relieved, my lord, the petitioner relieved from the, my lord, the post, my lord. From 7/5/2021 till 21/6/2021, there was a lockdown, my lord. Government imposed lockdown.
ಎಲ್ಲಿಂದ?
10/5/2021 till 21/6/2021, my lord.
21 ಈ ತರ ಲಾಕ್ಡೌನ್ ಇರ್ಲಿಲ್ವಲ್ಲ?
I have produced, my lord,
2020 ಮಾತ್ರ ಇದ್ದಿದ್ದು ಲಾಕ್ಡೌನ್.
SOP, my lord, I have produced annexure.
ಕಂಪ್ಲೀಟ್ ಲಾಕ್ಡೌನ್ ಇದ್ದಿದ್ದು ಓನ್ಲಿ ಫ್ರಮ್ 21st March 2020 till April for 45 days till April.
ಆಮೇಲೆ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕಂಪನಿಗೆ ಅಪ್ಲೈ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
Because of the transportation ಅದು ಹುಬ್ಳಿಂದ my lord ಬೆಂಗಳೂರು ಜಾಯಿನ್ ಆಗಲಿಲ್ಲ ಅಂತ, that is the
ಹುಬ್ಳಿಯಿಂದ ಬೆಂಗಳೂರು.
ಹುಬ್ಳಿ, my lord, ಹುಬ್ಳಿಂದ.
It was not, my lord, applicable to the, my lord,
ಆಮೇಲೆ anything else? ಈಗ ಅದಕ್ಕೆ 34 ದಿನಕ್ಕೆ salary.
34 ದಿವಸ ಸ್ಯಾಲರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ.
ಯಾವತ್ತು ಜಾಯಿನ್ ಆದ್ರಿ?
Chief Financial.
On 21/6/21 I have joined, my lord.
ಕಾಮೆಂಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಇದು?
Annexure G1, my lord, the circular.
Annexure H already, my lord, issued, my lord, actually. That period has been treated as
10 days period.
ಡೈಸ್
non under regulation 98, my lord.
ಗೊತ್ತಾಯ್ತು, ನಿಮ್ ಡೈಸ್ ನಾನ್ ರೆಗ್ಯುಲೇಷನ್ ಗೊತ್ತು.
You lordship is aware, my lord.
ಡೈಸ್ ನಾನ್ will not die.
My lord, actually, my lord, what he is, my lord, telling, the reason for, my lord, not reporting, my lord, waiting for 34 days, my lord, is lockdown period. My lord, the guidelines, my lord, issued by the government, my lord, he is relying. So that, my lord, guidelines is not
Guidelines issued in?
Guidelines issued by the government, my lord, restrictions imposed, my lord, during period of, my lord, the lockdown.
Intermittent.
In fact, my lord, that is not applicable.
Statutory limitation extend
It
ಆಗಿದೆ
is not
ಬಿಡಿ ಇದು
applicable.
ಆಗ್ಲಿ.
It is not applicable, my lord, certain, my lord, the services, my lord, actually, electric service, my lord, actually.
ಇದು ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಸರ್.
My lord, may I?
ಬಿಗ್ ಕೇಸ್ ಯಾಕಂದ್ರೆ ಕಾಸ್ಟ್ ಎಲ್ಲ ಇಂಪೋಸ್
My lord, only one submission, my lord, the, my lord, financial, my lord,
ಫಿನಾನ್ಸ್ ನೀವು ಎಷ್ಟೊಂದು ಹರಾಕಿರಿ ಮಾಡ್ತೀರಾ ಇಲ್ಲಿ?
director of finance,
ಅಯ್ಯೋ,
He is director of
you treat it as if it's your personal fiefdom, imposing penalties upon employees, not paying pension for ages. 34 ದಿನಕ್ಕೆ ತುಂಬಾ. You don't like his face ಅಷ್ಟೇ.
ಏನಿಲ್ಲ, my lord, not reported, my lord, within time.
ಕರೆಕ್ಟ್. ಎಷ್ಟು ಜನ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಳಲ್ಲ ಸರ್?
financial advisor.
Financial advisor post, my lord, actually, it's a very important post, my lord. He is supposed to, my lord, join. My lord, may I seek, my lord, short time, my lord.
No sir, why sir?
ಇದರಲ್ಲಿ ಏನೋ ಪ್ಯಾರೈಸ್ ಕಮಿಟ್ಸ್ ಬಂದಿಲ್ಲ.
ಅಯ್ಯೋ 34 days.
I understand, my lord.
34 days salary, 340 days ಆಯ್ತು
Monday
petition
till
pending
Monday, my
ಆಗಿ.
lord. Till Monday, my lord.
Please.
Tuesday.
Tuesday.
At the request of council,
I
DS
understand,
Comte, list the matter on Tuesday in fresh matters.
Please.
Next.
Madan Goda and Patil. Mallikarjuna is here, ma'am.
Here for petition. 3 and 4, my lord.
Pension
Discuss 3 and 4, my lord.
Settlement.
I have filed application for recalling the order, my lord, by which, my lord, your lordship has imposed cost, my lord.
ಯಾವುದು sir?
Earlier, my lord,
Petitioner was
last
retired from service in 2024.
order dated 19/2.
Management is concerned for having kept the papers of the petitioner pending for 7 months. Cost of 50,000 is imposed.
Actually, my lord, he has signed the pension paper on 4/12/2024, my lord, and we have, petitioner has signed the pension paper on, I have produced along with application.
4/12/24.
House Swami. And we have sent it on 10th of December 24, my lord. And it was received in the DDP office on 12 of December.
Correct ಅದು?
Alla, produce my document produce ಮಾಡಿ. Along with application I have produced.
Dispose ಆಗಿದೆ pending?
ಇಲ್ಲ, pending ಇದೆ.
ಮತ್ತೆ ಕೊಟ್ರ ಪೆನ್ಷನ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, we have sent paper, my lord, to the department.
ಕಾಸ್ಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬೋಣ ಅವ್ರಿಗೆ.
ಅವ್ರ ಮೇಲೂ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರ ಮೇಲೂ ಹಾಕಿದ್ದೀನಾ? ಹೌದು ಸ್ವಾಮಿ.
Yes.
I have produced, that's why, my lord, I have produced the document.
Yes, madam. We'll transfer the cost to you in the sense government.
We have sent the papers, your lordship.
ಯಾರಿಗೆ?
From
ನೀವು
ನಮ್ಮ
ಯಾರು
ಆಫೀಸ್ ಇಂದ ಕೆಳಗೆ ಕಳಿಸಿದೀವಿ, AG ಆಫೀಸಿಗೆ ಲೋಶಿಪ್.
ಯಾವಾಗ ಆಗುತ್ತೆ?
ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು.
ಯಾವಾಗ ಆಗಬಹುದು ಮೇಡಮ್?
That was sent on, my lord, 24/1/25, my lord. It is pending before the AG. AG is not party here, my lord.
Parvailla, government is there. Government controls the ages.
Yes.
I will verify your lordship whether it was released or
ಯಾವಾಗ
finalized.
ರಿಟೈರ್ ಆಗಿದ್ದು ಯಾವಾಗ?
31/5, my lord. 24.
The petitioner is before the court seeking disbursement of pension.
ಅಲ್ಲ ಅಲ್ಲ, consideration of his representation, my lord.
ಒಳ್ಳೆ ತೊಂದ್ರೆ ಇಲ್ಲ. Consideration of representation which concerns disbursement of pension. This court on 19/2/2025. ಅಯ್ಯೋ ಆವಾಗ ಆಗಿದ್ದ, ಇನ್ನೂ ಬಂದಿಲ್ಲ ಪೆನ್ಷನ್.
Your lordship, one more thing, your lordship, there is some departmental inquiry is pending against. ಅದು ನಾನು ಸ್ವಲ್ಪ
ಇಲ್ಲ ಇಲ್ಲ,
verify
departmental inquiry means, my lord, we have sent article of charges to the petition.
List the matter on Tuesday in the fresh matters.
Is your lordship.
ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ
Is
ಮೇಡಮ್.
your lordship.
ಯಾಕಂದ್ರೆ ಮತ್ತೆ
ಹೌದು,
1 ಲಕ್ಷ
ಇಲ್ಲ.
2 ಲಕ್ಷ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ ನಮಗೆ
ಬೇಡ.
ತೊಂದರೆ ಆಗ್ಬಾರ್ದು.
Then so far as our is
ಅದು ಅವತ್ತೇ ಮಾಡುವ.
please,
Let this word hang on your head ಸ್ವಲ್ಪ ದಿನ ಇರ್ಲಿ.
please.
Yes.
17.
Yes, sir.
I'll take out hand summons.
25 ಅಲ್ವಾ?
17.
17.
It was heard, your lordship.
Without
there is,
conducting departmental inquiry, my lord.
Allala.
Dismiss
He was
from
absent
service.
for 493 days, your lordship. Earlier I have submitted
Ah.
the last occasion.
ಓ ಇದು
Ah,
ಟ್ಯೂಸ್ಡೇ ರಿಗ್ರೆಟ್
Into a former.
because contempt they have filed, your lordship.
ಯಾವತ್ತಿದೆ ಕಂಟೆಂಪ್ಟ್ ಏನಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟರೆ
entry ಮಾಡ್ರಿ,
ಅದೇ
sir.
ಪ್ರಾಬ್ಲಮ್. ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಎಂಟ್ರಿ ಮಾಡಿ.
Even last time, your
Next
lordship
week, maybe
was
take a
asked
next
me
week, your
whether
lordship.
pension.
Contempt ಯಾವತ್ತು? The learned counsel for the petitioner undertakes not to precipitate the contempt proceedings.
But if
List
it
the
is-
matter on Wednesday.
Please, your lordship.
Please.
Yes. In fresh matters list.
Number 18. Sheridan Patil.
This lordships, my lords, was pleased to allow the writ of mandamus, my lords, directing my lords to consider the petition on compassionate authority, my lords. On the ground that, my lords, his father expired, my lords, on 20.
Compassionate appointment.
Compassionate appointments, my lords.
Your lordship, father is government.
My lords, now what has happened, my lords, since within 1 year, my lords, the application was not submitted, it was rejected on that ground. My lords, annexed, my lords, his brother, my lords, has given an application, my lords, prior 1 year, my lords. Only on that ground. it
Your
was not
lordship, one
considered.
KAT, government school teacher.
ಏನಿದು? ಸ್ಕೂಲ್ ಟೀಚರ್.
ಅಲ್ಲ ಇವ್ರನ್ನ ಎಂಪ್ಲಾಯ್ ಇದ್ರಾಗ he is seeking for that, my lords. Only that, my lords, let them consider this thing, application, my lords, and pass an order.
Appointment.
But
No, you have to go there on.
Yes, no, my lords, let them at
But
least.
there is already my order, madam.
Yes, my lords.
ಅವಾಗ ಯಾಕೆ ಹೇಳಿಲ್ಲ ಇದು? ನೀವಿರ್ಲಿಲ್ಲ.
His brother has given an application, my lords, within 1 year, my lords. That this document was not considered by
Petitioner is
the.
before this court seeking the following prayer. The petitioner was before this court seeking an identical prayer. This court disposes the petition by the following order, page 38 to 40. The result of the direction to consider his representation is the impugned order. The impugned order rejects the claim of the petitioner on this score that the application is not submitted within 1 year after the date of death of the employee.
Yes.
The learned counsel for the petitioner has now placed on record a representation submitted by the brother of the petitioner seeking employment on compassionate grounds. The communication is received by the respondent. The communication reads as follows. The representation is on 25/11/2025. The father of the petitioner had died on 20th April 2009, sorry, 25/11/2019.
19.
The father of the petitioner had died on 20th April 2019. Therefore, the reason rendered in the communication that there was no application filed within 1 year is on the face of it incorrect, which results in the prayer of the petitioner being granted with a direction to consider the case of the petitioner for compassionate appointment strictly in consonance with law and not reject it on such frivolous grounds of not submitting the application within 1 year without verifying the records.
And also, my lords, the brother has given also the consent, my lords, that he's.
All right, so and so. The learned counsel for the petitioner now submits that the brother of the petitioner has also consented to the appointment of the petitioner.
Annexure also is made.
Which is the affidavit is appended to the petition. In all these, in the light of all these circumstances, despite the vehement opposition of the learned HCGP.
KAT also, your lordship. KAT he is supposed to.
Despite vehement opposition of the learned HCGP, that the matter has to be placed, matter has to be urged, the grievance has to be urged before the Karnataka Administrative Tribunal, since the matter is for appointment on compassionate grounds, and earlier the petition, the court had entertained the petition. I deem it appropriate to entertain the petition to render a direction to consider the case of the petitioner, bearing in mind the observations made in the course of the order. For the aforesaid reasons, the following order: allowed, quashed. The respondent shall now consider the case of the petitioner in consonance with law, bearing in mind the observations made in the course of the order within 12 weeks from the date of receipt of the copy of the order, if not earlier. All recorded.
Oblations.
19, KL Patil.
I request.
Yes.
I request week's time lots to serve the hand summons.
ಅವಾಗಲೇ ಹೇಳಿದ್ರೆ ಯಾವ ಕೇಸ್ ಈ ಕೇಸ್ಗ?
ಅದು ಕನ್ಫ್ಯೂಸ್ ಆಯ್ತು.
List after vacation. Yes, next.
20, Chetan Manoli.
There will be tax.
Right time to file objection.
Ajay is disabled.
I'll file objection.
Anand Savar Munda.
That is.
I'll file objections.
Learned entry ಮಾಡಿದ್ಯಾ?
Yes, my lords. I'm for R2.
Learned AGA, ನೀವು objection ಹಾಕ್ಬೇಕಾ?
ಇಲ್ಲ, objection R2 ಗೆ ಹಾಕಾಗಿದೆ. Object to IA5, the government will file the objection. I have one submission.
Vacating stay ಹಾಕಿದ್ದೀರಾ? You have filed application for vacating stay.
Yes, yes.
The learned counsel for the second Bhushan Kulkarni ನೀವೇನಾ?
Bhushan Kulkarni along with me, along with Bhushan.
Yes. Learned counsel along with Bhushan Kulkarni submits that he has already filed his objections and as an application seeking vacation of the interim order. The learned AGA, notwithstanding the same, submits that he would want to file his statement of objections. Therefore, lists the matter on the 8th of January.
One small submission.
Yes, sir.
This petitioner is taking undue advantage of the
Interim order, huh?
interim order. And they are writing the letter to the panchayat that any document sought from the petitioner company will amount to contempt of court. So order may kindly be altered or it can be vacated.
ಅದು ಸುಲಭವಾಗಿ ವೇಕೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Alteration ಏನಾದ್ರು
I don't know what he is making submissions. He has not served the copies also.
ಕೊಟ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕು. List the matter on 8th January.
Interim order may kindly be extended.
Interim order subsisting will continue. Interim order subsisting will continue till the next date of hearing.
Please, oblige.
Not take any precipitative action.
Cell number 21.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೇಳಿದ್ರೆ ನಿಮ್ಗೆ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಲೆಟರ್ ಬರೀತಾರೆ. ಐ ಹ್ಯಾವ್ ಸಾಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಿಚ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಬೈ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ಅಥಾರಿಟೀಸ್. ಲೈಸೆನ್ಸ್ ಕೊಡಿ, ನಿಮ್ಗೆ KDB ಇಂದ ಕೊಟ್ಟಿರೋದು ಅಥವಾ ಎನಿ ಆರ್ಡರ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ.
ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ?
No, I have issued.
ಅಲ್ಲ, ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಲ್ಲ, ಯಾಕೆ ಬೇಕು? ಒಂದ್ ನಿಮಿಷ, ಸ್ಟೇ ಕೊಟ್ಟಿದೆ ತಾನೆ, ಇಂಟ್ರಿ ಮಾಡಿಲ್ವಾ?
ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್
ಆಯ್ತು,
ಟ್ಯಾಕ್ಸ್ ಕೇಳಬಾರ್ದು ಅಂತ ಹೇಳಿ. I am not asking tax.
What are
I am
you
not
asking?
tax.
What are you asking?
I have specifically I have issued one NOC in 2010 which is subjected to follow the conditions prescribed by the competent authorities like ASPCB, revenue authorities and other statutory authorities.
Who are you?
I am PDO.
PDO ಸ್ವಲ್ಪ ಹಿಂಗೆ ಅದು. You always go beyond your jurisdiction for extraneous considerations. I have seen many PDOs like
No,
that, so don't worry.
NOC was issued subject to
problem.
conditions.
Let the PDO hold his hands, otherwise I will direct that he shall not flex his muscles till the pendency of the petition. Sumna idbidi, don't invite orders. PDOs behave as is panchayat, they own the panchayat. Let them behave. Panchayat development officer, not self-development.
True.
Okay. Yes.
Number 21, Jagdish Patil, Shashank Hekar.
Lord, in this page 39, my lord, order of this honorable court to mutate name of petitioner.
Mandamus.
Endorsement was
What
quashed.
happened, my lord? The said land has been acquired for the purpose of airport authority, my lord.
ಎಲ್ಲಿ?
Hubli.
Again compensation ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
No, my lord, they are entering the name of the petitioner in the record of rights, my lord.
ಅಕ್ವೈರ್ ಆದ್ಮೇಲೆ ನಿಮ್ದೇ
Alla, endorsement was given.
ಈಗ ಅಕ್ವೈರ್ ಆಗಿದ್ಯಾ?
Alla, I am not able to claim compensation, my lord.
ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ.
No, as per revenue record, the
I have
earlier
purchased the
owner is
property.
the.
When did you purchase the property?
My lord, the sale deed also have produced at page 13, my lord,
One
1-3.
dated 11th December 87. Correcta?
Please.
Acquisition ಯಾವಾಗ?
2007, my lord.
Your name entry ಆಗಿರ್ಲಿಲ್ವಾ?
ಆಗಿರ್ಲಿಲ್ಲ. So earlier owner has taken compensation, my lord. As per instruction, my lord, one Naik Madhukar Tande
The
Ramrao.
Honorable Court, my lord, page 38, may
I
kindly
have
be
seen
seen.
those orders.
Please, page 38, this Honorable Court has observed, my lord, this is the fourth round of litigation.
Yes, sir.
It's not in dispute that the petitioner has purchased the plots bearing 65 and 66 in the said survey number. The petitioner has produced the PT sheet indicating the new plot numbers 63 plus 67/6 having been allotted to those lands purchased by him.
ಈಗ
It
there
is-
is a direction, yes, twice, thrice, consider the documents necessary. ಏನ್ ಮಾಡಿದ್ರಿ ಈಗ?
We are not party to that.
You are not
Early-
party.
No, my lord.
ಯಾರು ನೀವು?
The first time we are, government is the party.
Annexure F may kindly sing. Annexure F is the, my lords, endorsement issued by the Tahsildar.
Page.
Page number 43, my lords. 43. Please. My lords, first.
ಈ ಕಾರಣ ಹುಬ್ಬಳ್ಳಿ ಧಾರವಾಡ ಮಹಾನಗರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಕೊಂಡುಕೊಳ್ಳುವ ಅಂತ ತಿಳಿಸಿ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ಕ್ಲೋಸ್ ಮಾಡಿದೆ.
Please. The, in the, my lords, above para.
ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಯ್ತಾನೆ ಮುಂಚೆ
ಯಾರಿಗೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನ.
Annexure H, my lord, page number 48.
You consider this in the light of the several orders passed and past necessary orders.
Yes.
The petitioner is before this court seeking the following prayer. The petitioner was before this court not once but thrice. The coordinate bench on 11th September 2020 has passed the following order. Page 33, 35 to, sorry, 9, 8, 33 to 36. Para 2 to 33 to 39. The petitioner then submits a representation in terms of the order. It then again comes to be rejected. The rejection of which is called in question. ಮತ್ತೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
Please, my lord.
Second petition ಯಾವುದು ಸರ್?
Second petition, my lord, first petition was in 2017.
ಎಲ್ಲಿದೆ ಅದು?
That's at page 27.
Even before the said order, the petitioner was before this court in
WP 10899.
27 ಅಲ್ಲಿ ಅದು 28 and 30. ಮೇಡಮ್ ಇದಾಗುತ್ತೆ ಫಸ್ಟ್ ಇದಾಗ್ಬಿಟ್ಟದಾಗಿ. For the third time, the petitioner again is before this court in writ petition 106221 of 2020. The coordinate bench disposes the petition by the following order. The result is the subject petition. The learned counsel appearing for the second respondent Shashank Hegde, 4 and 5, Shashank Hegde, now submits that the first time the petition, the respondents 4 and 5 have been made parties to the list. To all the earlier orders, it was only the state that was a party. In that light, the learned counsel submits that if a reasonable time would be granted, the appropriate orders would be passed in accordance with law. In terms of also bearing in mind the observations made by the coordinate benches as quoted herein above. In the light of, in that light, I deem it appropriate to dispose the subject petition directing the respondents 4 and 5 to consider the case of the petitioner and pass necessary orders. It is needless to observe that the respondents 4 and 5 would not drive the petitioner back to this court again on the same cause of action of not considering the representation in accordance with law. The compliance within 12 weeks from the date of receipt of the copy of the order. Yes, next.
Obliged.
Next.
22, Sanjay's category.
My lord, the first petitioner, 101148. My lord, in this
ಏನ್ ಮೂರಿದೆ ಇದು?
connected petitions, my lord.
5 ಇದೆ.
Yes, ma'am. The other four petitions are against the suspension order, wherein the petitioner were working in a C category in the fourth respondent, CMC Kushtigi Melo. That the some of the landowners who got the layout approved from the deputy commission sought 40% release. And it was released prior to this petitioner who were joined as a bill collector and the revenue inspector, whereas the second
ಈಗ
division.
4 petition suspension da.
Yes, they are all suspend, the connected petitions.
ಯಾವ್ಯಾವ suspension sir?
22.1, 2, 3 and 4, ma'am.
Suspension na?
Yes, ma'am. Those are stayed by this honorable court.
All right, ಇದೇನು 22 ಏನು?
20, now, my lord, an order is passed, directing to hold an inquiry officer is appointed. Fifth
So what?
respond. The very suspension order, the deputy commissioner as then chief says that these petitioners are nowhere concerned when approving the 60% layout. 40% were given to the layout holder. Second 60%, which has to be released after the area has been development, my lord. And they sought a permission, and deputy commissioner, chief officer of the TMC, he has forwarded, and we were never consented. For a moment, my lord, the form number 3, which specifically says that who is the person responsible for it. We have never noted in the office file that is to be. Kindly see annexure D, my lord, with the typed copy I filed. Where it is.
ಏನು?
I filed statement of objections. These are, my lords, to be in the inquiry proceedings. These things have to be gone into by the inquiry officer.
Suspension.
ಅಲ್ಲ, but
Stay ಆಗಿದೆ suspension. ಅದನ್ನ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. Enquiry.
Inquiry.
One more submission, my lord. Deputy commissioner himself, typed page 116. Kindly see, my lord. He says, he recommend to the director of municipal administration that these petitions are, kindly see page 116 typed copy.
Which petition?
In the first petition, 1148, my lord. The lord's first petition.
101148.
10448. In that, my lord.
Enquiry ಆಗಿದೆಯಾ?
No, my lord, suspension itself was, because the.
11 page?
116, my lord, 116. Annexure P, my lord. The typed copy is there. Last two line, my lords. ಪ್ರಯೋಗ ಇಮೇಲ್ನ ಸರ್ವೆ ನಂಬರ್ಗಳು ಬರುವ 50% ನಿವೇಶನ ಈ ಹಿಂದಿನ ಮುಖ್ಯ ಅಧಿಕಾರಿಗಳು ಪೂರಸಭೆ ಇವರಿಂದ ನಿಯಮ ಬಾಹಿರ ಬಿಡುಗಡೆಯಾಗಿದ್ದು ಸದರಿ ಲಗ್ಗಸಿ ನಿವೇಶನಗಳು ಯಾದಿಯನ್ನು ಉಪನೋಂದಣಿ ಸಲ್ಲಿಸಿ ಸದರಿ ನಿವೇಶನ ಪೂರಸಭೆ ಸುಪೂರ್ತಿಗೆ ಪಡೆದು KMF ರಿಜಿಸ್ಟರ್ ಆಗಿರುವ ಖಾತೆ ರದ್ದುಪಡಿಸಿ ಈ ಕಾರ್ಯ ವರದಿ ಸಲ್ಲಿಸಿ ಸೂಚಿಸಿದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ದಿ ರೆಫರೆನ್ಸ್ ಇಸ್ against that, my lord, the sub-registrar was directed to cancel it, against which landowners have also filed an appeal itself.
ಆಯ್ತು, let the inquiry officer consider.
And my lord, kindly see
Look
next
into
page.
Everything. Suspension we will set aside.
Yes, kindly for a moment, annexure page, next Q, my lord, 117, my lord. Last line says, my lord, annexure Q, page 117, my lord. That so and so, the ಅನುಬಂಧ 4 ಆರೋಪಿ ಪಟ್ಟಿಯನ್ನು ತಮ್ಮ ಕಾರ್ಯ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಆದರೆ ವಸತಿ ವಿನ್ಯಾಸ ಬಿಡುಗಡೆಗಳು ನಮೂನೆ 3 ವಿತರಣೆ ಮಾಡಲು ಇವರೆಲ್ಲರೂ ಸಂಬಂಧಿಸಿದ ಕಡತದಲ್ಲಿ ಹಾಗೂ ಆನ್ಲೈನ್ ತಂತ್ರಾಂಶದಲ್ಲಿ ತಮ್ಮ ವರದಿಯಲ್ಲಿ ನೀಡಲು ಶಿಫಾರಸು ಮಾಡಿರುವುದಿಲ್ಲ. ಆದರೆ ಹಿಂದಿನ ಮುಖ್ಯಾಧಿಕಾರಿಗಳು ಶ್ರೀ ಉಮೇಶ್ ಹಿರೇಮಠ ಇವರು ತಮ್ಮ ಸ್ವಂತ ನಿರ್ಣಯದಿಂದ ತಂತ್ರಾಂಶ ನಮೂನೆ ನೀಡಲು ಅನುಮತಿ ನೀಡಿರುತ್ತಾರೆ. ಇವರ ಮೇಲೆ ಆರೋಪ ಮಾಡಿದ್ದೆ. ಆದರೆ ಮೇಲಿನಂತೆ ಇವರು
4 Please let the inquiry officer look into.
ಅಲ್ಲ, ಇವರಲ್ಲಿ ಕೈ ಬಿಡಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. We are now concerned.
ಕೈ ಬಿಡಲು ಮಾನ್ಯರಲ್ಲಿ ಕೋರಲಾಗಿದೆ.
Yes, my lord. So the annexure D also says, my lord, it is all online, my lord. We have never recommended or anything. And these are bill collector, SDA and all this, my lord. They don't have any authority of supervising or any file.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು?
My lord, pursuant to this, my lord, thereafter suspension order that was stayed, and now inquiry, annexure R is the inquiry order. My lord, I produced the stay.
ಯಾರ್ communication ಯಾರಿಂದ ಯಾರಿಗೆ?
That is the chief officer to the power order.
Officer ಬರ್ಸಿರ್ತಾರೆ.
The director of municipal administration. He is the authority.
Chief officer would have.
Chief officer ಬಿಡಿ, ಇವರು bill collectors ಆ?
ಅಲ್ಲ, bill collector and revenue officer.
ಇವ್ರಿಗೇನ್ power
Different
ಇದೆ?
rankings.
What is their power to do this?
They will have to, my lords, give consent or they will have to.
ಈಗ 60-40 ಮಾಡಕ್ಕೆ ಇವ್ರಿಗೆ ಎಲ್ಲಿದೆ power?
ಅಲ್ಲ, powers ಇಲ್ಲ.
ಮತ್ತೆ?
But when, my lords, the file is submitted and they will have to say my lords, whether that is fit for release of the
Who is the
60%
ultimate
or not.
approving
And based
authority?
on that,
Approving authority.
based on that, the chief officer will approve it.
ಹೌದಲ್ವಾ?
Based on that.
Based on that.
Based on
Chief
that.
officer has approved it.
Yes, sir, chief officer has
He has
approved.
approved it, no problem. Now this chief officer says that everything is online, these people have nothing to do with it.
Yes, sir. Further, next chief officer who has come, my
Whoever,
lords.
if they won
Yes.
over that chief officer.
Yes.
ಅವ್ರನ್ನ ಮೀಟ್ ಮಾಡಿದ್ದಾರೆ.
Ade. He has only, my lords, reported to the DMA. And the DMA has to take, my lords, action and to hold an inquiry.
Your Lordship, these are the persons who are the ground level workers, Your Lordship. On their report, Your Lordship, they have to do work, officers. The inquiry is to be conducted, Your Lordship. And after inquiry, it will come to know whether these are the persons who
ಚಾರ್ಜ್
are.
ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
Yes, ma'am. We have given reply also. For a moment, my lord, what are the other sides? Please.
ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿದರೆ you have given your reply.
Yes,
If
ma'am.
reply is considered?
No, my lord. By that time, you approach this honorable court, my lord.
Said, now
And
we'll do this. We'll direct the disciplinary authority to consider the reply. Bearing in mind all this that has happened and pass necessary orders in accordance with law. If they continue the inquiry, then you can come back. Suspension orders will set aside.
For a moment, kindly see annexure D, page 35, my lord. ಅದರಲ್ಲಿ my lord computer, ಈ ಆಸ್ತಿ ಬಿಡುಗಡೆ ಅಲ್ಲ, we say that ಲಭ್ಯವಿರುವುದಿಲ್ಲ, ಕಾರಣ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿ ಕುರಿತು ಸ್ಥಾನಿಕ ಪರಿಶೀಲನೆಗೆ ರವಾನಿಸಿದೆ, ಮುಂದಿನ ಕ್ರಮ ಕೈ. We are only stated they have not deposited tax or anything. We recommended for him. And annexure E series, my lord, chief officer, he put a condition and release, my lord. And he is placed under suspension. He is not placed, he is given other post, my lord. The persons who have committed.
Chief executive officer ಅನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ ಆಮೇಲೆ.
ಅಲ್ಲ ಬೇರೆ ವರ್ಗಾವಣೆ ಮಾಡಿದ್ದಾರೆ. Annexure E and all these things. My lord, these bill SDA and other things, they don't have role at all. And we have not recommended what government advocate says are other. Annexure D, my lord, ನಿವೇಶನಗಳು 3 out of 4 layouts, some 2 acres and other things. My lord, we have never, ಸದರಿ ವಿನ್ಯಾಸ ನಿವೇಶ ಬಿಡುಗಡೆ ಆದೇಶ ಲಭ್ಯವಿರುವುದಿಲ್ಲ.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, unless it is without jurisdiction, we will not interfere with the charge sheet. We will only direct the disciplinary authority to consider a reply and see whether further inquiry is necessary or not. Suspension orders I will set aside. Yes.
Please.
The petitioners in these cases are different, but cause of action is solitary. The cause of action is the challenge to the orders of suspension. In one of the petitions, the cause of action is initiation of a departmental inquiry. For the sake of convenience, the facts obtaining in writ petition 101-492 of 2025 would be narrated. The petitioners are all working in the cadre of bill collector or revenue officers in the which gram in ಯಾವ್ದಿದು ಗ್ರಾಮ ಪಂಚಾಯತ್?
Town Municipal Council.
TMC
ಕುಷ್ಟಗಿ ನೋಡ್ಕೊಳ್ಳಿ. It transpires that a complaint comes about by one Kiran Kamble to the Karnataka Lokayukta regarding alleged misuse of authority by the president and the Panchayat Development Officer of the said Panchayat concerning the deposit of tax collected. It transpires pursuant to the said complaint, the Taluk Panchayat had directed that the service of the petitioners be discontinued for a period of 5 years.
I think, my lord, different petition ಇರಬಹುದು. It is 49, my lord.
Development officer ಬರೋದಿಲ್ಲ.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ಮೇಡಮ್?
ಅಲ್ಲ, ತಪ್ಪು ಕೊಟ್ಟು.
ಜಗದೀಶ್ ಪಾಟೀಲ್ ಇಲ್ಲ ಮೇಡಮ್ ಇದರಲ್ಲಿ, ಯಾವ್ದಿದು?
ಅದು 21 serial number.
Serial number 22. Sorry.
Jagdish Patil ಅವ್ರು 21.
ಅಲ್ಲ ಅದು
ಗ್ರಾಮ ಪಂಚಾಯತ್ ಎಲ್ಲ ಒಂದೇ.
ಇಲ್ಲ, ಫಸ್ಟ್ ಪಿಟಿಷನ್ my lord
101-410.
48 ತಗೋಬಹುದು my lord. 48 ತಗೊಳ್ಬಹುದು ಫಸ್ಟ್. 48 covers all these aspects my lord.
ಎಲ್ಲ ಇದೆಯಾ ಅದರಲ್ಲಿ?
48, yes ma'am.
ಸಾರಿ, ರೀಡು ಮಾಡಿ.
Yes. Lokayukta 481. There is no Lokayukta in this.
The petitioners in all these cases, ಎಲ್ಲ ಒಂದೇ petitioner?
Yes ma'am, 4 persons.
The petitioners in all these cases call in question either the orders of suspension or initiation and continuance of a departmental inquiry against them. The petitioners, ಯಾವಾಗ ಸೇರಿದ್ರಿ ಸರ್ ನೀವು? For the sake of convenience, the facts obtaining in writ petition 101148 of 2025 would be narrated. The petitioners join the service of the respondent, ಯಾವ ಪಂಚಾಯತ್?
For CMC.
Kushtagi Town Panchayat on
Town Municipal Council.
Kushtagi Town Municipal Council.
My lord, in the year 2020,
2019-2020. The service of the petitioners in the respondent is, Panchayat is not the issue in the list. It transpires that these petitioners recommend, ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು?
release of 60% of the layout.
Suspension orders will set aside. It will take
They have not recommended, but they have given their.
I'll look into it and do it. Suspension orders will set aside. Yes. The departmental inquiry will dispose this petition with a direction to this disciplinary authority to consider the observations made in the course of the order and then continue with the inquiry if it is expedient. For the aforesaid reasons, the following order. The petitions, 3 petitions, suspension order. Yav suspension order, Sanjay?
My lord, for 22.1, 2, 3 and 4. Man.
All are suspension.
Yes,
Adu allowed and quashed. In idik matra separate ಬರ್ಕೊಳ್ಳಿ. The petition stands disposed. The inquiry, the charge sheet issued against the petitioner stands sustained, albeit for the present. The disciplinary authority is directed to bear in mind the observations made in the course of the order and consider continuance of inquiry to be expedient or otherwise, and then proceed with the departmental inquiry. While so doing, the reply of the petitioners or the observations made in the course of the order shall be taken note of by the disciplinary authority. Petitioners are at liberty to approach the appropriate fora in the event of need. Yes.
Please.
Number 23, Jagdish Patil, Shivraj Hiremat.
Consider the representation because of certain proceedings, my lord, which are stayed before this honorable court. They are not considering my case for promotion.
It may be disposed of, my lord, or we will consider, my lord.
The petitioner is before this court seeking the following prayer. The petitioner is appointed as ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮೇಡಮ್, ಅದಕ್ಕೆ ಕೇಸ್ ಇದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರ, ಅವಾಗ ಕೊಟ್ಟಿದ್ನಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್, ಅದನ್ನೇ ಹಾಕ್ಬಿಟ್ಟು the learned counsel appearing for the respondent Shivraj Hiremat now submits that if reasonable time is granted, the representation of the petitioner would merit consideration in strict consonance with law, and appropriate orders would be passed thereon. In the light of the said submission, I deem it appropriate to dispose the subject petition with a direction to the respondent to consider the representation and pass necessary orders in accordance with law, within an outer limit of 12 weeks from the date of receipt of the copy of the order, ordered accordingly.
Obliged.
24, Santosh B. Rao.
Covered by judgment, my lord.
Covered,
Covered, my lord.
Tuesday.
Covered Tuesday in Sambandha.
Just verify. I'll just
The
verify
endorsement
and
which has been issued for conversion of land, that land is under acquisition. We will not give the no objection to convert the land by the Buddha. That already this honorable court has considered and quashed.
Third.
In respect of same survey number.
The petitioner is before this court calling in question, seeking the following prayer. The learned counsel appearing for the petitioner submits that identical reason had been rendered to deny the claim of a similarly situated petitioner in writ petition so and so. The coordinate bench has held as follows. The learned counsel,
I make submission. Lots preliminary notification and final notifications were issued. Later on, my lords, the Belgaum Urban Development Authority said that, my lords, it's not in need of this land and sent the proposal, my lords, for dropping the acquisition to the state government. But state government, my lords, has not yet denotified those lands. So the notification still subsist.
Acquisition ಇಲ್ಲ.
The notifications, my lords, still subsist. Unless those notifications are
Preliminary
quashed,
notification, that is.
my lords, no objections, my lords, cannot be issued.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
ಆಗಿದೆ.
ಆಗಿಲ್ಲ ಅಂತಾರೆ.
ಆಗಿಲ್ರಿ. ಇದ್ರಾಗ ಐತಿ
ಅಲ್ಲಲ್ಲ.
order.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿಲ್ಲ ಅಂತಾನೆ ಮಾಡ್ತಾರೆ.
Land acquire ಮಾಡಿಲ್ಲ. Sale deed ಆಗಿ registration
ಇಲ್ಲ,
ಆಗಿ. Still land is, I have produced a record of rights. Land is standing in my name. Annexure A, my lord. Annexure B, page number 29.
Annexure D, my
Acquire
lords.
ಆಗಿಲ್ಲ, ಏನೂ ಆಗಿಲ್ಲ.
Annexure D,
B.
D.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ತೋರಿಸ್ಬಿಡಿ.
36, page number 36.
ಓದಿ.
Proposed for acquisition.
ಇಲ್ಲ, this is notification, my lords.
Proposed for acquisition.
ಸ್ಪೆಕ್ಸ್ ಹಾಕೊಂಡ್ಮೇಲೆ ಬೇರೆ
19-1.
ಸ್ಪೆಕ್ಸ್ ಹಾಕೊಂಡ್ಮೇಲೆ ಬೇರೆ ಕಾಣ್ತಾ ಇದೆಯಾ?
Sorry.
ಇಲ್ಲಲ್ಲ.
19-1, my lords.
19 ಆಗಿದೆಯಾ?
ಆಗಿದೆ. Annexure D,
Yes,
he himself has produced.
Please, my lord.
ಇದ್ರಲ್ಲಿ ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಮಾತ್ರ ಆಗಿತ್ತು ಇದರಲ್ಲಿ.
But till
ಫೈನಲ್
today,
ನೋಟಿಫಿಕೇಶನ್ ಆಗಿರ್ಲಿಲ್ಲ.
records
Therefore,
of
my lords,
rights are standing in
ಅದೆಲ್ಲ
my
ಗೊತ್ತಿಲ್ಲ.
name.
ಫೈನಲ್
Land has not
ನೋಟಿಫಿಕೇಶನ್
been-
ಆಗಿರ್ಲಿಲ್ಲ ಇಲ್ಲಿ. ಲೆಟ್ ಹಿಮ್ ಸೆಕ್ಯೂರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ಲಿಸ್ಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್.
Okay.
ನೆಕ್ಸ್ಟ್.
25 right case, sir. Chetina Isviraj.
Appear for petitioner, my lords. Seeking
Not
regularization,
well still? Yes.
seeking regularization of the petitioner. Petitioner was appointed in the year 2001, has rendered the service for 25 years, my lords. Now
ಏನಾಗಿ ಮೇಡಮ್?
librarian.
Library is all right.
In the earlier round of writ petitionership, they had applied under the notificationership. And they have challenged the procedure in which the selection was done. May I pass on the?
So selection procedure ಆಗಿದೆ. Selection ಆಗಿದೆ.
Lords,
You
what has
argue.
happened is, they had called for the vacancy was
Which they
called,
had not-
lords, and then we had submitted an application. After the entire procedure was completed, after the submission of application, the criteria was changed. That was challenged
Criteria was
before
not
this honorable case.
not changed, Your Lordship. We kindly
ಏನಾಯ್ತು
see, Your Lordship.
challenge?
Lords,
The
we
writ
had-
petition was dismissed, which
Writ
they have not
petition was
disclosed in the
dismissed.
writ petition.
That's
No,
all
we
right.
have disclosed it.
ಅಲ್ಲ ಈಗ ಕಂಟಿನ್ಯೂ ಆಗಿದಾರಾ?
I am still continuing.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೆ?
2000 to 2025, till date I am working. At present.
कहाँ से कहाँ तक?
2002, till date I am working.
1/1/2002.
2001,
1 ಇಂದ
till date I am
Till
working.
date.
Yes.
2013 notification, Your Lordship. They have applied
ಅದೇ
under it.
ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಏನಾಗ್ಲಿಲ್ವಲ್ಲ. ಬಟ್ ಕಂಟಿನ್ಯೂ ಆಗಿದಾರಲ್ಲ. ಅಷ್ಟಲ್ಲ?
Serial number
The rest of 90.
Serial number 19.
90.
90. Same,
Same, Your Lordship. The same institution and same.
The petitioner is before this court seeking the following objections ಹಾಕ್ಬೇಕಾ ಬೇಡವಾ? ಆಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹೋಗ್ಬಿಟ್ಟು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ, ಹಾಕಕ್ ಟೈಮ್ ಕೊಡ್ಲಿಲ್ಲ, ಎಲ್ಲ ಶುರು ಮಾಡ್ತೀರಾ. Shall I take your submissions as your objections?
Institution has forwarded my application.
You forward government ಅವ್ರದ್ದು objection I will stock ಬರೆದ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇಲ್ಲ, ಉಮಾದೇವಿ ಆಗ್ಬೇಕಾದ್ರೆ 10 ವರ್ಷ ಆಗಿಲ್ಲ. ಆಮೇಲೆ ಮೇಡಮ್
The requisite qualification which they
ಇರ್ಲಿಲ್ಲ.
don't have.
ಅಷ್ಟೇ. The petitioner ಇಲ್ಲ ಅವರು ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಹೇಳ್ತಾರೆ. Nothing against you, madam.
No, Your Lordship.
State.
I know.
The petitioner is before this court seeking the following prayer. The ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
Single petitioner, lords.
Single?
Yes.
All right. The petitioner is appointed, heard so and so. The petitioner is appointed as a library supervisor, ಏನು?
Librarian.
Librarian. A librarian ಒಂದು last year ಒಂದು
Yes,
ಬರ್ದಿದ್ದಾನೆ.
I have produced it along with the writ
Same.
petition.
ಇದೇ ಇನ್ಸ್ಟಿಟ್ಯೂಟಾ?
No, my lords, that's a different institution.
In detail, I have considered everything.
Annexure E, my lords, page 28.
Yes. Correct. Judicial. In my last stint, I have done this. Yes. The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. The petitioner is appointed as a clerk cum typist.
And then librarian.
Clerk cum typist on 1/1/2001 at the South Konkan Society's GS Sai College, Belagavi. It transpires later the petitioner on acquisition of the requisite qualification in library sciences is appointed as a librarian. In the interregnum, it transpires that there was a notification seeking direct recruitment to which the petitioner also had participated, but did not come out successful. Be that as it
Selection
may.
agayla, Lordship. Selection agayla. Still, it was under this thing they had
The
challenged.
notification was issued, but there was no selection process initiated. Be that as it may, the petitioner continued to work as a librarian in the said college and is working even today in the said post. Therefore, the petitioner initially as clerk cum typist and librarian later has rendered service of close to 24 years of 25 years of service. In the light of 24 years of service. In the light of the said circumstance, the petitioner submits a representation.
Annexure D. Representation is already given.
Page.
Annexure D, my lords, page 26.
Submits a representation seeking regularization of services on 10/3/2020. Adena 10/3/2025. That having not been considered, reject madidra?
No, my lords, the institution is forwarded to the government.
The institution forwards the same to the state government, and state government has rejected the claim of the petitioner in terms of its endorsement.
It is not yet.
What is that endorsement then?
Endorsement is that, my lords, the second respondent, the earlier notification which was called for direct recruitment, has sent one more communication stating that the selection should be based on 1:5 ratio. That is called in question.
How is that relevant? In regularization, the consideration of non-consideration of the representation is what has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner submits that the petitioner is entitled to be regularized in the services as 24 years have passed by from the date on which the petitioner is appointed initially as a clerk cum typist and later as a librarian. The incidental challenge the learned counsel would submit only to the fact that the communication Yurdalva by the institution. The institution,
By the
state government
has communicated to the institute to initiate process of recruitment and to call communication.
Ratio is to 1:5 ratio ಅಲ್ಲಿ appoint ಮಾಡಿ.
ಅದಕ್ಕೂ ನಿಮ್ಗೆ ಏನ್ ಸಂಬಂಧ ಮೇಡಮ್?
That is what they don't have any.
The incidental challenge is to a communication of the state government to the institution that they should follow the ratio of 1:5 while calling for applications in change to 1:10 that was called earlier. The learned counsel for the petitioner submits that would not have any bearing if a direction is issued to the respondent to consider the case of the petitioner for regularization. Learned counsel for the respondent Chetna Biraj representing the institution submits that they have enclosed the representation and communicated it to the state. It is for the state to take a decision in the matter as it is an aided institution. The learned HCGP submits that the representation of the petitioner is submitted only on 10/3/2025 and would merit consideration in accordance with law if reasonable time is granted. Though the petition could be disposed with a direction to consider the representation in accordance with law, I deem it appropriate to amplify the direction by quoting the judgment rendered by this court with regard to regularization of a similarly situated librarian in a different organization in writ petition 101-459 of 2025. This court has held as follows. ಇದು ಅಪೀಲು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ ಮೊನ್ನೆ. ಅದೆಲ್ಲ ನೆನ್ನೆ ರಾಮಚಂದ್ರ ಮಾಲಿ ಕೊಟ್ಟರು. Therefore, the representation of the petitioner shall bear consideration at the hands of the respondent, bearing in mind the observations made in the order quoted supra. The consideration shall, in accordance with law, shall happen with an outer limit of ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀರಲ್ಲ?
Yes,
outer limit of 4 months from the date of receipt of the copy of this order, if not earlier, ordered accordingly.
Great.
Serial number 90, Your Lordship.
90.
90.
For the reasons rendered in writ petition, Gayatri Madam, though, this said petition also stands disposed in on the same terms.
Serial number 9.
Ah, yes, next.
Published.
26, Chair Kambiawar.
Yesterday disposed of matter. ಅದ ಅಲ್ಲ ಸೆಕೆಂಡ್ ಇನ್ನೊಂದು ಮಾಡಿದ್ರಲ್ಲ ಡಿರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿ ಐ ವಿಲ್ ನಾಟ್ ಪ್ರೆಸ್ ಫಾರ್ ದಿಸ್ ವ್ಯಾಲಿಡಿಟಿ. ನಾವು ಡಿರಿಜಿಸ್ಟ್ರೇಷನ್ is revocation revocated. I am entitled for ITC.
ITC. Tax credit ತಾನೆ?
Please.
So and so, same order.
ನೀನ್ ಒಂದು ಆಗಿದ್ದು ನಂಬರ್ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ, ನಿನ್ನೆ ಆಗಿದ್ದ ನಂಬರ್ ಕೊಡಿ.
Please.
27, KL Patil, Vyas Desai.
Is vacating stay.
Covered.
Covered.
Section 92 of Education Act is not complied. On that reason, my lord, the Education Tribunal has ordered.
Page
Yes,
52,
sir.
page 52.
Covered against them.
Covered, man.
Oh, sorry.
In your favor.
In my favor.
Ah, correct. Adhe.
Lord's page 54, if your lordships shall kindly take.
Hmm.
Para 26.
Hmm. Ah, 92, no document. The petitioner is before this
One
court.
submission. The tribunal has directed for reinstatement, whereas they
That
have
may
all,
be.
they have all,
Reinstatement was ordered.
they have all
They are all
superannuated.
above 60.
ಅದು ಬರಲ್ಲ ಬಿಡಿ.
Except that, my lord, back
Petitioner,
wages.
the petitioner is
Back
before.
wages 50%, my lords, because no work, no pay. During that period, they have not worked.
They don't have any source of income, my lord. They were dismissed without any reason, my lord.
Private unaided
On frivolous.
institution.
Unneeded. ಹಂಗಾರೆ ಕೊಟ್ಟೆ ಕೊಡ್ತೀವಿ. Public money.
50% back wages.
Yes. Unneeded ಆದ್ರೆ public money.
3 teachers, my lord, dismissed without.
27, 28.
Financial condition is not.
Very weak, ಅಲ್ಲ?
Alla, really, my lord.
27.
Really?
27, 28, 29 more.
Seriously? The petitioner is before this court seeking the following prayer. The petitioner is the educational institution in which the respondent teachers were more petition idea one.
Second one is clerk, my lord. She was working as a clerk, promoted as a librarian.
Yeah, serial number ಏನಿದು?
27, 28, 29 more.
28, 29, 13 ಆ?
27, 28.
27, 28, 20, all connected ah?
Same.
Please.
Will pass a common order, different order. Different order. The petitioners in all these cases, separate order ಮಾಡಿ, connect ಮಾಡ್ಬಿಡಿ. The petitioners in all these cases is the educational institution. The challenge in each case is to the order passed by the Educational Appellate Tribunal concerning 3 different employees. All the, for the sake of heard so and so facts and brief germane are as follows. For the sake of convenience, I deem it appropriate to notice the facts obtaining in writ petition 103159 of 2025. 2025. The respondents come to be appointed, one as drawing teacher, other a physical education teacher, and a clerk in the service of the petitioner in the year 1985 onwards. Owing to certain allegations, the respondents were relieved from service. The relieving of them from service on 20th July 2021 and onwards was called in question before the EAT in EAT 1 of 2021, challenging the said order. The EAT allows the application and directs reinstatement and all back wages up to all back wages and salary and allowances. It is this that is called in question by the management. The learned counsel appearing for the petitioner would vehemently contend that that the tribunal has erred in setting aside the orders of order relieving these petitioners and further directing the petitioners becoming entitled to back wages. Entitled to back wages. The learned counsel Vyas Desai, representing the respondents, contends that the respondents were relieved without any rhyme or reason, and the EAT has in detail considered the case of these petitioners and passed necessary orders thereon. Passed an order which is impugned in the subject petition. The learned counsel submits that the order passed by the tribunal is unassailable, and therefore this court should not interfere. I have given my so-and-so. The four narrated facts link in the chain of events and the date and the position of the respondents with the petitioner institution are all a matter of record. The EAT, while allowing the application, allowing the appeals filed by miscellaneous appeals filed by these employees, has on the following reasons rendered the following reasons. Page 26 in the end. Sorry, page 54 to 61. The tribunal holds that the procedure contemplated in section 92 of the Karnataka
Education Act, Excise Act.
the Karnataka Education Act, though printed as excise, of the Karnataka Education Act is not followed, and therefore the entire proceedings are vitiated. The issue is no longer issue whether non-following of the procedure stipulated in section 92 would vitiate the proceedings or not is no longer res integra, as the coordinate bench of this court has held as follows. In the light of the judgment rendered by the coordinate bench is also the fact that there was no procedure stipulated in 92 followed prior to the passage of the impugned order. The order of the tribunal does not would not warrant any interference. The only interference, the tribunal has directed reinstatement into service. All the respondents have attained the age of superannuation as on today. Therefore, there can be no question of reinstatement of those respondents into the service of the management. But the petitioners, the respondents, would become entitled to all other benefits that is granted by the EAT. In the by the EAT, full back wages ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರಾ?
Full back wages ಕೊಟ್ಟಿದ್ದಾರೆ.
They do not have any source for
50%.
They do not have any source of it. They have worked sincerely. And
that is a relative term. Don't worry about it.
But without any reason, my lord, they have been dismissed.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿರೋದು. No work, no pay. ಯಾರ್ದಾರ 75%.
50% in
90.
90? ಏನ್ ಬಾರ್ಗೆ?
ಅಲ್ಲ, because 50% with some interest.
But the petitioners admittedly have not worked. Therefore, to balance the rights of the employee and the employer, and not to mulct the respondent petitioner institution with complete back wages, I deem it appropriate to modify that order of the EAT insofar as it directs 100% back wages to that of 75%. Except the said modification, the petition does not deserve any entertainment in the light of the settled principle of law is also this admitted fact that procedure under section 92 was not followed. Ordered for the aforesaid reasons, the following order. All the petitions are allowed in part except the 100% back wages that is directed, except the modification of 100% back wages that is directed to 75%. No other modification of the impugned order would require. All the other except the said modification, petition stands disposed.
Obliged.
Bill number 30, Chimbula Reddy, PS County.
Your Lordship, that is with regards to the property that has not been utilized for the purpose which it was acquired, Your Lordship.
ಯಾವಾಗ?
The year 1999 and 2000 by notification, Your Lordship, the said land was acquired.
Yes. Government.
That is in the possession of the Millards, the HESCOM.
ಅದೇ ಗೊತ್ತು.
Lord, as per annexure B, my lord, at the time passing award, the landowner has given consent.
Compensation ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ.
I am ready to pay that compensation with interest, Your Lordship. That is the only land which is available to me, Your Lordship.
Give me something.
And at that time,
Judgment ಏನಾರ ಕೊಡಿ.
There are covered matters, Your Lordship.
ಕೊಡಿ ಎಲ್ಲ.
This is
I'll-
consent award.
ಕೊಡಿ.
I'll produce it, Your Lordship.
I'll take it tomorrow,
Please, Your Lordship.
ಬೆಳಗ್ಗೆ.
Yes.
Fresh matters, yes.
Obliged.
Bill number 31, Renovation category. Ventilation for
Lordships, the e-way bill case, Your Lordships. E-way bill, Your Lordships. The part B was not updated, Your Lordships, due to technical reasons. And penalty was
Delay.
delay, no, Your
That's
Lordships.
conveyance
Part B
notes.
of the e-way bill, Your Lordships.
E-way bill is not.
E-way bill.
E-way bill, Your Lordships.
I filed my objections.
Was
one.
not
Kindly
updated.
see.
Objections ಯಾರು ಹಾಕಿದ್ದಾರೆ?
State has filed. Para 8, ink page number 5 of my objections.
But only the part B was not updated.
Listen, preliminary hearing on Tuesday.
Your Lordships, on Monday, Your Lordships.
No, Tuesday. We'll dispose it.
Bill number 32,
There's some reason in posting preliminary.
Yes.
Shivraj is Badoli.
30?
For the respond number 2, my lord.
Petitioners are
I
the
pay for
primary
the respond number 3, my lord.
cooperative societies.
ಏನ್ ಚಾಲೆಂಜ್ ಏನು?
Please, Lords. Lords, we being the primary agricultural cooperative societies, we had taken certain loan from the nationalized bank. Now that amount we have given it to the farmers, which is interest free, my lords. And subsequently, my lords, we are entitled for the reimbursement of that interest. We have produced the documents for having given the interest free loans, which are at Annexure F, pursuant to which, my lords,
ಅವರೇ ಹೇಳಿ ಬಿಡಿ.
please, pursuant to which, my lords, even the respondent number 6 has communicated the same to respondent number 5 and even to the Apex Bank at respondent number 2. Pursuant to which, my lords, the respondent number 2 bank, Apex Bank, they have issued the impugned notices stating that we have not produced that account statements within the stipulated time, and thereby they have rejected our claim.
Yes, madam.
My lord, I apply for the respond number 2. Sorry, my lord.
Apex Bank. Respond number 2, Apex Bank.
Yes.
My lord, the impugned order says that, my lord, since there is a delay in submitting the bill, we have returned it to the government, all the amount. So my lordship has.
ಎಷ್ಟು delay?
Lords, there is no delay, my lords. If your lordships may peruse it.
Even I have called for the documents, my lord, statement of objection ಆಗ್ತಿದೆ ಅಂತ ಹೇಳಿದೆ, ಇನ್ನೊರು ಇದನ್ನು ಫರ್ನಿಶ್ ಮಾಡಿಲ್ಲ. There are fund
ನೀವು ಎಲ್ಲಿದ್ದೀರಾ? ಬೆಂಗಳೂರಲ್ಲಿದ್ದೀರಾ?
No, my lord, I was not well today, so I was appearing through VC.
Monday, fresh matters.
Please.
Please.
Let him come next.
33, Girish Adwar, Jagdish Patil.
For the petitioner. Because the other connected matters where the voting rights were called and sought for, the order copies, they have been released yesterday. The prayer in this petition is
Monday
to hold, yes, Monday or after
Tuesday.
8
After
days.
vacation.
No, after 8 days, because
List on 15th in fresh matters.
please. Interim order may continue.
Interim order subsisting.
Please.
34, Aniruddha Kulkarni.
ಏನಿದೆಲ್ಲ?
Please, this is a challenge to a government order issued in the month of May. The government order is at Annexure A, my lords, page 27. What the government, my lord, decides is that in 2016, the government laid out, my lord, a government order and asked me to come and apply and establish a Janoshadhi Kendra, which is a pharmacy shop in government hospital premises. Please, my lord. In 2025, my lord, overnight they wake up and say that my policy has now changed.
Whose policy?
The government's policy, and that they want to give medicines for free. Therefore, you are no longer required. Is their stand in the government order? Please see page 27.
Where is my Janaushadhi ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ?
I have the soft copy, my lord. Adralli,
You should get everything.
please, the benefits of the scheme ಬಗ್ಗೆ there is an elaborate discussion.
Scheme, why it is necessary, ಅದು two rival ಇದು, why it was necessary ಅಂತ ಬರ್ದಿದ್ದೀನಿ.
The background of the scheme has been
Everything I've
extracted.
said in that.
Please. The impugned order is at page 20.
Ministers Janaushadhi Kendra.
Please,
Yes.
PM BJP, under that Yojana, page 27. If I may read the impugned order. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 1.
We are dispose ಮಾಡ್ತೀನಿ ಇದ್ನ. ಗಂಗಾಧರ್ ಬಂದ್ರಲ್ಲ. Yes. ಏನ್ ಜನಕ್ಕೆ ಔಷಧಿ ಬೇಕು ಅಂದ್ರೆ ನೀವೇ ಕೊಡ್ತೀನಿ ಅಂತಿದ್ದೀರಾ?
ಜನ ಔಷಧಿ ಕೇಂದ್ರದ್ದು
ಅದು ಗವರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಸರ್.
ಹೌದು, ಅದಕ್ಕೆ ನಾವು ಯಾವ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ನಮ್ಮ ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ರನ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ಯಾರು ಯಾವಾಗ?
Sir, my lord was only given, we are not prohibited to selling out.
Just because the dispensation in the center is different, state is different, don't trouble citizens. ಔಷಧಿ ಯಾರ ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
One minute. There is some problem with this centers, my lord. Now we are supplying the same drugs free of cost. So because of that, my lord, they are charging some amount. The complaints have been received.
Oh no, Janaushadhi Kendra, I don't think.
They are, my lord, why this has been done, my lord? Government of Karnataka wanted to sell the medicine free of cost. Earlier, my lord, we have permitted them to sell their product within the premises of the government hospital. Now with the same drugs we are giving it free of cost. So we are not prohibited if they establish the Kendra outside the hospital, we are not prohibited by the
Kendra establish ಮಾಡಾಗಿದೆಯಾ?
My lord, we are only given by rent. They are running their shops.
You have nothing to do with the establishment of the Kendra. It is the Government of India's project. All right. Government of India has approved the Kendra on the basis of a place that they have shown.
No, my lord. That is no.
Kendra will not be approved if there is no place shown.
No. That I will clarify it, my lord. We are only
Segment ಇದೆ.
We have only given the rent, my lord. We are not prohibited outside.
You should get everything.
ಅಲ್ಲ ರೆಂಟು ಇಲ್ಲ my lord. In terms of the earlier government order, free ಆಗಿ ಜಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ. In certain cases, despite there being a government order saying don't take money, give it for free, they are taking rent, my lord. The main matter is one such matter. I produced rent receipts as well.
No, my lord.
And my lord, they are just giving me a space. In multiple instances, I can demonstrate. ಬರೀ ಜಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ 120 square foot. ಅದ್ರ ಮೇಲೆ ನಾನ್ ಲೋನ್ ಹಾಕಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಡ್ರಗ್ಸ್ ನ ಲೈಸೆನ್ಸ್ ತಗೊಂಡು ಐ ಆಮ್ ಸೆಲ್ಲಿಂಗ್.
ಗಂಗಾಧರ್, ಯಾರು ಒಂದು ಮೆಡಿಸಿನ್ ಸಿಟಿಸನ್ ಹೋಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಅಲ್ಲೂ
ಅಲ್ಲ
ಪಾಲಿಟಿಕ್ಸ್.
ಒಂದು ನಿಮಿಷ. ನಾವು ಫ್ರೀ ಆಫ್
ಎಲ್ಲದರಲ್ಲೂ ಪಾಲಿಟಿಕ್ಸ್ ಇನ್ನೇನಿದು ಗವರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಮಾಡಿರೋ ಪ್ರಾಜೆಕ್ಟ್ ಅನ್ಬಿಟ್ಟು ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್
ನಾವು ಮಾಡಬೇಡ ಅಂತ ಹೇಳದೇ ಇಲ್ಲ. ನಾವು ನಮ್ಮ ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ಬೇಡ, ನಾವು ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಕೊಡ್ತಿದೀವಿ ಅಂತ ಹೇಳ್ತಿದ್ವಿ ಸರ್. Now we are not prohibited if they are establishing the center outside the hospital. We are not prohibiting, my lord. We don't have a rights over that. What we saying, my lord, within the premises we are giving free of cost. Please vacate it. And that also, my lord,
it may not ಇಲ್ಲ. It may not be as simple as please vacate it. my lord, ಇವ್ರು ನನಗೆ ಜಾಗ ಕೊಡ್ತಾರೆ ಅಂತ ಆ ಪರ್ಮಿಷನ್ ಪ್ರೋಸೆಸ್ 1 ವರ್ಷ ಆಗುತ್ತೆ. ಅದಾದ್ಮೇಲೆ I make necessary applications.
That is why I myself held how Janaushadhi Kendras are generated. What happens? State government they give a place, concurrence of the state government is taken, and Janaushadhi Kendra is established. It does not spring from air. ಈಗ Janaushadhi Kendra establish ಆದ ಮೇಲೆ ನೀವು ಅಲ್ಲಿ ಮೆಡಿಸಿನ್ ಕೊಡಬೇಡಿ, ನಾವು ಫ್ರೀ ಆಗಿ ಕೊಡ್ತೀವಿ. ನಾವು ಯಾವಾಗ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗಿದ್ದು?
ಇವೆಲ್ಲ 2016 onwards.
ಆಯ್ತಾ? 2016 ಈ ಗವರ್ಮೆಂಟ್ ಚೇಂಜ್ ಆಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ. ಅವ್ರಿಗೆ 2 years ಗಿಂತ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ. ದೇ ಎಂಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್.
2 years ಆದ್ಮೇಲೆ ಏನಾಗಿದೆ?
ಇಲ್ಲ, there is no agreement per se, my lord. They have just given a letter saying we need it for the general public interest, therefore please come and set up shop.
There should be agreement. It is a contract, my lord. We said they should require to enter the agreement. No, how can
state also should be reasonable and state or the center, it is for the people, sir.
No,
it is for the people. No citizen should be put to hardship. Anta Janaushadhi Kendra, the concept of Janaushadhi Kendra became because medicines are very expensive outside. ಅದಕ್ಕೆ ಇಲ್ಲಿ ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಕೊಡಕ್ಕೆ ಅನ್ಬಿಟ್ಟು ಮಾಡಿದ್ವಿ. ಅದಕ್ಕೂ ಪಾಲಿಟಿಕ್ಸ್
ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಇಲ್ಲ. ಅವ್ರು ಚಾರ್ಜ್ ಮಿನಿಮಮ್ ಚಾರ್ಜ್ ಮಾಡ್ತಿದ್ರೆ ನಾವು ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಕೊಡ್ತಿದ್ವಿ ಸರ್. ಈಗ ಮಂಗಳೂರು ತಕೊಂಡ್
ಅಲ್ಲೂ ಪಾಲಿಟಿಕ್ಸ್
ಇಲ್ಲ. ಅಲ್ಲಿ ನಾವು ಅಗ್ರಿಮೆಂಟ್ ಎಂಟರ್ ಮಾಡಕ್ ಹೇಳಿದ್ವಿ, ಟೈಮ್ ಲಿಮಿಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದೀವಿ. ಔಟ್ಸೈಡ್ ದಟ್ we don't have a right to.
You fight on policies. Please. ತೊಂದರೆ ಇಲ್ಲ. With the two governments, let it fight on policies. Citizens should not be.
ನನಗೆ ಅರ್ಥ ಆಯ್ತು. ಅಲ್ಲ ಮಂಗಳೂರು ತಕೊಳ್ಳಿ ಸರ್. I will clarify it on the what are the I will put the documents.
ಯಾರು ಬಡವರಿಗೆ ಔಷಧಿ ಸಿಗುತ್ತೆ ಅಂತಂದ್ರೆ ಅಲ್ಲೂ ಪಾಲಿಟಿಕ್ಸ್ ಮಾಡಿ.
The concern of the court, I understand.
ಮತ್ತೆ not correct. I'll take it on Tuesday, but it's not correct.
Please.
Tuesday ಬೇಡ.
Private multi speciality hospital ಅಲ್ಲ ಇವು. ಜನೌಷಧಿ ಕೇಂದ್ರ.
One more point, my lord. I secured a drug license for the Kendra, the specific location. The moment I am asked to even take out the drugs out of that stock, out of the location, I am exposing myself to prosecution under the Drugs and Cosmetics Act.
No, it has wide ramifications. Sir, you can't ಸುಮ್ಮನೆ by stroke of pen ಯಾರೋ ಕೂತ್ಕೊಂಡಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬಿಡೋದಲ್ಲ.
Legitimate expectation will also apply.
ನಾಳೆ ದಿನ ಆಯ್ತು, ಇವರು ಜನೌಷಧಿ ಕೇಂದ್ರದಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಆಗ್ತಾ ಇದೆ ಬಿಕಾಸ್ ದೇ ಲಯಬಲ್ ಫಾರ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇಫ್ ದೇ ಡೋಂಟ್ ಪ್ರಾಪರ್ಲಿ. ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಹೋದ್ರು ತಲೆನೋವು. ನೀವು ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ನಾವು ಕೊಡ್ತೇವೆ ನಾಳೆ ನೀವು ಹೆಂಗಂಗ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅವಾಗ? ಎಲ್ಲದಕ್ಕೆ ತೊಂದರೆ ಆಗೋದು ಯಾರಿಗೆ? ನಿಮ್ಮಿಬ್ಬರು ಜಗಳದಲ್ಲಿ ತೊಂದರೆ ಆಗೋದಲ್ಲಿ ಜನಕ್ಕೆ.
In fact, my lord, I can demonstrate ಈ government order ಬಂದ ಮೇಲೂ ಕೂಡ as early as my lord November ಅಲ್ಲಿ they have procured medicines from the same Kendra. The government does not have. It's another issue. Government ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅಂತ. That is not subject matter. But unfortunately, that is the situation.
It's not ಜನಗಳಿಗೆ ತೊಂದರೆ ಆಗಬಾರ್ದು. Legally will answer ಎಲ್ಲ. ಅದೇನ್ ತೊಂದರೆ. I am not fighting shy to answer it legally. But ಜನಕ್ಕೆ ತೊಂದರೆ ಆಗಬಾರ್ದು.
The object of this
object of Janaushadhi Kendra. That's why my judgment is there. Please. I've written why it came.
Please, I will.
Very important.
ನಮ್ದು ಕನ್ಸರ್ನ್ ಫ್ರೀ ಆಫ್ ಕಾಸ್ಟ್ ಅಲ್ಲಿ ನಾವೇ ಕೊಡ್ತೀವಿ.
ಇವ್ರ ಹತ್ರನೇ ಪ್ರೊಕ್ಯೂರ್ ಮಾಡ್ಕೊಂತ ಇದ್ದೀವಿ.
ನಾವು ಪೇಮೆಂಟ್ ಮಾಡಿ ಜನರಿಗೆ ಕೊಡ್ತೀವಿ.
Help.
It can't be that I am coming in the way of them giving free money.
ಅಲ್ಲ ಗವರ್ನಮೆಂಟ್ ಆರ್ಗನೈಸೇಷನ್ ಸಂಬಳ ಕೊಡಕ್ಕೆ ಇಲ್ಲಿ ಪ್ರಶಾಂತ್ ಹೊಸ್ಮನಿ KSRTC ಸಂಬಳ ಕೊಟ್ಟಿಲ್ಲ.
Yes, ma'am. Tuesday, please.
Tuesday, ದಯವಿಟ್ಟು ಬಿಡ. Wednesday, my lord.
Please ಆಗ್ಬೋದು.
Wednesday fresh matters.
Please.
Interim order
to dispose it.
Please.
Yes.
Interim order to continue.
List the matter on Wednesday in the fresh matters list. Interim order subsisting will continue to the next.
I shall get the judgment.
Janaushadhi Kendra. Yes.
So grateful.
35. Ramchandra V. Bhatt.
Bring for the petitioner, my lord. Lord, petitioner is auction purchaser. Lord,
KLR ಇಲ್ಲಿ
he had sought for entering in the name of the my lord.
ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಜನವರಿಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ ಬಿಡಿ. ಇಂಟರ್ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ಅದರಲ್ಲಿ my lord it can be disposed of.
ಪರವಾಗಿಲ್ಲ. Yes. The petitioner is before this court seeking the following prayer. ಏನು ಕ್ವಾಶಿಂಗ್ ಎಲ್ಲ ಕೇಳಿದ್ದೀರಾ?
My lords,
only mandamus restrict ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ quashing it can be allowed, my lord. On it's an auction purchaser, my lord. Petitioner is auction purchaser. My lord, I had sought for entering my name in the revenue records. My lord, it was
the
rejected.
Petitioner is before this court seeking the following prayer. The petitioner heard so and so. The petitioner purchases a property, purchases the land in survey number 72 measuring 5 acres and 11 guntas. ಎಲ್ಲಿ ಯಾವ auction ಅಲ್ಲಿ?
Lord, court auction.
In the court auction, the court of the civil judge Sirsi issues a certificate of sale in favor of the petitioner in execution case 89 of 2015. The petitioner is wanting to get the same registered before so they get the sale certificate registered by producing it before the fourth respondent. The fourth respondent has not acceded to the request of the petitioner, therefore reject madidara.
Annexure H, my lord.
It is rejected on the score that there are set.
Annexure H page 36, my lord.
This comes to be rejected on the score that the application of the petitioner cannot be processed as it is not a compromise decree.
Alla. Respond number 4 has rejected on the ground that limitation under section 23 has expired.
The fourth respondent rejects the same on the score that the limitation as obtaining under section 23. Covered alla bardirbeku.
Haudu.
23 has expired, the limitation is expired and therefore he would not register the document. It is that is called in question before this court in the subject petition. The learned counsel appearing for the petitioner submits that section 89 of the Registration Act does not contemplate any situation of limitation under section 23 to be projected for the purpose of registration or otherwise. And would submit that the issue in the list stands answered by judgment rendered by the coordinate benches of this court. The learned AGA, though, would refute the submission of the petitioner, is not in a position to dispute the position of law as is considered by the LA judgments.
My lords, Annexure J, my lord, page 37.
So and so. The coordinate bench of this court in KM Shrikanta has held as follows. SCC Karnataka online Karnataka quote the same thing. In the light of the issue standing completely answered by what is rendered by the coordinate bench, the petition deserves to succeed with a direction.
My lords, may I make one submission? My lords had issued a direction to state, my lord, to correct its action last occasion. My lord, now it's informed by AGA that, my lord, they have done necessary corrections. So I will be disposed of, my lord, with that observations.
The learned the petition deserves to succeed. However, this court on 2/12/2025 had passed the following order. The learned AGA submits that pursuant to the order, the software has been corrected, and henceforth the problem that is now projected would not arise. After the problem would be that whether the limitation under section 23 in such cases. In that the effort in that light as well, recording the said submission, the petition deserves to be allowed.
Basic one clarification. My lords, in fact, revenue authorities, my lord, assistant commissioner, he has rejected the same application on the ground that it's not a compromise decree. That may be observed, my lord. Those endorsement may be set aside. Annexure FG.
ಅದು challenge ಮಾಡಿದ್ದೀರಾ?
ಅದನ್ನು challenge ಮಾಡಿದ್ದೀನಿ. Annexure FG.
The learned, the other circumstance that that is sans countenance is the order of the assistant commissioner. The assistant commissioner refuses in change.
Annexure F, my lord, page 34. He says that, my lord, it's not a compromise decree.
Change of what?
My lord, entering my name in the revenue records.
The assistant commissioner rejects the claim of this petitioner for entry of the entry of his name in the revenue records on account of the sale, on account of his auction purchase in the court sale, courts on the score that it is not a compromise decree. The assistant commissioner appears to be blissfully ignorant of law. Therefore, they said it need not be a compromise decree alone that can be registered, can be directed to be registered, or the change of revenue entries. Even a court sale is a valid sale in the eye of law. In that light, the petition, the order, the impugned endorsement of the assistant commissioner is rendered unsustainable. For all the reasons, the petition is allowed, quashed.
Also that of Tahsildar, my lord, Annexure G.
All orders quashed.
Please, my lord, oblige.
ಇನ್ನೇನು ರಿಲೀಫ್ ಕೇಳಿದ್ದೀರಾ?
ಇಲ್ಲ ಅಷ್ಟೇ.
ಇಲ್ಲ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಏನ್ ಮಾಡ್ಬೇಕು?
ಇಲ್ಲ ಮಾಡ್ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
ಮಾಡ್ತೀರಾ?
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದೆ, ಮುಟೇಶನ್ ಆಗಿದೆ.
ಸರಿ. ಇನ್ನೇನು ಎಲ್ಲ ಆಯ್ತಲ್ಲ?
36 GB Nayak.
ಅಲ್ಲ, ಕೋರ್ಟ್ ಸೇಲ್ ಅಂತ ಕೋರ್ಟಲ್ಲೇ ಎಲ್ಲ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಅದು ಮಾಡ್ಬೋಣ ಅಂತ ಅಷ್ಟೇ. 30?
Your Lordship, this is regarding my grandmother's death certificate.
ಕೊಟ್ಟಿಲ್ವಾ?
She died on 29/4/1977.
77.
I have attached the death certificate, Your Lordship.
ಇದೆಯಲ್ಲ, ಯಾಕೆ ಬೇಕು ಮತ್ತೆ?
Respondent number 1 wrongfully applied for a new death certificate on the date 8/4/2006.
ಅದ್ರ ನೇಮ್ ಬೇರೆ ಇದೆಯಾ?
ಇಲ್ಲ, name same is, Your Lordship. Place and date of death is wrong. So
ಎಲ್ಲಿ ಸೌದತ್ತಿ? ಮುಳ್ಳು ಇರ್ಲಿ ಬಿಡಿ.
Mugli Hall village. And the date is also wrong. Later they made an
ಸುಮ್ಮನೆ ಇರ್ಬೇಕಾಗಿತ್ತು, ಯಾಕೆ ಅಪ್ಲೈ ಮಾಡಿದ್ರಿ?
unregistered will ಮಾಡಿದ್ರು, Your Lordship. ಆಮೇಲೆ ಅದನ್ನ the property is sold to the third party.
ಈಗ ಯಾವ ಕರೆಕ್ಟ್ ಮಾಡ್ತೀರಾ ಸರ್?
Kindly see, this is based on the order passed by the competent court.
ಏನು ಪರ್ಸೆಂಟ್ ಡೆತ್ಸ್?
Criminal miscellaneous.
ಅಲ್ಲೇ ಕೇಳಿ ಕರೆಕ್ಷನ್.
Criminal miscellaneous ಎಲ್ಲ ಅಕೌಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಒಳ್ಳೆ ಕರೆಕ್ಷನ್ ದೇರ್ ಓನ್ಲಿ.
And that is a ಲೋಕ್ ಅದಾಲತ್ compromise.
ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗ.
Prayer.
We were never served any notice, Your Lordship.
Annexure F is, my lords, the compromise in lok adalat in criminal miscellaneous number 299 of 17.
ಆಯ್ತು, 9th ಹಾಕೋಣ. List on 9th fresh matters. Next.
37.
Obliged.
Notice ಆಗಿದೆ ಇಲ್ಲ ಅಲ್ಲ? 36 learned AGA is directed to accept notice for the respondents. List on 9th fresh matters. Next.
37.
My lord, serial number 37.
Yes.
It is covered by the judgment in Karnataka Chinmaya Seva Trust, my lords.
Chinmaya Seva Trust. M. Tirmalesh and Rupa accepts notice. Tirmalesh alva? Madam.
Yes, my lord. Baluli, it is Shivraj Baloli, my lords.
Error?
Shivraj Baloli.
Baloli. Learned Counsel Shivraj Baloli is directed to accept notice for the respondents, Chinmaya Seva Trust. Yes, next.
Grateful.
38. Sharna Basrasi.
For petitioner. The issue is squarely covered by the.
Squarely? ಕೊಡಿ ಅವ್ರಿಗೆ.
Reported judgment.
ಇದರಲ್ಲಿ instead of giving the opportunity to rectify the mistakes, my lord, she has not, my lord, rectified the mistakes.
ಅಲ್ಲ, ಏನು ಸ್ಕ್ವೇರ್ಲಿ ಕವರ್ಡ್?
Loaded.
ಅಲ್ಲ, ಅದೇ ತಮ್ಮನೇ
Anganwadi
ಜಡ್ಜ್ಮೆಂಟ್
worker.
ಅಂದ?
wherein, my lord,
Anganwadi worker.
opportunities ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
Not
Payment
approved.
cannot be denied on curable defects.
Curable defects. To err is human.
Human.
Moreover, my lord,
ಇದು ಬೆಂಗಳೂರಲ್ಲಿ ಬರ್ದಿದ್ದು. ಕರೆಕ್ಟ್.
Yes.
ಎಸ್ ಹೌದು.
as per annexure D, my lord,
The department has, my lord,
ರಾಜ್ಕುಮಾರ್ ಗಿಜೋರಿ ಫಾಲೋ ಮಾಡಿಲ್ವಾ?
yes, ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಮಿಸ್ಟೇಕ್ಸ್ ಇದ್ರೆ ಲೆಟ್ ದಮ್ ರೆಕ್ಟಿಫೈ ಅಂತ ಅಪರ್ಚುನಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
But in
ಇಲ್ಲ,
this
annexure
case,
D
your
is
lordship,
incomplete
she has
applications.
uploaded and completed the process, your lordship.
ಈಗ ಯಾರು ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ? ಇವರೇ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರ? ಅಂಗನವಾಡಿ ತಾನೇ ಇದು?
ಹೌದು ಹೌದು.
ಯಾರು ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ?
ಸೈಬರ್ ಕೆಫೆ.
ಸೈಬರ್ ಕಫೆ. ಅವ್ರ ಮನೇಲಿ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ರೆ ಅವ್ ಏನೇನೋ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲಿ ನಂಬರ್.
This is the responsibility of the persons who has.
The only mistake is that, my lordship,
ಅವ್ನಿಗೆ ಎಲ್ಲಾ ಅಂಗನವಾಡಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅಪ್ಲೋಡ್ ಮಾಡಕ್ ಕೊಟ್ಬಿಟ್ರೆ ಒಂದೊಂದ್ ಕಡೆ ಇದ್ದೇ ಇರುತ್ತೆ.
ಈ ಪರ್ಸನಲಿ he has uploaded, my lord, in the.
ನೀವು ಪರ್ಸನಲಿ?
ಹೌದು ಹೌದು, ಅವರೇ ಮಾಡಿರೋದು. ಸೈಬರ್ ಕೆಫೆ ಪರ್ಸನಲಿ ಸೈಬರ್ ಕೆಫೆಗೆ ಹೋಗಿ, ಅಂದ್ರೆ ಪ್ರೈವೇಟ್ ಸೈಬರ್ ಕೆಫೆ, ನಾಟ್ ಮೈ ಲಾರ್ಡ್ ಬಿಲಾಂಗ್ಸ್ ಟು.
ಸರ್ಟಿಫಿಕೇಟ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಂಗನವಾಡಿ ಆಗ್ಬೇಕು ಮತ್ತೆ.
ಸೈಬರ್ ಕೆಫೆ ನಮ್ಮದಿಲ್ಲ.
ಪ್ರೈವೇಟ್ ಸೈಬರ್ ಕೆಫೆ ಅಂತ ಇದ್ದಾರೆ.
ಅಂದ್ರೆ
ಸೈಬರ್ ಕೆಫೆ ಗವರ್ಮೆಂಟ್ ಇನ್ನು ಶುರು ಮಾಡಿಲ್ಲ ಸರ್. ಪಬ್ಲಿಕ್ ಎಸ್.
Meanwhile, my lord, she has got married, my lord. She is residing, my lord.
ಮದುವೆ ಆಗಿದೆಯಾ?
ಮದುವೆ ಆಗಿದೆ. Thereafter, my lord, before.
No, my lord.
ಇದೆ ಸರ್ಟಿಫಿಕೇಟ್ is there.
ನಿಮ್ಗಲ್ಲ ಸರ್.
Client.
ಯಾಕೆ ಗಾಬರಿ ಆಗ್ಬಿಟ್ರಿ?
Already 810 final order was issued, your lordship, and appointment letter was also issued.
ಯಾವಾಗ? 810?
810/25.
ಮೊನ್ನೆ ಆಗಿರೋದು. ಎಸ್ ರಾಜಶೇಖರ್, ಮೆರಿಟ್ ಯಾರ್ದು ಮೇಡಮ್?
That is also protected by interim order. In spite of, my lord,
ಮೆರಿಟ್ ಯಾರ್ದು?
Petitioner.
merit none. ಅಲ್ಲ, merit, my lord, petitioner is more than meritorious. She will get anywhere, my lord, and compared to, my lord.
ವಿಡೋ ಅಲ್ಲ ತಾನೆ ಯಾರು?
No, there are no widows.
ಫಿಸಿಕಲಿ ಡಿಸೇಬಲ್ಡ್ ಅಲ್ಲ ತಾನೆ ಯಾರು?
ಇಲ್ಲ, both are not.
ಅವರು ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ 230
ಪ್ಲೀಸ್.
ಸಾಕು, ಬೆಲ್ ಮಾಡಿ. ಎಷ್ಟಿದೆ ಮೇಡಮ್ ಇದು? ಕಮ್ಮಿ ಇದೆಯಲ್ಲ, ಇಟ್ಟು ಅಷ್ಟೇ.
Serial 82, I appear for the respondent. May I request it on 10th? 10th.
ಯಾರಲ್ಲಿ ಟೈಮ್ ಬೇಕು?
ಆಮೇಲೆ 110, this matter pertains.
ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ದು ಬಂದ್ರೆ ಯಾರು?
ಇಲ್ಲ, ನಾನು already have informed the petitioner counsel. 110, this matter pertains to disqualification of the members. ಹೇಳಿದ್ದೀನಿ. So
ಬಾರ್ ಕೌನ್ಸಿಲ್
ಇಲ್ಲ, this is a disqualification.
ಯಾವುದೋ ಶೀಲ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ 230 ಬೇಕು. ಬೆಳಗಾಂ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಏನದು?
ಹೌದು.
ಅಲ್ಲ, ಮೆನ್ಷನ್ ಮಾಡಿದ್ದು ಅದೇ ಅಲ್ವಾ?
May I request, my lord, 110 on Monday in the fresh matter list.
Monday in the only fresh matters.
ಯಾಕಂತಂದ್ರೆ your lordships on previous occasion directed, my lord, to post this matter in the fresh matter list. Therefore, my lord, it has come up in the BIM.
114 also, my lord, it's a covered matter. Regularization.
Monday ಹಾಕೋಣ.
Monday, please.
114 also, teachers regularization. Teachers covered matter, teachers regularization, covered by lordships matter.
Monday
ಈ
fresh.
ಗ್ರೂಪಲ್ಲಿ ಬಂದಿದೆ.
Monday fresh matter.
Monday 114.
ಮಧ್ಯಾಹ್ನ ಮುಗಿಸ್ತೀನಿ. ಯಾಕೆ? ಏನ್ ಪರವಲ್ಲ? ಸಂಜೆಡ್ಡ ಗೊತ್ತಾಯ್ತು? ಅಲ್ಲ, ಸಂಜೆಡ್ಡ ಯಾವುದು? ನೀವಾ ಬರ್ಲೇ ಇಲ್ಲ ವಾಪಸ್ಸು?
Before my lord incident, he had gone, my lord. Thereafter, he is there only.
ಈಗ ವಾಪಸ್ ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ.
ಬಿಡಿ, ವಾಪಸ್ ಬರಕ್ ಆಗಲ್ಲ. ಅಕ್ಯೂಸ್ಡ್.
Monday.
I will reject it.
Monday.
If you don't come back ಅಂದ್ರೆ ಪಾಸ್ಪೋರ್ಟ್ ಇಂಪೌಂಡ್ ಮಾಡಿ.
Come back ಅಂತಲ್ಲ, ಬರ್ತೀನಿ ನಾನು my lord.
ಇಲ್ಲ, ಪಾಸ್ಪೋರ್ಟ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದೆ ಏನು?
30 ವರೆಗಿದೆ.
13/12 ಇದೆಯಾ? ಇಂಪೌಂಡ್ ದ ಪಾಸ್ಪೋರ್ಟ್ ಅಂಡ್ ಇನ್ಫಾರ್ಮ್ ದಿ ಅಥಾರಿಟೀಸ್ ದೇರ್. ರೆಡ್ ಕಾರ್ನರ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಸೋಣ. ಬರ್ತೀರಾ ಅವಾಗ ವಾಪಸ್? ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಏನ್ ಎಲ್ಲೂ ಹೋಗಲ್ಲ, ವಾಪಸ್ ಬರ್ಲೇಬೇಕು. ರೆಡ್ ಕಾರ್ನರ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಒಂದು ನೋಟಿಸ್ ಹೋದ್ರೆ ಸಾಕು, ಅವರೇ ಕಳಿಸ್ತಾರೆ ಅಲ್ಲಿ. ಎಸ್, ಅದನ್ನ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಬೇರೆ ಇನ್ಯಾವ್ದಾರು ಇದ್ರೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕೊಳ್ಳಿ.
Serial number 66, Lordship.
Huh.
Last occasion, Lordship directed to me, take notice, Lordship, in respect of 2 to 6, Lordship. 6 is private party, Lordship. Notice has to go, Lordship.
ಅದು ಊಟ ಆದ್ಮೇಲೆ ಮಾಡ್ಬೋದಲ್ವಾ?
Please, Lordship.
Adjournment if
Adjournment.
Great.
But if the other side comes and objects, I will take it.
Only
ಅದು ಗೊತ್ತಿಲ್ಲ. General term.
Only government.
General term. Yes.
ಗೌರ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ
Hello, court officer, can you hear us? Hello? Hello, sir, can you hear us?
Yes, sir.
Okay, thank you, ma'am.
Serial number 59 here. Taken next week.
You want to withdraw?
No, no. For respond today, I filed a call.
Wait. Yes. Call the case. Shilwant, Bar Association ಯಾವ್ದು? 53 ಮುಗಿದ ತಕ್ಷಣ ತಗೊಂತೀನಿ. ಇನ್ನೊಂದು 10 matters. Damage over declaring orders. ಆಯ್ತು ಆಮೇಲೆ ನೋಡಿ. Yes. PP sir.
Please,
Please, those second list matters.
please, that's also bar association, because your lordship is
Bar
called
association. Alwala.
second list, the two matters. One is KBJNL matter. sir.
KBJNL
Yes, please. That there, my lords, it appears that they are seeking time, but we oppose it for this reason, my lord. It's covered by the constitutional bench decision. The beneficiary, my lords, is required to made a party. That KBJNL, my lords, Karnataka. Please, Krishna Bhagyan. That is, it implements, my lords, entire upper project, my lords, Krishna upper project, my lords.
As far as KNNL is concerned, Niravari Nigam is concerned, the what are we telling? Niravari Nigam is concerned.
Please.
They say they are the beneficiaries. KBJNL adre, they are not the beneficiaries.
My lord, may I submit, my lords, this aspect.
So if they are not the beneficiaries, then why should we made the party neither necessary nor proper party?
May I submit it?
That's the contention.
I will answer it.
In case in KBJNL.
Please, I will submit straight away like this, my lords. The government of Karnataka formed a company called, my lords, KBJNL. And that purpose itself is to acquire the land, to my lords, develop this Krishna Bhagya Yojana, my lords. And they sent the proposal to the government. These lands are required for us for channel and irrigation. And the government in turn acquires it and hands over the property to us. And we ourselves pay the amounts.
ಯಾರಿಗೆ compensation ಕೊಡೋದು ನೀವಾ?
We give the
You have distributed compensation.
Yes. And that's mentioned in every award.
Yes.
Every award it is
1 minute.
Please.
Now Anil Kale ನೀವು ಹೇಳಿದ್ರಿ they are not necessary party. ಆಯ್ತಾ? ನಿಮಗೆ compensation ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ. ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಒಟ್ಟು compensation ಬಂದಿದೆ. Enhance ಮಾಡಿದ್ರೆ ಯಾರು ಕೊಡೋದು?
Lord, enhance. Lord, this is
ಯಾರು ಕೊಡ್ತಾರೆ? ಗವರ್ಮೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನಿಮ್ಗೆ?
government, my lord.
Normal.
My lord, this is the government land acquisition officer appointed by the government. My lord, KBJ and my lord, it is the 4-1, the 11-1. These are, my lord, my lord, lands acquired under the, my lord, NIM Act. 11-1, there is a notification. 19-1, there is a declaration. In the declaration and the preliminary notification and final notification, there is clearly stated the purpose of acquisition. These lands are acquired, my lord, for the purpose of, my lord, raising of a dam height.
ಆಯ್ತು. They are not on the purpose of acquisition. See, if the government has acquired and given it to KBJNL for the purpose of construction of a dam or whatever it is.
Enter project of the Krishna Bhagya Jalanagam.
Yes.
The implementation of the Krishna Award 3
Correct.
is on the KBJNL. Enter implementation agency beneficiary is KBJNL only.
ಮತ್ತೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡದೆ
It is KBJNL only.
ಆಯ್ತು. ಈಗ compensation is determined at huge amounts. Now who is going to pay that?
It is going to be paid by the state government, paid to the
KBJNL will pay.
Yes.
Will pay to the beneficiary in turn pay to the land acquisition officer, land acquisition in turn pay to the land losers.
If you are agreeable, all of you, I will set aside the order, remit the matter back to hear them and pass orders within a time frame.
Please.
That would serve the interest.
ಏನ್ compensation ನೀವು ತಗೊಂಡಿದ್ದೀರಾ, ಅಕಸ್ಮಾತ್ ಡಿಸ್ಪರ್ಸ್ ಆಗಿ ನಿಮ್ ಕೈಯಲ್ಲಿ ಇದ್ರೆ ಅದು ಹಂಗೆ ಇರುತ್ತೆ. We will not direct recovery. ಆಮೇಲೆ set off ಎಲ್ಲ will do it.
Please, my lords.
That is the best way to do this.
One var, my lord, I will convince your lordship. This is not the, my lord, KBJNL is not the beneficiary. It is not the person interest, my lord. They are not the person interested under the act. My lord, it is defined in, my lord.
ಹೇಳಿ. No, you tell me. No, sorry, I interrupt ಮಾಡಿದೆ ಹೇಳಿ.
ಇಲ್ಲ. ಒಂದು objection ಆಗ್ತದೆ.
No. What my thing is, now ultimately the person who has to pay compensation to you which is whatever amounts it is not heard in the matter and compensation enhanced tenfold, 20-fold. Is that possible?
My lord,
Basic,
My
I
lord,
think
may
it's
I make
too.
one
in
submission,
my
my lord?
case,
1 minute, madam. I'll come back to you. Wait.
in my case, my lord, the compensation is not enhanced, my lord, 20 times. Maybe the land acquisition, determination of the land acquisition, my lord, it is maybe at a lesser side.
ನಿಮ್ದು ಅಂತಲ್ಲ.
But whatever
Generally,
the, whatever the,
ಆಗಿರೋದೆಲ್ಲ ಹಾಗೆ ಇದೆ.
whatever the reference code
100 times
enhanced now,
agidide. 100 times agidide.
Whatever-
There's lot
whatever
of
the-
fraud. Government has now decided to form a SIT also, my lord. Several persons are
let
involved
it
at
be,
several
my lord,
stages.
my lord, whatever the, in my case, whatever the compensation determined by the reference code, it is below the, my lord, price fixed by the government itself. For the said purpose, the government has fixed 40 lakhs. In my case, it is fixed only 36 lakhs.
All right, then why are you worried?
My lord,
It can't go below that at all.
now, my lord, what, in this case, what had happened is, now already award is passed. Now reference is filed. Reference is filed, matter is referred to the appropriate authority. My lord, may I request, my lord, kindly, for section 23 of the new act, what it says? Section 23.
Could you? No, but you tell me, division bench has already considered this.
My lord,
Justice Alokara there.
No, my lord, in fact, Constitution bench considers long back, my lord.
My lord, it is no
Ananತರ
doubt,
ಹೌದು,
it is
division
no
bench
doubt,
ಇದೆ.
my lord, I will agree, my lord, it is a beneficiary. If it is a beneficiary, my lord, it is a personal interested, my lord, there are judgments of the apex court and it has to be, my lord, heard. My lord, my case is simple, my lord. KBJNL cannot be, my lord, considered as a, my lord, beneficiary, first aspect. Because the new act, the lands are acquired under the new act.
All right.
Procedure has been prescribed.
All right.
My lord, before the land acquisition officer, every interested person should be heard and notice should be.
Correct. Now,
And
before,
then thereafter,
before the SLAO they are heard.
there SLO, my lord,
ಅವ್ರದೇ SLAO ತಾನೆ?
my lord, thereafter, after SLO, the reference would be, my lord, filed by the landowner.
Correct.
The reference is, my lord, only it is a, my lord, indicative value. It is an objection to the award passed by the, my lord, land action officer.
1 minute.
Thereafter, what happens, my lord? After reference, LO has to refer it, my lord, to the, my lord, appropriate authority.
Now it is referred to the appropriate authority.
Yes, my lord. It is referred to appropriate authority. Appropriate authority has determined the compensation.
ಎಷ್ಟು?
Now, my lord,
ಈಗ for
36 lakhs.
illustration ಹೆಗ್ಡೆ ಸರ್ ಎಷ್ಟಿದೆ ಯಾವ್ದಾರ ಒಂದು ಹೇಳಿ
36 lakhs, my lord, ಇದರಲ್ಲಿ.
ಅಲ್ಲ ಇವ್ರದಲ್ಲ ಅನಿಲ್ ಕಾಳೆ ಅವ್ರದಲ್ಲ ಬೇರೆ.
Please, now, my lord, I have a table, my lords, where the SLO award per acre is 2 lakhs. Enhanced amount is 36 lakhs. I have a table itself, my lord. So this speaks in volumes. Speaks in volumes.
Should they not be heard in the matter?
My lord, it is true, my lord.
But do not they have a right
First,
to contest?
first, my lord, they have to establish. Yes, my lord, it is true. If it is a beneficiary, my lord, that is what, my lord, I am trying to canvass. May I request, my lord, the
So,
64.
I will
64
only.
and 65.
Huh?
Please.
ಏನ್ ಹೇಳಿ?
Sorry, my lord.
ಅಲ್ಲ, ಪರವಾಗಿಲ್ಲ.
Sorry, my lord.
No. No, what I was thinking was, send the matters back.
Yes, my lord.
Fix a time limit. In 3 months, the court will hear, or ಯಾರ ಮುಂದೆ ಇದು? Reference court ಅಲ್ವಾ? Reference court will hear all the parties and pass orders. If compensation is already received by you, it will remain with you, subject to the outcome of those things. And if compensation is determined at a particular value, if it is really gross, contrary to law, then definitely appropriate orders will be passed.
True, my lord.
ಅದು KBJNL.
Yes, my lord.
KNN ಅಲ್ಲಿ they are the beneficiaries.
Yes, my lord. That, my lord, I am.
ನೀರಾವರಿ ನಿಗಮ
Other
ಕೇಳಲೇಬೇಕಾ?
But what is, my lord, my point is, my lord, now KBJN, after passing of the award by the LAO, they have, my lord, satisfied the award. Thereafter, my lord, reference court amount, in some of the cases, not in these cases, some of the cases, reference court determines the compensation, and appeals are filed by the government as well as the claimants before the High Court. And in those appeals, there is a direction by the division bench. MFLA. Direction by the division bench to pay the 50%. They have no objection, they pay the 50%.
50% is with you, no problem. You keep it. Now, the other 50%, it will be determined and it will be set off, reduced or whatever it is. But they should be heard in the matter.
True, my lord.
If the tomorrow the court comes to the same conclusion of the same, then it is up to all of you to avail of such remedy.
Yes, my lord.
But it can't be that without hearing, they are mulcted. They're not mulcted, but you have given up your lands. It's not mulcting actually. But they should be heard for a determination of compensation.
True, my lord. Now, the land acquisition, my lord, the person, the agriculturist and the land loser, he should not be made sufferer, because the law, my lord, 64, section 64, for a moment, one minute. What it says, my lord, 65, 64 and 65. May I request?
Yes. No, land loser should not be, suffer prejudice, not put his rights into
What is the
jeopardy,
duty?
all that fine.
Yes, what is the duty cost on the, my lord, officer immediately after filing of the, my lord, reference?
Reference to authority.
Yes, authority admale, 64, my lord, he refers it to the authority. 65, collector statement to the authority. May I read, my lord? In making the reference, the collector shall state for the information of the authority in writing under his hand the situation and the extent of the land with particulars of any trees, buildings or standing crops thereon. B, the names of the persons who has reason to think interested in such land. He must disclose the names. Then the amount awarded for the damage in so and so, the amount deposited, the if the objections. B, my lord, it is the names of the person should be, my lord, disclosed. It is, my lord, what the landowner will do, he will only object by filing a reference.
Is nimde KBJNL. Division bench judgment by KBJNL remitting the matter back and directing a particular action to be taken within a time frame.
While
The division bench judgment.
sir, now implementing the award to
One objection, one date fix ಮಾಡಿ.
Martini, but
In all these,
we will take your submissions as your objections.
My lord, I'll make one submission. My lord,
And
may
in
kindly see
submissions
the
or
page
objections
number
and then
20. Allah, my submissions will kindly, my lord, see the page number 25 of the writ petition. The special land acquisition Upper Krishna project is made as a party to the proceedings, my lord. The Upper Krishna project is a subordinate body of the KBJNL, my lord. They are working together, my lord. They cannot seek at this stage
Madam,
for the remanding.
I'm really,
filed my-
1 minute. I'm really surprised. If they have to be heard and order is passed, why all of you are fighting shy? So it is it a presumption that it is increased tenfold without?
No, my lord,
without any
I'll make
foundation? Why are you worried?
On
3
that-
months, 50, 1 minute, madam. MFA quarterly 50% is already directed to be deposited. You have the 50% with you, or it is deposited, withdrawn, or court will
Not
calculate.
all the matters, my lord. Not all the matters, my lord. Only
True,
few-
madam.
few
No, what
matters,
I'm
my lord.
telling is, see,
Yes, my lord.
50% if you have it. Otherwise, I'll fix 3 months' time. By then, the court will decide everything in accordance with law and all your rights are protected. I'm not saying recover the amount now.
No, my lord. The thing is that, my lord, the where the
No,
trial.
I need to follow, madam. There is a division bench judgment. How are you saying you are not the beneficiary?
I'll
There is
file my
in
detail
the
objection.
KBJNL, what objections you will file against the division bench judgment?
One opportunity will be given, my lord, because the person who has appeared before the first
Madam,
respondent.
if after a week I am going to pass the same order, today also I will pass the same.
No, my lord, I'll make a
Your
submission.
submissions
my lord.
will be objections. ನೀವೇನು beneficiary ಅಲ್ಲ ಅಂತನಾ? 1 minute, madam. You are saying KBJNL is not the beneficiary?
My lord, one submission permit me to allow, my lord. My lord, page number 25, kindly see the page number 25, my lord. The special land acquisition officer, Upper Krishna project.
ಆಯ್ತು,
The
UKP,
advocate-
madam.
Yes, my
SLAO
lord.
UKP is a party in the proceedings. We will
Yes,
take
my
it
lord.
that way itself.
Yes,
Even
my lord.
then, it is not
Yes,
the UKP or SLAO who is disbursing compensation, it is KBJNL.
My lord, the UKP Upper Krishna project works.
Madam,
the
Upper Krishna
subordinate-
project is a project, madam.
My lord, they work under the KBJNL only. My lords, I'll file my detailed objections, then my lords may be kind.
Whatever
My lords,
detailed
one
objections you may run into 100 pages, I cannot overcome the division bench
No,
judgment.
my lord, one opportunities may be given, my lord.
Last
One.
time also, my lord, your lordship specifically said, I'm going to take it up for
No, my
disposal,
lord.
my lord.
This is the
Your lordship
first time
accommodated
the
each one of them.
for me
And these
because my-
technical
I
notes, they have been
filed
dragging on, and at the other side, my lords, they want to pressurize. What they're doing it, my lords. And your lords may kindly take judicial notes. There are vast reports in the papers also that lot of fraud is there. And your
No, that the court will consider
Please.
and pass. I am
And
not
that's
going to
why-
enter. I am
Please.
not going to enter into that arena at all. Now the thing is, I'm only on PONJ.
Please, my lord.
Principles of natural justice have been violated in not hearing the beneficiary and Theltala. We will not define him to be the beneficiary. Also, he is the one who is going to make the payment. Is not heard, and the payment it is increased tenfold. Then how do you sustain, sir?
My lord,
In
I'll
some
make
cases, 100 times.
one opportunities may be
ಇವಾಗ
given.
ಸ್ಟಾರ್ಟ್ ಆಗಿರೋದು ನಾವು ಅಲ್ಲ
ಇಲ್ಲ,
2025 94 ಇಂದ ಇಲ್ಲಿವರೆಗೂ
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
ಹೌದು
My lord,
sir.
this project is,
Ah,
my lord,
1 minute.
I'll make a submission.
Madam,
This
1 ನಿಮಿಷ.
project-
I time ಕೊಡ್ತೀನಿ. Wait, madam. Yes. ಅಲ್ಟಿಮೇಟ್ಲಿ ಈಗ ಸ್ಟಾರ್ಟ್ ಆಗಿರೋದು ಈಗ ಅಂದ್ರೆ ಇಂಥದ್ದೆಲ್ಲ ಶುರು ಆಗಿರೋದು ಈಗ. ಇಲ್ಲಿವರೆಗೂ ಎವ್ರಿಥಿಂಗ್ ವಾಸ್ ಫೈನ್.
Please, ಗೊತ್ತಾಗಿದ್ದು.
10-fold, 20-fold. See, land value was not this much because the land value is high and the compensation is high. Now all these things have started. 10-fold,
In
20-fold.
Bagalkot city, 22 crore rupees per acre is awarded.
Per acre.
23 crores. In the
But my lord,
remote
how it
place,
custom, I'll
remote
explain, my
place,
lord.
9 crores have been
ಒಂದ್
allotted.
ನಿಮಿಷ. ದೇವನಹಳ್ಳಿಲೂ ಇಲ್ಲ ಅಷ್ಟು. Wait.
22 crore rupees Bagalkot city, in remote village, 7 to 8 crore rupees. 5,000 rupees per square feet. All the lands have considered as a NA potentiality.
And that's why, my lord, they
And
object
all
to
are
remand.
relying upon one judgment. And
It's
my lord,
natural to
My
object.
lord, my lord, I'll make a submission. Serial
This is
ಆ
why
case-
I
ಆ
told
case
you,
challenge
I'm
ಮಾಡ್ಲಿ.
surprised
No,
that you're all
my lord.
fighting shy.
Aಲ್ಲ, everybody will object.
I'll make a
One-
submission.
and
on that.
challenge those
They
cases.
will
Search
In
for
serial
reasons to
number
get
2, my
somehow
lord.
it's adjourned.
No, no.
No, my lord, in serial number 2, my lord, they have
It is
awarded.
happening everywhere.
as per
There are
their
some-
contention,
also
my
take
lord,
Don't worry, the buck stops here, I say. Yes.
My lord, as in serial number 2, as per their contention, award is around 6 crores, my lord. My lords may, if the, my lords may come to
One
your,
more, please, my lords.
details of
In some cases,
paragraph, my
there was
lord,
remand.
the award
There
is
was one
passed
aspect.
for the 183
After remand,
rupees per square feet, my lord.
After remand, the
183
reference
rupees
court
per
finds
square
that
feet.
earlier order is bad, confirms the land acquisition orders. We have about 66 cases where it has happened so. 66 cases which were remanded, my lord, earlier pursuant to the earlier orders. On all those cases, 10-fold, 20-fold, 30-fold increase. After remand, we participate, we produce evidence, we cross-examine. Then the reference court says land acquisition order is very much correct.
It is.
Award is correct. Therefore,
My
their
lord,
apprehension is correct.
My lord, I'll make a
So,
submission.
ಎಲ್ಲ
now,
cases
I-
that cannot be
I
made
have the
applicable.
statistics.
Regarding the quantum, my lord, regarding the
Madam,
quantum,
ನೀವು
I'll
ಇಲ್ಲಿ
make a
ಬಂದ್
submission.
ಮಾತಾಡಿ ಇಲ್ಲ ವಿ.ಸಿ.ಲಿ ಸುಮ್ಮನೆ ಇರಿ ಸ್ವಲ್ಪ.
ಅಲ್ಲ, ಒಂದು
I will
opportunity.
ask you, wait.
Yes.
So now, if by a remand, lot of skeletons are going to come out of the cupboard, we will do it.
ಇಲ್ಲ ನಮ್
Right.
ಕೇಸಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ಈ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ನಾವು.
ಅಲ್ಲ ನೀವು ಮಾಡಿ, ನಾನಿಲ್ಲ, I will not assess NA
Because
potential
it
ಎಷ್ಟು
was-
ಇದೆಷ್ಟು ಅದೆಷ್ಟು ಎಲ್ಲ.
In these
Take the
cases,
reference, ಈಗ ನಿಮ್ ಕೇಸಲ್ಲಿ 36 lakhs ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ, it will ಜಾಸ್ತಿ ಆಗ್ಬೋದು.
Yes.
It may be beneficial to you.
that
And
may
then
be there, my lord.
why are you fighting share of a benefit
It
that
will,
may be
my lord, it
conferred
will
upon
open,
you?
my lord, what happens, my lord, there are thousands of judgments. On this ground, madam, everything will go, my lord, now.
Sir,
The
there may
poor
be-
genuine,
one ನಿಮಿಷ.
what happens, my lord, before the reference court, the cases where, my lord, the land acquisition officer is a party, my lord, UKP, my lord, authorities are a party, deputy commissioner is a party. While sending a reference, it is a duty casted on the land acquisition officer to report the person who is the beneficiary, who is the person interested. That is the, my lord, statute. My lord, those documents are not produced here.
No, I'm not saying I'm going to decide it now. I will give you opportunity to whatever you want to do. I'll fix a date. On that day, whatever, no adjournment on that day.
Yes, my
You
lord.
file your objections, whoever wants to file their objections, let them file. But you are telling that they need not be heard. It's a little difficult to digest.
But if he has a right, my lord, if money is paid by him,
The money is paid by him, he has to be heard,
government,
he
it
has
is
to
the
be heard.
government, it is an agency.
Well,
only,
let us
my lord,
not, I'll conclude now. It's on this objection, my lord. Last second, in every award, last sentence, in every award.
KBJNL should pay.
ಹೌದು, in every award it is so. Every award. My blood
They
friend
are
probably did
directed
not
to
see.
pay. Should they not be heard in as rudimentary as that,
beneficiary,
sir?
every,
Yes.
it is the, my lord, agency created by the government for
Company,
disturbance.
company.
My lord,
Company.
Company.
My lord, it is the company.
It's a
Company
company,
or agency, my
it
lord.
may be a company, a statutory
Yeah, my lord,
body,
under the new
or
act.
whoever it is,
And-
but should they not be heard?
My lord,
Somebody from whose coffers amount is coming to you, should that coffer be heard or not?
my lord, in some of the similar instances, wherein, my lord, in company, the KIDB matter, which was heard by, my lord, the Honorable Apex Court in a Pirappa Harijan's case, what had happened there was, my lord, the company had filed up, my lord, approached the Apex Court with a similar contention.
The purchaser
that we
company in
have-
that case. Purchaser approached.
ಅವ್ರು ಹೇಳ್ತಾರೆ ತಾಳಿ. ಹಾ. ಅನಿಲ್ ಹೇಳಿ.
My lord, it was the company, it says, my lord, it approaches, he was the allottee. There is a difference between the beneficiary and the allottee.
Because
That-
division
the-
bench ಅಲ್ಲಿ ಏನು,
that-
it's only a 2-page order. But if you have some Supreme Court judgment, you tell me, I will consider everything. I will consider and pass orders. See, at Anil Kale ಅವರೇ,
ಹೌದು, ಹೌದು, ಹೌದು,
at any cost, at
But
any
it has
cost, a land loser should not be put to jeopardy. That is the concern of the court as well. Land losers, ಯಾಕಂದ್ರೆ ಇವರಿಗೆ ಸ್ವಲ್ಪ ಕೊಟ್ರೆ ಆಮೇಲೆ ಮುಗಿಸ್ಬಿಡ್ತಾರೆ. ಅದು ನೋಡ್ಕೋಬೇಕು. Well, we'll balance it.
Yes,
All right. Yes.
No, my lord,
See,
that's
my lord, I'll try to persuade if it is only a statute is clear, because everything under the new act, beneficiary is defined, my lord, defined, everything is defined. My lord, I will narrate those things, my lords, and one opportunity.
I'm not telling, I'm only telling, see, but if it's too rudimentary to say, if somebody has to pay, they have to be heard and trusted.
Yes.
Nothing else.
In fact, para 26 of that constitution bench with kind permission, my lords, para 26, my lord,
So we'll
clearly
dis-
lays down, my lords.
We'll decide it.
Please.
I'll fix it on 12th at 2:30.
And my lord,
By
the,
then you file your objection.
and aims and objects of the, my lord, while establishing the, my lord,
Yes, yes.
KB channel.
Yes.
That
That
has to
also
be, my
I
lord,
will produce
produced.
it.
Never says that
That-
they are the paying the amount.
ಅಲ್ಲ ಅವ್ರದ್ದು
ಇವ್ರು ಯಾಕೆ ಅದು ಬೇರೆ
ಆರ್ಡರ್
ಮಾಡಿದ್ರು
ಇದೆ
ಅವ್ರು ಕೊಡಕ್ಕೆ?
ಒಂದು ಇನ್ಕಾರ್ಪೊರೇಷನ್
ಅಲ್ಲ award ಅಲ್ಲಿ ಯಾಕೆ ಬೇಕಾಗಿತ್ತು?
My lord, let the
See,
government.
award ಅಲ್ಲಿ the person who is not a party is directed to pay the amount. That is the problem.
Between the euros, intersay between the government and the KBJ.
No, 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 no.
ಈಗ ಇನ್ಕಾರ್ಪೊರೇಷನ್ ಇಫ್ ದಿ if the government
my
as well
lord,
as the KBJNL, my lord, they my lord required to produce. Why this this idea has come up only, my lord, to delay the payment of the
No,
compensation. That is the thing. The
you can be rest assured, I
main
will
reason
balance
behind
the
it
rights
is, my
and
lord,
do it. No, you should not be put to jeopardy at all, because they are a big mighty thing. We'll see. ಏನಾಯ್ತು ಈಗ? ಏನು ಸುನಿಲ್ ದೇಸಾಯಿ ಏನು ಹೇಳಿದ್ರು?
There are many other beneficiaries.
ಸುನಿಲ್ ದೇಸಾಯಿ
beneficiaries ಅಲ್ಲ.
ಏನ್ ಸುನಿಲ್? What's it? ಹೇಳಿ.
Now your lordships also required to take note, Lord, the manner in which when they have approached this court, there are the appeals which has been filed by the state, which has been turned down by the division bench.
No
On the
appeal on
ground,
merit, it has been turned out only on the ground, I'll make it factually correct, only on the ground of delay, not on the merit, not on the merit.
ಆಯ್ತು, we'll see.
No, on merit you tell, not on the merit, factual incorrection.
Now, my lord, now by virtue of after, my lord, closing of the issue with regarding the determination of the amount is concerned, now this, my lord, the trigger up. I do agree that, my lord, I am not saying that, my lord, there are some instances where there may be a, my lord, the compensation may be in a higher side, or there may be, but that cannot be a ground, my lord, to reopen and reinstate all this. This is to be, and, my lord,
because the
there are
division bench judgment ಅಲ್ಲಿ
nothing has been said. My lord, in one of the case, my lord, where I have appeared for MML, my lord, Mysore Minerals Limited, undertaking of a, my lord, where we are not a parties to the other reference or before the MFA. My lord, there was an order which we have preferred appeal to the Supreme Court. Supreme Court says it is only determination of a compensation which we have to argue. Go before the authority where MFA it has been remanded. File in a review. If it is determinable, they will decide it. Now, by virtue of that, whether the rights of the, my lord, the losers is to be taken, larger aspect is to be taken note.
That is what, yes. We
May I amend?
My lord,
May
we
I-
have,
ಯಾವುದು?
not today, my lord.
ಅಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್
Yes,
ಇದೆಯಾ ಈ
yes.
ತರದ್ದು?
My lord,
No,
may I?
I am informed there are many matters where my learned friends or the claimants don't want to engage in advocate now. They are watching now. The moment the honorable court says we are going to dispose of, they will appear. No, the claimants, that's the claimants are watching.
May I know?
ಅರ್ಚನಾ ಮೇಡಮ್ ಇದೆಯಾ?
They will appear later. Claimants will appear later.
May I, my lord?
ನಿಮ್ದು ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ನ್ಯಾಷನಲ್ ಹೈವೇನಾ?
My lord, in serial number 2, my lord,
ನಾಟ್ ನೆಸರಿ ಪಾರ್ಟಿ. ಆಯ್ತು, ವಿಲ್ ಸಿ.
may I, my lord?
ಆಯ್ತು, ವಿಲ್ ಸಿ. ಆಯ್ತು, ವಿಲ್ ಫಿಕ್ಸ್ 12th ಅಷ್ಟ್ರಲ್ಲಿ ಹಾಕಿ. ಸುನಿಲ್ ದೇಸಾಯಿ ನಿಮ್ದು ಯಾವ್ದಾರು ಇದ್ರೆ ಹೇಳಿ, ಬೇರೆ ಯಾವ್ದಾರು ಇದ್ರೆ ಹೇಳಿ. ಎಸ್
Please, we will also, please, we will also
at 2:30.
please produce, my lords, that the government, my lords, we have complaints that why appeals are not filed, delayed appeals filed, my lord, under AAG put it, my lords, delayed appeals are filed. We have found, my lords.
ಯಾವ್ದ್ರಲ್ಲೂ ಅಪೀಲ್ಸ್ ಯಾವ್ದು ಡಿಟರ್ಮಿನೇಷನ್ ಆನ್ ಮೆರಿಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿಲ್ವಾ?
Till today, arising out of KB.
My lord, in my matter only, the High Court has disposed the matter. On merits, it is disposed already, my lord, in the MFA, my lord. They have not taken that contention.
File everything.
I'll produce along with my statement of
Take it on
objection.
12th, no adjournment
Yes,
on
my
that
lord.
day.
Yes, my lord.
ಆಮೇಲೆ ಇನ್ಯಾವ್ಯಾವ್ದು ಮ್ಯಾಟರ್ ಇದೆ KNN ಅಲ್ಲಿ? ಯಾರು ಇವರಲ್ಲಿ? ಅವಿನಾಶ್ ಅಂಗಡಿ ಪ್ಲೀಸ್. ನಿಮ್ದು ಯಾವ್ಯಾವ್ದು? ಇನ್ನು KNN ಅಲ್ಲಿ ಯಾರು ಬರ್ತಾರೆ ಅವ್ರದ್ದೆಲ್ಲ ಫೈಲ್ ಎವ್ರಿಥಿಂಗ್.
There are thousands of cases, my lord.
Thousands?
Oh, thousands of cases.
ಇಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಷ್ಟು ಹೇಳಿ.
Different benches, what they do, what has been happening is, my lords,
2000
when
appeals,
some cases come up for hearing, my lords, they would say we are not entered appearance, we want objections. We have made submissions before honorable different benches, my lord. Then we had appeared, my lord, with different benches. Then the honorable bench would, my lords, accommodate them. Then the matter goes. It's going on like this. There are more than 10,000 cases like this, my lords. Now we have come to know.
When 200 writ petitions,
All I will list it on next Friday.
Now, my lords, may I make one submission, my lords? In some cases, they won't appear, my lord. Then they will again seek time, my lords. I only pray.
No,
Your
I
lords
am
may-
not going to grant adjournment in any case on the ground that they have not filed objection, whatever.
We will serve all the advocates, my lords.
Serve everybody.
We will serve on the learned advocates.
when
All the
200
cases.
matters have been parted, my lord, 200 matters have been parted by the coordinate bench.
First time ಕೇಳ್ತಾರೆ, coordinate.
ಅಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲೂ ಕೂಡ
ಇಲ್ಲಿ
ಹೀಗೆ.
ಆಗಿದೆ. ಇಲ್ಲಿ
ಒಂದೇ
ಧಾರವಾಡ
ಒಂದು
matters
ಕಾರಣಕ್ಕೆ-
one inch, sir. Dharwad matters have been parted, my lord. It has been posted for further hearing, my lord.
ಕಲಬುರಗಿಯಲ್ಲೂ ಆಗಿದೆ ಹಂಗೆ. Everywhere they seek time and honorable courts, my lords, of course, we have to give time.
12th, I am going to finish.
Then they will put forth the ground, my lord. There's other benches pending, we will wait. It's going on like
Sir,
this.
You want me to wait? I will.
No, we don't want. We want justice, my lord. You just may lay down, my lords, the law, so that it applies to everybody.
ಎಲ್ಲ ಕಡೆನೂ ಅದೇನೆ.
The rest of all of us want justice. Both of us.
My lord, meanwhile, let them come with the status, my lord, list details till date, in how many cases they have appeared and objected. It is only started, my lord,
They are
2025.
not parties at all.
That
Don't
may be
make them
reason in
parties.
one or these.
ಇಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಏನ್ ಗೊತ್ತಾ, ಮುಂಚೆ ಎಲ್ಲ ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ, ಪಾರ್ಟಿ ಮಾಡಿದ್ರು ಯಾರು ಒಪ್ಪೇರ್ ಆಗಲ್ಲ ಅಲ್ಲಿ.
My
They have
lords,
satisfied
may
the
I
amount.
submit now, my lord? This has my interesting question, my learned friend Rose.
Interesting question.
Question for this reason. Now we came to know, my lords, we have R&R department has their own legal team, my lords.
R&R
When
also
R&R
government,
department-
not R&R. Not
Government,
R&R.
anyhow, the
It's
government revenue department.
ಏನು?
Rehabilitation and resettlement department, my lords. Now, my lord, the scheme was earlier, land acquisition officers, my lord, would pass the award, they are only the parties. The files would go to that concerned department. That department had some set of legal advisors, they would write which is fit and which is not fit. And this fit and not fit that we found later, the government finds that there's something and some were dismissed, inquiry was conducted, etc. And now the
Fit and not fit,
Yes.
they are misfit and unfit ಇರುತ್ತೆ.
this, my lord, we came to know, my lord, that the total outlay of the government was 1,000 crores. It went to 100 crores, 1,000 crores. Then an inquiry was held. Then they came to know that something is fishy and evidence is not led. Appeals are not filed in time. Deliberately, appeals are filed after much delay, dismissed, not contested, no cross-examination. All this has been going. Now, special investigation team has been constituted recently by the cabinet, my lord, decided. This is a very, very serious issue, my lords.
Public money, sir.
And we have to pay. We pay. And we are never parties in anything. And then they say, my lords, you need not be parties, and they get attachment orders. And then they, once DC office attached, then they ask us to pay the money. We don't have the funds, and then we realize no puppies are furnished to us. It's only a memo by the department to pay these amounts. And then we are answerable. Action is taken against us. Then we come to know. Then government issued a circular, my lords, that all these reference courts should issue notice to everybody. Despite that circular, my lords, reference codes don't issue. We have produced annexures.
Don't leave any document.
Please, I will make a
behind.
separate compilation.
You produce every compilation.
Please, please.
And on the list of dates, notes of arguments, judgments, whatever you want to file after serving an advance.
Please,
ನಿಮ್ದು ಅದೇನೆ same.
And from their incorporation. ಅವಾಗಿಂದ ಇಲ್ಲಿವರೆಗೂ
ಅಲ್ಲಿಂದಾನೆ.
ಅದು ಹುಟ್ಟಿದ್ದು ಅದಕ್ಕೆ ಸರ್, ಕೃಷ್ಣ ನದಿಗೋಸ್ಕರ ಹುಟ್ಟಿದ್ದು ಅದು KBG.
ಈ ಬಲಾಢ್ಯ
ಅದು ಹುಟ್ಟಿದ್ದೆ ಕೃಷ್ಣ.
ಇವೆಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದು ಇಲ್ಲಿಂದನೇ, ಬೇರೆ ಎಲ್ಲಿಲ್ಲ ಎಲ್ಲಿಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದು ಇಲ್ಲಿಂದ.
ಅದಕ್ಕೆ ನೀವು ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ ಮಾಡಿ.
Problem started, my lord. If it is a normal compensation, my lord, even it can.
ಈ government definitely does not
Because
bother.
yes, my lord. 10 ರೂಪಾಯಿ 100 ರೂಪಾಯಿ
ಅದೇನಾಗುತ್ತೆ
ಕೊಡ್ತಿದ್ವಿ.
ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ನಿಮ್ಗೆ 10 ಲಕ್ಷ ಬರೋ ಕಡೆ 1 ಕೋಟಿ ಕೊಟ್ರೆ 10 times
ಅದು
ಜಾಸ್ತಿ. 1 ಕೋಟಿ ಬರೋ ಕಡೆ 25 ಕೋಟಿ 30 ಕೋಟಿ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ರೆ ಇಟ್ಸ್ ಆಲ್ ಪಬ್ಲಿಕ್ ಮನಿ ಸರ್.
ಆಲ್
ಮನಿ ಇಟ್ಸ್ ಮನಿ ದಟ್ ಅವ್ರಿಗೇನು ಉದ್ರಿಲ್ಲ ಅಲ್ಲಿಂದ. ಪಬ್ಲಿಕ್ ಮನಿ.
20% of cases.
That's why when such public money is bartered like this, we should be careful ಅಷ್ಟೇ.
And I was also seeing, my lord, seeing the value of the land.
ಇಲ್ಲ, because the senior counsel gave an illustration also. When the matter is remanded, 100 crores ಎಲ್ಲ SLA ಓದ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
One incident in
ಇಲ್ಲ ಅಂದ್ರೆ such instances can happen. So it is definitely on the higher side.
One incident, my lord. Supreme Court has imposed the cost on the state 5 lakh rupees for the non-payment of the amount. That is the issue relating to interest on interest. Subsequently, review has been filed. Subsequently, Supreme Court has accepted our, even after imposing of the 5 lakh rupees cost, my lord, accepted our case, my lord. Now instead of 14 crore rupees, now it is 30 lakhs rupees. So there are, and it will be precedent for other cases also, my lord. That is a larger implication on the
No, we
state.
will decide this. This I will decide. We will not
And also,
wait,
even
we
the
will not
irrigation
wait for
project,
anything.
my lords, we are.
Unless by then
Please.
the coordinate bench would pass an order, I will
Please.
follow it.
No, my lord,
Otherwise-
phase-wise, this irrigation project is going on, my lord. At one phase, we have completed only 1/3 acquisition. Still,
ಅಲ್ಲ, ಇನ್ನು
2/3 is
compensation ಕೊಡ್ಬೇಕಲ್ಲ.
that we are giving. Your lords may also take judicial notice. As far as the original order is concerned, award is concerned, my lords. The original proceedings are required to be parties. We have advised them to pay. They have paid. Original awards, we are satisfying, my lords.
No, original awards you are satisfying. This is enhanced tenfold. ಅಲ್ಲ.
Enhanced without.
We'll see.
Please.
We'll see.
Without any
ಇನ್ನೊಂದು
notice.
ಜಡ್ಮೆಂಟ್ ಹೇಳಿದ್ರಲ್ಲ, ಅದನ್ನು ಎಲ್ಲ ಗೆಟ್ ಎವ್ರಿಥಿಂಗ್.
Pirappa judgment.
ಅರ್ಚನಾ ಮಗ್ದುಮ್
Same judge.
ಅದು ಎಲ್ಲ ಸೇರಿ get it. Yes.
Pirappa, KD. Serial number 91, notice is not at issue. Same.
ಅದು ಅದೇನ ಸೇಮ್.
List one, serial number
KBJ
91.
ಅಲ್ಲ,
Again,
you will take notice.
No, I am the petitioner.
Petitioner, ಅದು 91 ಅಲ್ಲಿ emergent notice to the respondent. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. The state ಗೆ AG. Yes. ಅದನ್ನು 12th. ಕಳೆ sir, 12th will finish. Heard the learned senior counsel PP Hegde appearing for the petitioner and the counsel so representing the respondents. They list the matter at 2:30 PM on 12th for further hearing.
Please, may I pray, my lords, in all the cases, kindly permit us to serve on the advocates. Otherwise, impossible.
ಇಲ್ಲ advocates
ಅದೊಂದು ದಯವಿಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿ.
General order ತಗೊಂಡ್ಬಿಡಿ ಒಂದು. In all these cases, the petitioners shall serve on the respective counsels representing the parties before the reference court and file an acknowledgement of such service.
Please, separate notice to respondents may kindly be dispensed with. Otherwise, office comes with that obligation every time.
In lieu of notice.
Please, in lieu of, please.
Connect the 90, serial number
91 ಅದಕ್ಕೆ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ. ಅದು ನೀರಾವರಿ ನಿಗಮ. ನೀರಾವರಿ ನಿಗಮ್ಗೆ ಯಾರು? ಅವಿನಾಶ್. ನೀರಾವರಿ ನಿಗಮ KBJ ಏನಲ್ಲ. ನೀರಾವರಿ ನಿಗಮ ಯಾರು? ಓ, ಸಾರಿ. ನೀವು ಈ ಕಡೆ ಬನ್ನಿ. Yes.
KNL KBJ ಮಿಕ್ಸ್ ಆಗೋದು ಬೇಡ.
KNL sir.
No. Waters are there flowing differently, my lords.
12th at 2:30.
2:30.
Yes.
Most
12th ಎಷ್ಟೊತ್ತಿದ್ರು will finish this.
Please, lordship's can permission. Serial number 107, this pertains to land acquisition. From the date of disposition till preliminary notification, in between 5 or
Damage award.
Damages.
I will take that
Yes,
also. I will hear that also.
Similar matters are listed before the.
53 ವರೆಗೂ ಮುಗಿಸ್ಬಿಟ್ಟು I will take that Shilwant sir ಇದು ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಏನದು ಅದು ಮುಗಿಸ್ಬಿಟ್ಟು then I'll come back.
Yes, sir. Please.
12th.
Please, my lords. That registration of births and deaths, if my lords please to.
ಅದು ಇದೆ correct.
ಹೌದು, ಎರಡನೇ ಮ್ಯಾಟರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಎರಡನೇ ಮ್ಯಾಟರ್ ಮೈ some of the
5 minutes. Finish Shilwant sir.
Please. That's also bar association.
Correct. But register of births and deaths, that is
that's because
Supreme Court has directed
the direction is there.
to be disposed immediately.
Please.
Yes. ಇವತ್ತು ಎಷ್ಟೊತ್ತಿದ್ರು ಅದು ಮುಗಿಸೋಣ.
As my lord, please.
ಅದ್ರಲ್ಲಿ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು?
ಅದರೊಳಗೆ Union of India, he is also for that matter.
I represent the state in the matter, my lords.
Vivek Reddy is my lord.
Vivek Reddy is also there.
I am for the state in the
I will commence and they will also add.
I'll
My friends are
Ravishankar
there.
sir.
Ravishankar and
4:15 ತಗೊಂತೀನಿ ಅದನ್ನ.
I appear for the respondent in this matter.
No adjournment in that Supreme Court has directed closure immediate. No adjournment at all.
Any adjournment, my lord.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ಹೇಳಿದ್ರು. No, I have told it to everybody including me. So we'll take it at 4:30.
The only issue is, my lord, how to share the documents and some judgments, my lord, is the only.
How to share?
Yes, my lord.
I will hear and reserve it. You share it.
Screen share.
Yes.
Screen share.
Ravishankar sir, 4:30.
Lordships, please.
Yes.
please.
ನೀವು ಇರ್ತೀರಲ್ಲ.
I'm here, please. I am present.
That's very important. Supreme Court has directed. So
Yes, please.
Actually 4/9/2025 in the 2 months ಒಳಗೆ ಮುಗಿಸಕ್ಕೆ ಹೇಳಿದ್ರು. I have crossed the deadline.
It was only because my lords were not sitting there.
Correct.
Only because of that.
ಅದಕ್ಕೆ
Please. ಅದು ಎರಡನೇ ಮ್ಯಾಟ್ರು ಬ್ಯಾಂಗ್ಳೂರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಲೀಸ್.
I make one submission. Bangalore list, third matter, serial number 3, could it be had when your lordships are here in Bangalore? Milords? Looks like today it may not be taken up. So many other
Oh.
matters.
Your guess is correct. We'll see.
Please, I'll wait.
Reach Aglila Andhra, we'll take it in Bangalore. Yes.
Please.
Yes, Shilwan sir. Bar Association, yes.
As a petitioner, as a past almost 12 years, he is the president of Bar Association. Even a single complaint is not made against him. As a
Some documents.
one.
Have not taken together.
Yes, Shilwan.
As the petitioner.
Malas, I'm producing the documents in support of my claim.
Produce.
As the Bar Association, in fact, is the present past 12 years with no allegation against him at any point of time. Till
You are the president, huh?
I was the president. Now no confidence is moved against me and I'm removed.
Removed?
I'm good with no confidence resolution is passed. Plus the facts are like this. This arose because of plus one a function which is arranged, which is scheduled to be held on 4th of October, 150th anniversary of the Bar Association of Belgaum.
Belgaum Bar Association.
Belgaum Bar Association.
Belgaum Bar appears to be very powerful. Yes.
Illa, innore ಏನೈತಿದಿಲ್ಲ. Now, because of that function, this has happened. And they have achieved their object.
Oh, because of the function.
Yes, they have achieved their object. No, sir.
Don't look at him.
A committee was constituted.
Malas, I'll counter those
Don't
points. It's
worry.
okay. Let him finish.
Yeah.
Madam, we can sit down, no problem.
Deepak, don't get intimidated because she's standing. Yes.
No, sir, bylaws are there, Milos Annexure B is the bylaw. For the function, Milos, we have formed a committee of 150 advocates. Milos, all arrangements were made. Suddenly, a complaint came to be filed.
On what day?
On the president for no confidence.
All right.
Milos, only on the ground that 3 persons were Milos, practicing without any sanat, and they should be objected. That is their main contention in the complaint. And that interstate dispute between the advocates. That was the main cause for this complaint also. And he, in fact, moved no confidence. Plus, the committee has taken a decision not to call the meeting because there is no bylaws does not provide for no confidence motion. And 617 members again gave an application not to conduct the general body because rule does not provide for that. Since the members approached this honorable court passed an order, my lord, sir.
Consider representation.
Consider ಅಲ್ಲಿ ಒಂದು guidelines issue ಮಾಡಿದ್ದಾರೆ. Lordship can turn to
Guidelines also na. Suraj Sabra ತಾನೆ? Suraj Govindraj ಅವರದಾ?
Suraj. Annexure J 112.
112.
121 minutes.
Partly allowed.
Partly allowed.
Meeting shall be.
Respondent 3 is directed to call for general body meeting by giving a notice of not less than 3 days, which notice shall be affixed so and so and so. Kindly see last one. It is hoped and believed that all the advocates shall cooperate with each other to celebrate the milestone of 150 years of existence of Respondent number 3 Bar Association in a peaceful, cooperative, fraternizing or joyful manner. This is the order. Based on this, a meeting was called for no confidence. There are no allegations, no discussion took place, no hearing. They straight away passed an order, though the certain members said no discussion is required because function is approaching. No discussion, no hearing, nothing. They passed a resolution by ballot. That is also not provided in the rules. They asked for a ballot. about 450 advocates alleged to have participated in the meeting, but ballot votes about 541 alleged to have participated in the voting, but 629 votes were found in the ballot box.
Eh?
Ah.
429 participated.
541 participated.
Ah.
510 participated. 629 votes were found in the ballot.
ಅದೇಂಗೆ?
ಅದು ಗೊತ್ತಿಲ್ಲ, ಅವ್ರು ಹೇಳ್ಬೇಕು. Plus, at least an opportunity, the bylaws does not provide for no confidence. Even society, Karnataka Society Registration Act does not provide for no confidence.
Then how was it held?
Pardon?
How was it held without authority of law then?
That is I am questioning before this court.
Then the coordinate bench ಕೇಳ್ಬೇಕಾಗಿತ್ತು ಇದಿಲ್ಲ ಅಂತ.
ಮೀಟಿಂಗ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ರು ಅವರು. not for no confidence.
150 years ಮಾತ್ರ ಹೇಳಿದ್ರು.
ಮೀಟಿಂಗ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. This discussion should take place, and they have to vote. They have to give opportunity of hearing.
For
Nothing
what?
is opportunity of hearing. At least they discuss. What is my explanation for it is not a misconduct. I cannot take action against the advocates who are without sanad. If they are practicing without sanad, I can only restrain them. That's all. I made a complaint to the Bar Council. I made an inquiry with the Maharashtra State Bar Council. She has got sanad in that. I said compromise matter. There is a tussle between two advocates, and there is a sexual harassment against one advocate, and we wanted to compromise that. He said he did not compromise. Ultimately, complaint came to file. He is the main cause for this.
Who is the main cause? ಇದ್ರಲ್ಲ.
ಹೌದು.
ಬೆಳಗಾಮಲ್ಲಿ.
ಬೆಳಗಾಂ.
ಆಯ್ತು.
Can you see the resolution? Typed copy, at page 37. 37, may I read, In this meeting, 5 and 10 members of Belagavi Bar Association, Belagavi, have attended the meeting. This meeting is undertaken under the in-charge Vice President of Vice President, Sri Baswaraj so and so. He is presided today's special general meeting under the supervision of so and so. During the meeting, Vice President Baswaraj so and so has addressed the meeting and welcome everybody so and so. I will come to last month. Majority of attendance members have expressed their view that there is no need for any discussion today. Today's agenda, there was no agenda also to that subject, and same was considered by both the members of the KSBC, and it was come to be declared to the present attendees that the voting shall be held in closed ballot manner, and the same shall be begin at 3:30 p.m. and so and so. Must your lordship can come to last page 39.
Yes.
At around 3:30 p.m. under the supervision of two supervisors so and so, the voting was commenced, and it is concluded in a peaceful manner at 6:30 p.m. In total, 629 members have casted their ballot papers into two ballot boxes so and so. Here, their participation is mentioned here. After counting votes from both the ballots so and so, 629 votes are there. But register shows 5 and 10 voters have casted their vote, and no opportunity is given, no discussion took place, no bylaws provide for that, and it is not a misconduct if I don't take action against them. It is my duty to inform the Bar Council. I inform the Bar Council, and 617 members said not to take any action of non-confidence because she has done the work, all the development. 617 when the no confidence are moved. 617 advocates may not have.
President is a lady, is it?
Illa, lady illa. 617 members have said not to no confidence because he has done the
confidence.
Work. Yeah, they have confidence. That is the case.
What are your grounds are no provision for
no provision under the bylaws.
Opportunity.
No opportunity is gone. No discussion took place. Manipulation is there, and they have raised the voters list by manipulating the numbers.
Yes, madam. Who is
And
answering
Malas,
this?
for part 12 years is the precedent, because they want to Malas, stop the function. This no confidence in mode. That is the only motto, they have achieved it already.
Function stop ಆಯ್ತಾ?
Function stop ಆಯ್ತು, ಎಲ್ಲ ಕೆಟ್ಟೋಯ್ತು, Supreme Court judges ಎಲ್ಲ ಹೋಯ್ತು ಎಲ್ಲ. Plus, he has collected more than 22 crores for this function.
ಅದು ಅಲಿಗೇಷನ್?
ಇಲ್ಲಲ್ಲ, ಅದು ಮಾಡಿದ್ದವರು for
ಫಂಕ್ಷನ್ ಗೋಸ್ಕರ ಮಾಡಿದ್ದು.
ಹೌದು. And they want to stop it, they have stopped it.
ಅಷ್ಟೇ. Who is answering?
My lords, I'll answer.
Yes.
My lords, as per the requisition dated 26/11/2024, a requisition was given by the respondent number 16 in the present writ petition that there are a number of members who do not have confidence on the present petitioner, my lords. As per that requisition itself, as per the writ petition, the earlier writ petition, it was decided to discuss and decide upon the requisition dated 26/11, my lords.
The requisition contained no confidence.
Yes, my lords, to discuss and decide upon. My lords, may kindly see the requisition at page number of the 67 of the petition, my lords.
Subject.
One ನಿಮಿಷ.
My lords, specifically 68, page number 68, my lords, the last paragraph.
ನೀವು ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಅಗ್ರಿಕಲ್ಚರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅವತ್ತಿದ್ದೆ ಅಲ್ಲಿ. I was not there on that day.
ಪ್ರೆಸಿಡೆಂಟ್ ಕೆಲಸ ಬಿಟ್ಬಿಟ್ಟು?
ಇಲ್ಲ, ಅದಕ್ಕೊಂದು
ಅದು ಒಂದು ಅಲಿಗೇಷನ್ ಇದೆ.
ಒಂದಿನ ಹೋಗಿ ಬಂದು ಅಲ್ಲ 150 ವರ್ಷದ ಫಂಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಪಾಸ್ಟ್ ಮಲಸ್.
ಆಯ್ತಾಯ್ತು ಹೇಳಿ.
Let them show me any allegation for past 12 years.
What an illustration you've given. Very good. Nero played violin when Rome was burning. Yes.
My lords, as per this requisition itself, the this honorable High Court itself in the previous writ petition had given an order to discuss and decide upon this particular requisition itself, my lords. That was a direction. As per that direction itself, we called for a meeting on the 16th of November, my lords. The documents which I have produced, the attendance sheet as well as the resolution and the attendance sheet, it is showcasing that we called for a meeting on the 16th of November, and this meeting was attended and participated by the present petitioner, my lords. And it was decided on 16th of November that on the 20th of November they would be holding a special general body meeting, my lords, wherein it would have been discussed and decided upon the subject of the no confidence motion, my lords. And on the 20th of November, my lords, again the petitioner was present. He participated throughout the proceedings under the observations of respondent number 4 and 5. The no confidence motion was held. As far as the allegation that he was not given a fair chance of hearing, my lords, he was given a chance, my lords, to express. It's not that we never
express
his opinion, my lords.
All right, correct. Yes.
He was given a fair chance, my lords. And also, he had more than 9 months, my lords, from the date, that is 26th November 2024 till 20th September 2025. Because 26th November, they submitted a requisition that they do not have confidence in the present petitioner, my lords. So from that date till 20th November, he had ample number of time to convince the members of the Bar Association that to have confidence in him, my lords. So
he did not get confidence at all. You have failed, sir.
My lords, also, as far as the order of the writ petition, the previous writ petition, and the meeting that was held on the 16th of November, this proves that the petitioner has accepted the order of the Honorable High Court. And now that he is coming and challenging it by invoking a writ, he cannot do so. This writ petition is not maintainable also, my lords. Why? My lords, because he has to challenge the writ, he has to challenge the previous writ petition, the order of the writ petition, because as per the directions given in that writ petition, we have conducted the meeting.
You show me in the Justice Suraj Govindara's order that he has given a direction indicating that it can be no confidence, except saying this representation will be considered. No confidence ಮಾಡಬಹುದು ಅಂತ direction ಇದೆಯಾ?
My lords, on that.
ಇದೆಯಾ?
ಇದೆ, my lords, on that aspect, my lord.
Suraj Saab order ಇದೆಯಾ?
Yes, my lords.
One sentence ತೋರಿಸ್ಬಿಡಿ.
My lords, here.
No confidence ಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ, no confidence ಗೂ direction ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಒಂದು sentence.
Not directly with regard to no confidence.
ನಾನು ಕೇಳಿದ್ದು directly.
My lords,
representation consider ಮಾಡಕ್ ಹೇಳಿದ್ರು.
Yes, my lord.
ಆಯ್ತಾ? ಅದಕ್ಕೆ ಮಾಡಕ್ ಹೇಳ್ಬೇಕಾದ್ರೆ representation ಏನಿದೆ ಅಂತ ಹೇಳಿಲ್ಲ. ಬಟ್ it is said 150 years matra ankondu his lordship has passed an order. How did you hold no confidence? What is the provision that you have to hold no confidence? Nim bylaw idya, Societies Registration Act idya, ಎರಡು ಹೇಳ್ಬಿಡಿ. Cooperative society ಬೇರೆ, ಇದು Societies Registration Act. ಇದೆಯಾ ಹೇಳ್ಬಿಡಿ.
Please, I am appearing for respondent number 16 in this.
All right.
My lordship, may kindly see page number, my lord, 117, my lord. My lord, as per the, my lord, amended bylaw of the Belgaum Bar Association, my lord. The bylaw is, my lord, incorporated in the judgment of the, my lord, honorable court, my lord.
ಯಾವುದು ಸೂರತ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಅಲ್ಲ?
Please, page number 117 may kindly be seen, my lord.
What is the meeting hold madam? The procedure for holding meeting.
Please, sir.
General body meeting.
My lord, 117 paragraph number 7, my lord. Model bylaw section.
I am holding that, yes.
Please, my lord. Lord, in that, my lord, paragraph number Roman 3, my lord. In respect of bar association having member of more than 1,000 or more, special general body meeting can be called on the requisition of the 200 or more members, my lord.
For
In
what?
view
Meeting.
of this, my lord.
Meeting.
Please, my lord.
Meet.
In view of this, my lord, the honorable court, my lord, directed two state bar elected members, my lord, to hold the meeting, my lord.
Hold the meeting.
In view of the, my lord, representation.
Hold the meeting.
My lord, to hold the meeting in view of, my lord, representation given by the, my lord.
What representation?
Representation is, my
ಅಲ್ಲ
lord.
ನಿಮಗೆ ಇದರಲ್ಲಿ ಜನರಲ್ ಬಾಡಿ ಮೀಟಿಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಕ್ಕೆ no confidence is a right of non-suiting a person who is elected. There should be express provision, no implied. Cooperative Societies Act ಅಲ್ಲಿ ಏನಿದೆ?
ಇಲ್ಲ ಇದರಲ್ಲಿ
ಅಲ್ಲ Cooperative Societies Act ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ? ಡೈರೆಕ್ಟ್ ಪ್ರಾವಿಷನ್ ಇದೆಯೋ ಇಲ್ಲ?
ಪ್ಲೀಸ್.
Societies Registration Act ಇದೆಯಾ? ಇಲ್ಲ. Now you tell me a solution. Now a president of the association behaves bad, misconducts everything. How do you remove him?
Disqualification is there, my lord, in the bylaws.
What? How disqualification?
Disqualification is mentioned in the bylaws.
How?
Must say it is there. Must have. 15.
But ಇಲ್ಲಿ permission ಕೊಟ್ಟಿದ್ದು ಸೂರತ್ ಗೋವಿಂದರಾಜ್ ಆರ್ಡರ್ ಅಲ್ಲಿ to the hold a meeting. There is no specific provision for no confidence at all.
As per my representation only, my
ಯಾರು
lord.
representation ನೀವು ಆಕಾಶ ಕೇಳಿರ್ತೀರಾ, ನಮ್ಮ ಮ್ಯಾಂಡಮಸಿಂಗ್ ಕೊಟ್ಬಿಟ್ಟು ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು ಇವೆಲ್ಲ.
That is the reason, my lord, honorable court directed.
You have misinterpreted, misused the representation direction and done this act of no confidence.
May I submit before?
Did the court extract the representation for what you have given anta?
Please, my lord.
ಎಲ್ಲಿದೆ?
At the time of argument only, my lord, even, my lord, they were also agreed for, my lord, two elected body members to, my lord, participate in the meeting, my lord.
General, come to your prayer, sir.
Please.
Prayer is extracted at 115.
Lord, issue a written nature of mandamus directing respondent and.
ಎಲ್ಲ representation consider ಅಷ್ಟೇ.
Please, my lord. Operative portion may kindly be seen. So may I read, my lord?
No, is it not?
120, my lord.
No, no problem. Tomorrow you may be in this side. That's a different thing.
Please.
And you tell me one thing. Consider representation ಅಂತ ಕಳಿಸ್ತೀವಿ. That will be in accordance with law. In accordance with law, you should have power to call for no confidence motion under the bylaws or under the Societies Registration Act.
Please.
In both of them, there is no provision. How do you call for a no confidence motion? And that is first thing. And in a no confidence motion, without deliberation, how can you remove a precedent? What is the deliberation that has happened? What is the proceeding that you have recorded of such deliberation? Nothing.
Lord,
Nothing.
For a moment, my lord, page number 120, my lord, operative portion may kindly be seen.
Order ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ. Now, what is that you have done? No confidence motion ಮಾಡಿ. Where is the proceeding of the day?
My lords, I've produced the.
ಇದೇನಾ?
ಇದೆ.
Deliberations ತುಂಬಾ ಆಗಿದೆಯಾ? ಏನಾಗಿದೆ? ನೀವೇ ಹೇಳ್ಬಿಡಿ ಏನಾಗಿದೆ ಅಂತ.
My lords, firstly, the meeting was called for in the morning session, wherein whether it had to be discussed and decided whether to call for a no confidence motion. It was discussed and decided upon by the members of the Bar Association that they would be calling for a no confidence motion and the voting would happen at 3:30 PM, my lords. And accordingly, the voting started at 3:30 PM, which ended after 7 PM, and 7 PM.
How many voted?
My lord, 629 people voted in total.
But why the register, he says that it is only 510?
My lords, I have produced the attendance sheet, my lords.
General
It's-
register, ಅದ್ರಲ್ಲಿ ಎಷ್ಟಿದೆ?
In the morning meeting, there were 510 people, my lords. While voting, there were 629.
ಆಮೇಲೆ ಜಾಸ್ತಿ ಜನ ಬಂದ್ರು.
ಹೌದು.
Court has also, this court has said, my lords, to conduct a function smoothly. That they forget.
ಹಂಗ್ ಮಾಡಿದಾರಲ್ಲ, ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್.
ಅದು ಎಲ್ಲ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ, ಫಂಕ್ಷನ್ ಹಾಳು ಮಾಡಿಬಿಟ್ರು ಎಲ್ಲ.
ಫಂಕ್ಷನ್ ಬಿಟ್ಟು ಬೇರೆ ಟೆನ್ಷನ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರು.
This they don't, no, they forget this.
Agreed by the writ.
They forget this order.
They have approached my lord division bench, honorable division bench.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
No, my lord, they have not filed any, my
ಅಲ್ಲ,
lord.
ಜಸ್ಟಿಸ್ ಸೂರಜ್ ಅವರ ಆರ್ಡರ್ ಫೈನಲ್
I am not agreed.
Yes, my lords, this order has been final, has
No,
attained
we'll have
finality.
to go from, start our journey from there only. ಅದಕ್ಕೆ ಮುಂಚೆ ಹೋಗಕ್ಕಾಗಲ್ಲ. Because he has permitted consideration of the representation and by giving directions. Meeting shall not be held so and so. It's not that plain order saying that consider representation ಅಲ್ಲ ಅದು.
ಅಲ್ಲ, one, the
box is there.
If this honorable court permits, my lords, we have bought the ballot box also. We can produce it before this honorable.
ನಾನ್ ಕೌಂಟ್ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ, ನೀವು
New will refer, lords. We have bought.
fixed for counting of the votes also, my lord.
My lord, lordship, may come for a moment, kindly see page number 120, my lord. Order of the, my lord, honorable bench, coordinate bench.
I am there only, sir. 120 ಅಲ್ಲೇ ಇದ್ದೀನಿ.
Please, my lord.
By law,
Paragraph number 2,
26
my lord.
notice shall be given. Every direction is given here.
The respondent number 3 is directed to call for general body meeting by giving notice not less than, my lord, 3 days, which notice shall be affixed on the notice board of respondent number 3 association and circulated on WhatsApp group of respondent number 3 association. The meeting shall be conducted under the supervision of the Mr. So and so, Mr. So and so, who are the
Mr.
present members of the Karnataka Bar Council, my lord.
Lord, his term will complete by February 9th. That's all.
ಈಗ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
ಇಲ್ಲ, ಈ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಇದರಲ್ಲಿ.
ನಂದ ಇದು?
ಇಲ್ಲ, ಇಲ್ಲ.
ಫಸ್ಟ್ ಶುರು ಆಗಿದ್ದು ನನ್ನ ಹತ್ರನಾ?
ಹಾ,
ಕೊಟ್ಟಿಲ್ಲ.
we
ಅಷ್ಟೇನಾ?
thought that we'll dispose it off ಅಂತ ಹೇಳಿದ್ರಿ ತಾವ.
Yes, madam. Anything else?
My lord's only contention is that his entire writ petition order, the no confidence motion was brought and it has been
So
done.
you draw your rights completely with Justice Suraj's order.
Yes, my lord.
Correct.
And subsequently, my lords, the no confidence votes are also there. It may be counted if, as the allegations are made by the petitioners, that there are more votes. If there are more votes,
No,
then
I am at the threshold. Even if you take cue from the order passed by this court, which gave you a mandamus, can that be used when there is no provision for no confidence under the bylaw, under the act? Under what provision of law did you call the no confidence motion? You called a general body. General body for general discussion. No confidence, there should be specific provision. ಅದು ತೋರಿಸ್ಬಿಡಿ ಅಷ್ಟೇ.
my lords, as per the representation and at annexure F, the no confidence motion, it is already mentioned there that the meeting is for no confidence motion. If that was the case, the petitioner would have contended the same before the.
He was confident that he will not get votes against him. ಅದಕ್ಕೆ participate ಮಾಡಿ.
Now that he has lost the no confidence motion, he is coming up with this particular writ petition, my lord.
My lords, also another submission in this regard is that now he is challenging the outcome of the no confidence motion. He cannot challenge it by way of invoking a writ. He has to file an appeal before the appropriate authority, my lords. He
ಅವರೇ
cannot-
ಕೌಂಟ್ ಮಾಡಕ್ ಸಾಧ್ಯ. ಈ ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ ಕೌಂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ನೀವು ಬ್ಯಾಲೆಟ್ ಬಾಕ್ಸ್ ತಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂದ್ರೆ? Yes.
No, to show the clarity, my lords.
No, I'm only on the legal aspect of it, madam.
Yes, my lords.
Whether you have power or not to hold no confidence motion, that will have to be answered. Because the earlier order is only a mandamus to hold a general body meeting to consider 150 ವರ್ಷ. ಅವ್ರು 150 ವರ್ಷ ಅಂದ್ಕೊಂಡು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರು.
ಇಲ್ಲ, ಆಕ್ಚುಲಿ ನಾವೇ ಹೇಳಿ ತಗೊಂಡಿದ್ದೆ ಸ್ವಾಮಿ, ಏನಾರು ಮಾಡಿ ಮುಗಿಸಿ ಫಂಕ್ಷನ್ ಇದೆ ಅಂತಂದು.
ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮಾಡಿದ್ರ?
ಕಂಪ್ಲೇಂಟ್ ಆಗಿ ಎಲ್ಲ ಆಗಿ ಆಮೇಲೆ and they have sent a complaint to all the judges and they refused to come.
Judges?
Supreme Court judges complaint ಮಾಡಿ they refused to come and must we can ultimately cancel the program. They achieved their object.
ಬೆಳಗಾಂ ಬಾರ್ ತುಂಬಾ ಪವರ್ಫುಲ್ ಆಯ್ತು ಅದಕ್ಕೆ.
In this manner.
150-year history itself shows, sir, it is powerful. Yes. All right, ಅಷ್ಟೇ ಅಲ್ಲ? Please, we'll decide it. Heard reserved.
Please.
You are Naina, right?
Yes, my lords. Much better.
Yes.
Please, ma'am.
ಬೇರೆ ಸ್ಟೇಟ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಏನ್ ಸಬ್ಮಿಷನ್ ಇಲ್ವಾ? ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ. ಎಸ್. ಅದೇನು ಕೊಡಿ ಯಾವ್ದು ಅಲ್ಲ, ಈಗ ಯಾವ್ದು ಇನ್ನೊಂದು ಹೇಳಿದ್ನಲ್ಲ ತಗೊಂತೀನಿ ಅಂತ. ಯಾವ್ದು ಮೇಡಮ್ ಇದು? ಒಂದು ನಿಮಿಷ ಬನ್ನಿ ಇಲ್ಲಿ. PP ಹೆಗ್ಡೆ ಇದ್ದಾರಾ? ಬರಿಸಿ. ಹೌದು, ಎಷ್ಟು 4:30 ಅಂತ ಹೇಳಿ. I will finish.
Bill number 38. Karnataka Surat C. Rajshekar Argundeli.
Anganwadi.
Rajkumar Gijori, covered.
Please, Your Lordship. But
ಬೇರೆ ಯಾವ್ದಾರು ಅವ್ರು ಕೊಡಂಗಿದ್ರೆ ಚೆಕ್ ಮಾಡಿ. ಅವ್ರನ್ನ ಯಾಕೆ ಕಳ್ಸೋದು? ಪಕ್ಕದ ಅಂಗನವಾಡಿಲಿ ಇದ್ರೆ ಅವ್ರು ಹೋಗ್ತಾರೆ. ಟ್ಯೂಸ್ಡೇ ತಗೊಂತೀನಿ, ಜಸ್ಟ್ ಚೆಕ್.
Please, Your Lordship.
ಟ್ಯೂಸ್ಡೇ or Wednesday I'll take. ನೋಡಿ ಇದ್ರೆ ಕೇಳಿ.
Nothing, Your Lordship. The only thing is petitioner is more meritorious, but admittedly she has not uploaded. And after uploading the documents, it's everything is fine.
You can't deny merit. I for one will not.
When documents are not available, in the absence of
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇರಲಿಲ್ಲ? ಡೊಮಿಸೈಲ್ ಇರಲಿಲ್ವಾ?
Domicile, from the date of earlier notification, Your Lordship, there are many cases which we came across with the Your Lordship.
Correct, ತುಂಬಾ ಇದೆ.
ಅಲ್ಲ, ಎಲ್ಲ ಕಡೆನೂ the lady who has approached the Your Lordship.
You will definitely look into. ಈಗ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಗೆ ಅಂತ ಕರೀತಿರಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕರೆದಾಗ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರೆ ಆಗಲ್ವಾ?
ಅವಾಗನು ಹಾಕಿರಲ್ಲ. ಅವಾಗ ಹಾಕಿಲ್ಲ ಅಂತಂದ್ರೆ
that time I have produced my lord.
See, we'll lay down something.
Please,
If upload ಮಾಡ್ಬೇಕಾದ್ರೆ ಹಾಕಿಲ್ಲ ಅಂತ ಇವ್ರ ಕ್ಯಾಂಡಿಡೇಚರ್ ಇಲ್ಲ ಅಂದ್ರೆ, if they find it to be more meritorious, if they submit objections along with the document, you will consider ಅಂತ ಒಂದು ಬರೆದು ಇಟ್ಬಿಡ್ತೀನಿ. ಅವಾಗ ಲಿಟಿಗೇಷನ್ ಕಮ್ಮಿ ಆಗುತ್ತೆ.
But the very purpose of notification.
ಮೇಡಮ್, ಇವ್ರು ಮಾಡಲ್ಲ, ಹೇಳಿಲ್ವಾ? ಸೈಬರ್ ಕಫೆ, ದಟ್ ಮ್ಯಾನ್ ಹ್ಯಾಸ್ ಸಮ್ ಪ್ರಾಬ್ಲಮ್ ಇನ್ ಹಿಸ್ ಹೌಸ್ ಅಂದ್ರೆ ಅವ್ನು ಏನೇನೋ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾನೆ.
Then even
ಇವರೇ ಅಪ್ಲೋಡ್ ಮಾಡಂಗಿದ್ರೆ ಬೇರೆ.
Even government is also not responsible for not uploading the
documents. I'm not saying you're responsible. They are themselves responsible. But it is, see, ಈಗ caste certificate ಕೊಡ್ಲಿಲ್ಲ ಅಂತ it is not that they don't belong to that caste at all.
Even the person who has filed the very same caste certificate, Your Lordship, we have chosen that person only. ನಾವು ಬೇರೆದವ್ರನ್ನ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲಿ whole problem is merit.
ಹೌದು. Please.
She is more meritorious. That's the whole problem. Let's see. ಒಂದು ಬುಧವಾರ ಕೇಳಿ ಯಾವ್ದಾರ ಪಕ್ಕದ ಅಂಗನವಾಡಿಯಲ್ಲಿ ಕೊಡ್ತಾರ ಅಂತ. ಅಂಗನವಾಡಿ ತಾನೇ ಬೇಕು? ಹಾ, ಸರಿ. ಇಲ್ಲ ಅಂದ್ರೆ I will write saying that there is one judgment, latest judgment. This is not a curable defect, it goes ಅಂತ ನಾನೇ ಕೊಡ್ತೀನಿ. Not a curable defect. If documents are not uploaded, it is to their peril ಅಂತ ಇದೆ. That is last week it is rendered by apex court or division bench of some court. I'll get it. Yes. ನೀವು ನೋಡಿ, ನಿಮ್ against ಇದೆ, ನಾನೇ ನೋಡ್ತೀನಿ. Yes.
ಇಲ್ಲ, page number 22, my lordship, it is the caste certificate. It has been issued in the year 2017 itself.
No, you don't. It's not that your caste gets wiped off by not submitting the document. That is why we'll have to fall back upon merit. Who is more? See, whatever the state may devise, state may have favorites, state may have partisan. Merit should not be compromised in anything. It's public employment after all.
In the absence of the certificates.
In the absence, ಈಗ ಆಯ್ತು, document ಬಂದಿದ್ರು ಬಂದಿಲ್ಲ ಅನ್ಬಿಡ್ತಾರೆ.
ಅಲ್ಲ, ಈಗ provisional list will be issued when they have called for objections, Your Lordship. ಅದಕ್ಕೆ ಫೇರ್ ಚಾನ್ಸ್ ಬೇಕಂತಾನೆ ಆನ್ಲೈನ್ ನೋಟಿಫಿಕೇಶನ್ ಕರೆದಿರೋದು. ಬಟ್ ದೆನ್ ಆಲ್ಸೋ
Wednesday.
Please, Your Lordship.
Seal number 40, Sunil Desai.
Order of suspension, my lords.
It is
Termination.
already revoked.
Single use of banners, my lords.
Banner.
Oh, I asked for who is the
Please,
corporator,
lords.
Kudil?
Srimati B. Ratnamma.
Lordship, as per my instructions, that order has been revoked, Your Lordship. Vapas. Okay.
ಇಲ್ಲ ಇಲ್ಲ ಬರ್ದ್ ಬಿಡ್ತೀವಿ ಈಗ. ಇನ್ನೊಂದ್ಸರಿ ಇದು ಕ್ರಾಪ್ ಅಪ್ ಆಗ್ಬಾರ್ದೆಲ್ಲ.
Your Lordship.
Then, my lordship, I have to receive the instruction from the.
Huh?
I
ನೀವು
appear for the
corporator.
corporation. ಇಲ್ಲ, corporation ಗೆ appear ಆಗ್ತೀನಿ.
ಕಾರ್ಪೊರೇಷನ್ ಇರ್ಲಿ ವೇಟ್. ಬ್ಯಾನರ್ ಹಾಕಿದ್ದಕ್ಕೆ ಸಸ್ಪೆಂಡ್ ಮಾಡಿಸಿದಿರಾ?
ಅದೇ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರ್ಬೇಕು ಸರ್.
ಅದು ಬರೋದೇ ಇಲ್ಲ ಬಿಡಿ. ಬ್ಯಾನರ್ ಅಲ್ವಾ? ಬರಲ್ಲ. State's mannerism towards bannerism should stop. I will write it.
Page number 48, Your Lordship. Wherein ಬ್ಯಾನರ್ ಗಳು ಹಾಕಲಾಗಿತ್ತು, ಆದ್ರೆ ಮಹರ್ಷಿ ವಾಲ್ಮೀಕಿ ಜಯಂತಿಯ ದಿನಾಂಕ 7/10/25 ಇದ್ದು ಜಯಂತಿಯ ಆಚರಣೆ ಪೂರ್ವದಲ್ಲಿಯೇ ತೆಗೆದಿದ್ದು. That is the allegation.
Corporator
But
husband
as
picture
per my
ಹಾಕಿದ್ದು.
instructions, Your Lordship, some
ವಾಲ್ಮೀಕಿ
subsequent.
ಅವ್ರದ್ದಲ್ಲ. ಕಾರ್ಪೊರೇಟರ್ ಹಸ್ಬೆಂಡ್ ಪಕ್ಕದಲ್ಲಿ ಹಾಕೊಂಡಿದ್ರು, ಅದನ್ನ ತೆಗ್ದಿದ್ದಾರೆ.
That is subsequent, Your Lordship.
ಅಷ್ಟೇ, ಗವರ್ಮೆಂಟ್ ಸಸ್ಪೆಂಡ್ ಮಾಡಿರೋದು ಅವ್ರು ತಾನೆ.
ಅವ್ರ ಬೇಸ್ಡ್ ಆನ್ ಮೈ ರಿಪೋರ್ಟ್.
ಅದೇ ಬೇಸ್ಡ್ ಆನ್ ಯುವರ್ ಅಷ್ಟೇನಾ? ಹಾರ್ಡ್ ರಿಸರ್ವ್.
Tuesday or Wednesday, Your Lordship.
ವೆನ್ಸ್ಡೇ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡೆ.
Finally, list the matter on Wednesday in the fresh matters list.
Please.
Interim order subsisting would continue till the disposal of the petition.
Ivan M. Patil.
51, 41 na?
Yes.
Yen Patil?
I have heard the hand summons. Respond number 1 and 2.
What's the matter? Rowdy?
They have violated the interim orders of the court, my lord.
Violated?
Yes. Earlier, they have given undertaking before the honorable trial court. Thereafter, the trial court has granted the interim order. In spite of that, my lord, they have violated the order and continued
Who has violated?
The respond number 1 and 2, my lord.
Sir, go complain to the civil court.
Your lordship, last occasion, your lordship has directed. Your lordship may kindly see in page number 49, para 21.
ಗೊತ್ತಾಯ್ತು.
Yes.
ಈ matter. Yes.
I undertake to file.
ಯಾರಿಗೆ ಸರ್?
R1.
para 49 ಅದು?
My lord.
ಅಲ್ಲ ಎಲ್ಲಿ ಅದು? ಅವಾಗ ಓದಿದ್ದೆಲ್ಲಿ ಅದು?
Para 21, my lord.
Of?
Page number 49, my lord.
ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ರೆಡಿ ಇದ್ದೆ. ಈ para 21 ನೋಡಿದ ತಕ್ಷಣ.
Yes.
ಅವಾಗ ನೋಟಿಸ್ ಮಾಡಿದ್ದು. para 21 ನೋಡಿದ್ದೀರಾ?
R1.
para 21 ನೋಡಿದ್ದೀರಾ ಅಂದೆ?
para 21 of the petition.
ಇವ್ರ ಬ್ರದರ್?
My lord.
ಅವ್ರು ಯಾರು? ಸಿವಿಲ್ ಜಡ್ಜ್ ಗೊತ್ತಾಯ್ತು.
Yes.
ಬಟ್
ಅಂದ್ರೆ ಈಗೇನೋ ಎಕ್ಸ್ ಜುಡಿಷಿಯಲ್ ಅಫ್ಸರ್.
ಎಕ್ಸಾ?
Yes.
Yes. R1 was civil judge.
Civil judge?
Yes.
ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಆಗ್ತದೆ. ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ರೆಡಿ ಇದ್ದೆ. The moment I saw this, I issued notice.
No, the respondent number 1 born and brought up in that property.
Born and brought up in that property.
Yes. Parents.
ಅದು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Civil court ಅಲ್ಲಿ.
They are fighting it out. Fight it out.
It is there. It is there, Your Honor. And the main contention what I have taken in the WS also I have filed. The property belonging to respondent number 1 is other than the suit schedule property. And it is based on the document submitted by the plaintiff itself. On 18/10/2025, they have filed a memo along with one Tahsildar report, which says the respondent number 1 property is in survey number 381, but suit schedule property is in 394.
But undertaking ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Undertaking was only for 4 days.
4 days?
Yes. It was there only for 4 days during
the honorable court has given the
during Deepavali festival.
Status quo order, my lord.
It was only for 4 days. It is clearly mentioned in the order sheet.
You do. I will permit you to file a contempt petition there.
Contempt petition is already filed.
They have filed the application.
The petitioner is before this court seeking the following prayer. ಈಗಿಲ್ಲ ಅವರು. Don't worry.
Being a judicial officer, they have themselves violated the court orders. Then what about the
property? Judicial officer ಈಗಲ್ಲ.
Property is entirely different.
The petitioner is before this court seeking the following prayer. The petitioner is before at the doors of this court on a circumstance that private respondents have violated the interim order or the undertaking rendered before the concerned court. The learned counsel for the respondent number 2 now submits that the petitioners have also invoked the contempt jurisdiction of the civil court.
Respondent number 1.
Respondent number 1 have also invoked the contempt jurisdiction now, and the contempt application is pending adjudication before the concerned court. In that light, leaving open all the contentions to be urged before the concerned court in the contempt application, the petition stands disposed.
As possible as early to dispose of the
The concerned court shall endeavor to conclude the contempt application if it's pending as on today, with an outer limit of 4 weeks from the date of receipt of the copy of the order.
Last 2 weeks it is pending.
8 weeks.
1 week.
1 week. Yes.
2 weeks.
4 weeks from today, if not earlier. Yes.
For petitioner, as mandamus to consider the representation of to comply the order of this honorable court fastly.
Comply the order of mandamus.
Please, ma'am.
Where is the order?
Annexure B, page number 16. Annexure B, page number 16.
Annexure B.
Please, plus operative position.
You comply madakke mandamus kelta idira.
Earlier order was passed in the 2000.
Till today they are not considered.
Alla yavagin order? 2000?
2001.
2001 order.
Please, there is a direction, page number 24.
Representation kottidi yavaga sir?
Now there. Plus my.
Manne. Anything else?
Plus father is died on 21/4.
The petitioner is before this court seeking the following prayer. The petitioner, father of the petitioner, the father of the petitioner had knocked at the doors of this court, not last year, not last 10 years, but 24 years ago. In writ petition, 25 years ago, in writ petition 26250 of 2000, which comes to be disposed on 12th April 2001, rendering certain directions. The father of the petitioner in his rendering certain directions, which reads as follows. The father of the petitioner in his lifetime, petitioners in their lifetime did not choose to pursue the direction so issued by the coordinate bench 25 years ago. Today, the son is before the court asking for a simple mandamus to comply with the order passed by the order passed by the learned single judge quarter century ago. The mandamus being a right, mandamus being a writ, undoubtedly the person seeking mandamus must demonstrate a right and the consequent obligation by way of a remedy. The right that admittedly the father of the petitioner did have is lost by sheer delay, as delay defeats equity and the law protects the indolent, diligent and not the indolent. Petition lacking in merit stands rejected. Ishte innu 25 varsha nadistira litigation bitre ನೀವು.
In the lifetime of father sir, that is you know that
father ಹೋಗ್ಬಿಟ್ರಲ್ವಾ?
19 ದಲ್ಲಿ ಹೋಗ್ಬಿಟ್ರು ಸರ್.
Yes.
43.
Next.
My lord, for the petitioner in this case, my lord. Of mandamus, my lord, to consider annexure A and A1.
Has been not served, my lord. I appear for respondent number 2.
ಏನ್ mandamus sir?
My lord, that my
mandamus ಭಯ ಆಗುತ್ತೆ, threat of mandamus ಆಗ್ಬಿಟ್ಟಿದೆ ಈಗ.
No, my lord, my representation was not considered. My lord, annexure A, my lord, they said that the matter is pending in Supreme Court. Hence, after consideration of the matter in Supreme Court.
What's the matter, sir?
A matter is, my lord, to consider my credentials, my lord, like.
Pertains to weightage
before the Supreme Court.
Yes, that is
the learned counsel for the petitioner to serve set of papers upon the respondent. List the matter.
Supreme Court considered, my lord. Supreme Court dispose of the matter. Dispose agide annexure A2.
Dispose agide
annexure A2, page number 21. 21, 22 and 23, my lord.
ಇದೇನೆ ಶಂಭುಲಿಂಗ್ ಪಾಟೀಲ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಇವ್ರದ್ರೊಳಗಡೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆ, ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ವಾಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆ? Shambhuling Patil is pending before the apex court.
No, on the basis of this, your lordship last week has disposed of. Myself and Lingraj Muradi case, by referring this, your lordship
ಆಯ್ತು
disposed
ಅವ್ರಿಗೊಂದು
of.
ಕಾಪಿ ಕೊಡಿ.
Please, ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Please, my lord.
Covered ಇದ್ರೆ
Yes,
covered. Close.
ಹೌದು, but required to challenge the endorsement.
ಆಯ್ತು
which was there.
ಅವತ್ತೇನಿದೆ ಹೇಳಿ.
Please.
46. Nitin Bolbandi.
For the petition, my lords. My lords, challenging the order passed by the family court. The order is passed without jurisdiction, my lords, and
Why,
application.
sir?
Sorry, my lords.
Why jurisdiction?
My lords, the application was filed under section 24 by the wife. However, the honorable trial court has said that the wife need not be entitled to the maintenance. However, an order has been passed for the maintenance of the child. There's a specific provision under section 26 of the Hindu Marriage Act, which says that if any pendentilite application has to be filed with respect to the child, it can be filed under section 26.
No, don't worry about the provision, sir. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಈಗ 10,000 ಮಾಡಿದ್ದಾರೆ, my lords.
ಜಾಸ್ತಿ ಮಾಡ್ಲಾ?
In fact, that's one part of it, my lords. The second part is, my lords, that I have filed.
Quoting a wrong provision will not.
No, that's not the only ground that I am urging before your lordships.
Yes.
The second ground, my lords, is that I filed an RCR petition back in 2023, my lords. Now, what the trial court is doing, my lords, since 2023 till date, the trial court is not allowing me to cross-examine the respondent. What the trial court has done since the application was filed till date, it was just for the maintenance.
ನೀವು RCR first ಹಾಕಿದ್ರಾ?
Please, my lords.
Divorce first ಹಾಕಿದ್ರಾ?
No, there is no divorce at all, my lords.
ಬರೀ RCR ಇದೆ.
Only RCR. I have filed for RCR. I have filed multiple. I have tried multiple attempts to get my wife back. Now, in order to.
After filing RCR, has she filed PCR?
No, my lords. There is nothing, no application. Then what she does? In fact, there was a newborn child, my lords. Now, what she does? A girl child was born.
All right.
Now, my lord, what she does is she holds the girl child on ransom. She doesn't allow me to meet, nor my parents to meet the girl child. Thereafter, my lords, I plead the honorable trial court for me to visit the child. She doesn't allow me to do that.
Those circumstances ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು?
I filed a GNWC. That compelled me to file a GNWC, my lords.
ಅದಲ್ಲದೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Thereafter, my lords, I got the visitation rights. Now, what the trial?
ಅದಲ್ಲದೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Sorry, my lords.
ಒಂದು petition expeditious disposal ಹಾಕಿದ್ರೆ.
Yes, my lords, that is why I am before your lordship. Now, what is the trial court is doing is it has holded both the petitions. It is saying I will not allow the petition to go cross-examine either in that petition or this petition.
Don't worry. That we will take care. Now, maintenance ಎಷ್ಟು arrears ಇದೆ?
Maintenance, my lords, arrears is, I am ready to pay and I have been paying, my lords.
ಎಷ್ಟಿದೆ?
Now, my lords, it's 190 was the total arrears. I have paid around 32,000 right from the petition was filed. I am ready to and willing to pay, my lords. However, my lords, my only submission is the trial court is holding this, both the cases.
You don't worry about trial court. When do you clear the arrears?
I will, my lords. If sufficient opportunity is given to me, sufficient time is given to me. Now, the problem, my problem,
tomorrow,
my lords,
Monday, Tuesday.
not be possible, my lord, that soon, my lords.
Why, what are you working as?
My lords, I was working. In fact, I had a company of a security agency that got, because of the, I suffered losses and the company got shut. Thereafter, right now, my lords, I am working as.
After the RCR, it got shut or what?
It was during the process, my lords. It was during the process.
Maintenance order ಆದ್ಮೇಲೆ it got shut.
Before that. So it was during the process, I suffered losses in my business, and for the reason I could not.
So you should keep your wife, sir, with you.
I am, my lords,
So
I
you will
am
not
trying
suffer
to.
losses. Yes.
I have made multiple attempts, even today, my lords. If my wife cooperates, my lords, I have accepted all her conditions. I have never left any conditions unfulfilled.
You cooperate.
I am willing to cooperate, my lords. I have even said that I will make a separate accommodation for you. But despite that, my lords, there is no heed to my request. So, my lords, both the petitions are still pending. I am not allowed to do the cross-examination.
So that we will take care. Don't worry about that. Now, maintain. Arrears.
With respect to the arrears, my lords, I'll come to that, my lords. Now, my incapacity is, my lords, I am a patient of cardiomyopathy, my lords. I need cardiomyopathy, sorry.
ಅದೇ cardiomyopathy ಇದ್ಯಾವ್ದು ನಾನು ಕೇಳಿಲ್ವಲ್ಲಪ್ಪ.
Medical terms, my lords, they will get interchanged. So I am a patient. Now, my wife has left me specifically for this one reason. Post the marriage, she found out that when I went for a medical checkup, it was found that I am suffering from a heart ailment. Now, the sooner she found this, she deserted me.
Dilka Mamla.
Yeah. So the sooner she found that, she deserted me. I've made multiple attempts, and now my condition, my lords, is that monthly I have to spend a number of amount for my own medical conditions. For that, my lords, and right now I'm incapacitated to pay 2 lakh amount right now, my lords. If sufficient amount.
2 lakhs is the arrears, Sangha. Cat is out of the bag.
10,000 per
only
month ಮಾಡಿದ್ದಾರೆ.
90,000.
But the order is from the date, my lord, from the date of the application.
So
ಆ
2
ತರ
lakhs
arrears
ಇದೆ
ಆಗಿದೆ.
ಹಾಗಾದ್ರೆ, arrears.
Sorry, my lord?
2 lakhs ಇದೆ arrears.
190 ಇದೆ, my lords. Out of that, I have paid 33,000. So it comes to roughly about 1,60,000.
90 ಅಂದ್ರಲ್ಲ ಈಗ ಅದಕ್ಕೆ.
ಅದೇ 190 to 32,000 ಪೇ ಮಾಡಿದ್ದೀವಿ.
ಈಗ ಮಿಕ್ಕಿದ ಯಾವಾಗ ಪೇ ಮಾಡ್ತಾರೆ ಹೇಳಿ?
Sufficient, reasonable opportunity, time may be given, my lords. Out.
We'll give you reasonable opportunity. Next Friday.
Maybe 2 months, my lords. I'll pay in. ಅಲ್ಲ ಯಾಕಂದ್ರೆ because my own medical ailments are not allowing me to comply the order of the court.
ಅಂದ್ರೆ it is not for the wife, for the child.
Yes, my lords, I do agree, my lords. I am not disputing. I am not at all disputing my
child,
responsibility
yes.
to.
We'll dispose it, directing closure, but
Yes.
first arrears.
Yes, my lords. 4
Friday?
weeks, my lords, 4 weeks time may be given.
No, 2 weeks. Friday, list the matter on Friday, the 12th. The further proceedings before the concerned court shall remain state subject to the condition that the petitioner would deposit 1 lakh by the next date, failing which the interim order would stand automatically vacated. Friday, the 12th, not 13th. Yes.
Please. Grateful.
Read for certiorari, my lords. In consumer application, my lords, execution application, I have been made the party. I'm not the director of the cooperative society, my lord. My lord, at annexure A and A1, my name is not forthcoming in the office bearer's name, even though I have been made the party, my lord.
Serial number?
Serial number 47, my lord.
Appealaki.
My lords, here what has happened is I'm not the office bearer. If I was an office bearer, I would have filed an appeal or I would have contested the matter, my lords.
Appealaki.
My lords, in similar set of facts, my lords.
Appealaki. ಎಲ್ಲದಕ್ಕೂ ರಿಟ್ ಆಗ ಕಷ್ಟ.
My lords, what has happened?
District forum order ತಾನೆ?
Yes, my lord, district forum
State
order.
state
I'm not
forum.
challenging the order, my lords. I'm challenging the execution application wherein warrant has been issued against me, my lord.
Even that is appealable. Anyway, connected matters ಎಲ್ಲ ಕೊಡಿ.
Connected ಇಲ್ಲ, my lords, only the same.
ಇಲ್ಲ, ಅದೇ ಸುಮಾರು ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಎಸ್ ಮೇಡಮ್, ಇದು ಕನ್ಸ್ಯೂಮರ್ದೆಲ್ಲ ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿಸಿ. For petitioner shall serve on the counsel who represents the respondent. ಯಾರು contesting respondent?
Respondent number 1 and 2, my lord. Decree holders.
Before decree holders, before the concerned court and file an acknowledgement of such service. List the matter on 12th.
In the meantime, interim order, my lord.
Stay ಕೊಟ್ಟಿಲ್ಲ. Till the next date of hearing, there shall be an interim order of stay for the proceedings in the execution, so on.
Please, madam. Grateful.
48, Purnima HS.
What, madam? ಧಾರವಾಡದಲ್ಲೂ ಇದೆಯಾ? ಧಾರವಾಡದಲ್ಲೂ ಕೇಸ್ ಇದೆಯಾ? Yes.
My lord, there's a matter seeking directions to be issued to respond number 3 to frame guidelines.
For what?
With respect to housing loans, my lord. There is a guidelines which is already existing with respect to personal loans. But with respect to housing loan, the interest charged and the tenure, there is a certain practice of unilateral increase of loan tenures which is being practiced. My lord, against
ಯಾವ್ದು
this, there
ಗೈಡ್ಲೈನ್ಸ್
is,
ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಈಗ?
it's against the
Towards-
RBI circular.
Towards which loan? RBI has issued a circular?
Yes, please.
Which
my lord.
page, what page did I get it?
Page number 118, my lord. My lord, page number 118, annexure H. My lord, this is the circular issued with respect to personal loans, that there should be certain justice in, my lord, may I take your lordship to page 119, my lord, I'll read out the relevant portion.
Yes.
Clause 6, my lord. Clause 4 and 6, my lord. Clause 6 is
All
adding
applicable charges.
applicable charges, statement of accounts and the tenure, my lord, loan tenure. This is with respect to personal loans, my lord. Now may I take your lordship to, my lord, page 121. Now, my lord, this is an RTI reply we received from RBI, wherein, my lord, at page 122, the RBI admits that there is no such specific regulation with respect to housing loans, and it exists only with respect to personal loans.
Now you are aggrieved by your personal problem
Aggrieved,
also?
my lord, aggrieved by the fact that my loan tenure has been unilaterally increased from 180 months to 320 months.
Without your consent?
Without my consent and without an intimation as well. Now, my lord, I filed a consumer complaint before the district forum, and the forum has refused to interfere,
It's
stating that,
not maintainable there.
please, my lord, it is not maintainable, and they are refusing to interfere on the ground that it pertains to the agreement, loan agreement, clauses of the loan agreement. Now, my lord, the issue is that the loan agreement is not in consonance with the RBI circulars. There's one more circular dated 2007, May 2007, at page 115, my lord. This specifically mentions,
Excessive interest charges.
please, my lord, that is point number 4.3, my lord. The total cost to the borrower, including interest and all other charges levied on a loan, should be justifiable having regard to the total cost incurred by the bank in extending the loan, which is sought to be defrayed, and the extent of return that could be reasonably expected from the transaction. Now, my lord, how I am aggrieved is that, my lord, I borrowed a loan for rupees 4 lakhs, and I have already repaid 13 lakhs.
13 lakhs
13
against
lakhs.
4 lakhs.
Please, my lord.
And they've increased it again now?
Please, my lord, I can point out the relevant portion which records the number of EMIs as well, page 54 and 91.
54 and?
91. Page 54 is the sanction letter, my lord. Here it records that the equate monthly
180 months.
180 months. Now, my lord, going to page 91.
ಅಲ್ಲ ಇವ್ರದ್ರಲ್ಲಿ ಕಂಡೀಷನ್ ಸಪ್ಲೈ ಅಂತ ಕೆಳಗಡೆ ಇರುತ್ತೆ ಏನೋ ಒಂದು.
Lord, that is the shelter they take, my lord. That is the shelter that they take in the
They
district
will
forum.
take that shelter that you have signed on the document ಅಂತ.
Please, my lord. Now 91 ನಲ್ಲಿ, my lord, ಅವರು ಯೂನಿಲ್ಯಾಟರಲ್ ಆಗಿ ಇನ್ಕ್ರೀಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಇದೆ, my lord, tenure in months 320, page 91.
91, 320 months.
320 months. No intimation or ಏನು proof ಕೊಟ್ಟಿಲ್ಲ, my lord, district forum ಅಲ್ಲಿ to establish that at least an intimation was sent to me. Now, when I challenge this before the forum, this is the issue.
No, forum you can't maintain.
Now, my lord,
This is the only forum.
My lord, direction to be issued to respondent number 3, my lord,
We'll have to hear them.
they are empowered under section 35 of the
That's
banking
why we'll
regulation.
hear them and
My lord, there's one of your lordship's judgment as well, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
Valmiki cooperative.
ಅದ್ರಲ್ಲೇನು?
No, that was with respect to 35A.
That 35
But that was
interpretation
not
of
with
35A.
respect to interest.
That is CBI ಕೇಳಿದ್ದು.
ಹೌದು, my lord, that is with respect.
They heard the learned counsel H.S. Purnima appearing for the petitioner. The Srimati H.S. Purnima appearing for the petitioner. The petitioner is before this court seeking a direction for issuance of guidelines to ensure fair trade practice by the banks in unilateral increase of repayment tenure of housing loans. The petitioner secures a housing loan from
ICICI Bank.
From ICICI Bank. At the time of sanction of the housing loan, the tenure of the housing loan was 180 months, which could be gathered, page 54, Allah?
54, my lord.
Which could be gathered by the chart in the housing loan document, page 54. The learned counsel submits that the loan that was availed was 4,30,000.
4 lakhs, my lord.
30,000 ಇದೆ ಇಲ್ಲಿ sanctioned.
But 4 lakhs was availed, my lord.
Though the sanction was 4,30,000, the loan that was granted was 4 lakhs.
4 lakhs, my lord.
Against 4 lakhs, the learned counsel submits that the petitioner has already paid 13 lakhs. The reason for the aforesaid fleece is that the loan tenure is increased from 180 months to 320 months by the bank unilaterally without intimation, notwithstanding the fact that the entire amount had been completely cleared in terms of what was sanctioned in at the outset, while the tenure was 180 months. Therefore, on that score, the petitioner has also caused legal notice upon the respondent bank and also a representation to the RBI to direct under section 35 of the Banking Regulation Act to bring about guidelines like the guidelines that are subsisting insofar as, what loan is that?
Personal loans.
Insofar as personal loans are concerned, the representations have gone unheeded. Therefore, the petitioner 35A of the Banking Regulation Act. The representation having gone unheeded, the petitioner is before this court. The petitioner, ICICI Bank, Sachin Angadi, na? Learned, RBI ಗಿಲ್ಲಿ ಯಾರು ಇದಾರಾ? Nobody, I guess.
No, I'm not aware of the
You will
council.
not be aware, yes. The petitioner shall serve on any panel council representing the respondent. Emergent notice ಮಾಡಿ. Emergent notice to the returnable by, emergent notice returnable by the 9th of January. 9th of January 2026. The petitioner is also at liberty to serve on any panel council representing either of the banks. List on 9th at 2:30 PM for further hearing.
Lord, I have sought
The
for an interim
petitioner,
order on.
in the light of the aforesaid circumstance, as also the fact that the loan amount of the petitioner has been unilaterally varied to 320 months as against 180 months, further steps, what interim order have you sought?
Further payment of EMI may be
The
stalled.
further payment of, the bank shall not demand further payment of EMI, and on the strength of non-payment of such EMI cannot initiate any proceedings till the next date of hearing.
Please, my lord.
Yes.
Lord, if
It's a good question to answer.
grateful,
Yes.
my lord, if it may be taken up in the Bangalore
Aದೇ
list.
9th ಹೇಳಿದ್ನಲ್ಲ, further hearing 2:30 PM.
Grateful, my lord.
Yes.
Obliged.
I am not here only after January, I am coming there. Yes.
Grateful, obliged.
49, Sandeep Koilwar.
Serial number 49 and 50, my lords. They both challenge GST proceedings initiated against the same SSC. This happened, my lords, is that in my own case for the previous assessment year, the petitions before my lords are for 1920 and 2122. For 1718, the same issue had arisen. I filed a writ petition. This honorable court has granted stay at Annexure P.
Page?
Annexure P, page 211. my
Same
lords.
tag. Page ಏನು?
Page 211. my lords.
211. Tag, same order.
The respondents may just differ. 1 to 4, my learned
AGA is directed to accept notice for respondents, so on.
1 to 4.
1 to?
1 to 4, my lords. 6 and 7, Shivraj Ballalli.
6 and 7, Shivraj Ballalli.
5 and 8, Mr. MB Kanvi.
5 and 8, Venkatesh Karvi, DSGI.
That is in 50 minutes, sorry, in 49. In 51, the respondents, additionally 1 to 4 and 9 is AGA.
1 to 4?
And 9 is AGA.
AGA.
Otherwise,
ಬರ್ಕೊಂಡ್ರು.
5 and 8, Mr. Karvi.
5 and 8, Venkatesh Karvi, DSGI.
And 6 and 7, Shivraj Ballalli.
6 and 7, Shivraj.
Same, Annexure P even in that.
Same order, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ order, yes.
Achha.
Kambi ಅವರ್.
Your Lordship, 107 of 107 petition under GST Act.
What is 107, madam?
Any person aggrieved by any decisions or order passed under this act or a Central Goods and Service Tax Act by an adjudicating authority may appeal to such appellate authority as may prescribed within 3 months from the date on which the said decision or order is communicated to such person.
Why is it rejected now?
Because there is a delay.
How many days?
1 year and 4 months.
1 year and?
4 months. 5 months.
5 months. What's the reason for delay?
Your Lordship, in the present case, the delay in filing the appeal exceeded permissible conditions. Period of 1 month beyond the statutory timeline. As such, the undersigned lacks the jurisdiction to condone the said delay. Consequently, for the aforementioned reasons, the appellate cannot be entertained.
What to do?
Please, Your Lordship, it's my first submission, tax matter. Your
I would
Lordship,
have done it that way. I know it's a first submission, so I let you make your submission.
Yes, sir.
All right, goody.
Covered by judgment.
What's your name?
Amrita.
So and so appearing for the petitioner. Same order. Give that. Yes.
52.
Allowed. First case allowed.
Grateful.
Yes.
Much obliged.
52, man. There's a challenge to income tax proceeding. Man. The sanction which has been done prior to reassessment is unsigned. Man.
Remand.
No,
Stay
this may
may
not
be
be for
granted,
stay
my
because the
Stay cannot be granted.
Stay may be granted.
the sanction is unsigned. Man. And what
No
is
problem. That's why when she's there, she's fair. The Termination Rupa?
Yes, my lords.
Council M. Termination Rupa accept notice for the respondents. The petitioner to serve set of copy, madam. Copy, yeah.
Copy there.
Oh,
I'll serve
yeah.
again one more copy.
Petitioner to serve set of papers upon the council, if not already served. There shall be an interim order of stay as prayed for on this score that the learned of score the contents of the petitioner that the order itself is unsigned.
The sanction is answered. At annexure
Sanction
B.
letter, huh?
At annexure B, my lords.
Sanction letter at annexure B stands unsigned. Yes.
Much obliged.
Yes. 4:30 ಆಯ್ತಲ್ಲ. Correct, ತಗೊಳ್ಳಿ ಅದು ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
My lord. 230 mode list, serial number 1.
ಸಂದೀಪ್ ಹುಳುಗೋಳ್. ಏನಿದು?
Just identical to 49 and 50, my lords.
Same.
The GST matters. This
ಅನ್ಪೂರ್ಣ. 49,
the respondents
50
would
same.
differ, my lords.
Respondents different. ಅದೇನೇನು ಹೇಳಿ?
My lords have WP 109264, my lords.
I don't have.
Oh, sorry.
I have 49, 50 ಹೇಳಿ.
Same annexure.
ಅಲ್ಲ, respondents ಯಾರು ಹೇಳಿ?
Yes, my lords. 1 and 2.
Oh, this is 109264 writ petition.
Yes, 109264 ಅಲ್ಲಿ 1 and 2, 4 to 6 and 8 is Shivraj Ballali.
ಬರ್ಕೊಂಡ್ರು ಮೇಡಮ್.
1, 2, 4 to 6 and 8, madam. 3 and 7 is the learned ASG, madam. 9 is the learned AGA.
ಅಷ್ಟೇನಾ?
2, 6, please. ಅಷ್ಟೇ.
ಆಮೇಲೆ
2, 6, 7 ಅಲ್ಲಿ madam. 1 to 4 and 9 is AGA. 5 and 8 is ASG, madam. 6 and 7 is Shivraj Ballali.
ಅಷ್ಟೇ. Yes.
All in the same petitioners case.
ಮೃತ್ಯುಂಜಯ ಹಳ್ಳಿಕೇರಿ.
Serial number 3.
Much
Mr. J. Saligiri.
I am appearing for the petition.
ಏನ್ ಎಲ್ಲಿ ಇದು ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್
ಸಾಯಿ ಓನ್ಲಿ
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯಾ? ಪೀಸ್ಫುಲ್ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
My lords, kindly see, they are seeking, my lords, the modification of the circular. For that, my lords.
ಸರ್ಕ್ಯುಲರ್ ನಾನು ಸ್ಟೇ ಮಾಡಿರೋ ಸರ್ಕ್ಯುಲರ್.
ಅಲ್ಲ.
ಮತ್ತೆ
18/12/2022.
ಬುಲ್ ರೇಸ್?
Not in this petition. We are not seeking anything in this.
When is your race?
Day after tomorrow. Day after tomorrow is the protest.
ಏನ್ ಕಂಬಾಳನ ಏನಿದು?
It is not a race, it is only a protest. Annexure D may kindly be seen. Annexure D.
I am
In page number 33. This is representation given to Deputy Commissioner saying that, my lords, they want to agitate a protest.
ಹೋರಿ ಹಬ್ಬ ಹೋರಾಟ ಸಮಿತಿ.
Yes.
ಯಾವತ್ತು ಶನಿವಾರನಾ?
ಶನಿವಾರ.
ಸಂಡೇ.
6th, my lord.
6th,
6th, my lord. 6/12.
Yes, government.
Am I audible, my lord?
Yes, sir, you are audible.
Okay.
ನನಗ್
Yes.
The
Lord,
Deputy Commissioner already.
Sorry.
My lord, what development has happened is after we moved the petition, today they have held a meeting with the Samiti and they have said we will permit you provided you follow these 14 conditions. My lord, we are agreeable to follow all the 14 except one. That is at serial number 13. I would request my learned friend to pass on that letter, my lord.
This is 4/12.
Kindly have a look at item number 13, my lord. 1-3.
No, I'm extremely sorry, my lord, sir, that my apologies, my lord. I'm sorry.
Kindly have a look at that item number 13, my lord. That's the only contentious issue now between us and the government.
ಯಾವುದೇ ಪ್ರಾಣಿಯನ್ನು ಏನಿದು?
ಯಾವುದೇ
ಪ್ರಾಣಿಯನ್ನು ರ್ಯಾಲಿಗೆ ಬಳಸಿಕೊಳ್ಳುವಂತಲ್ಲ.
That's all.
ಪ್ರಾಣಿಯನ್ನು ಬಳಸಿಕೊಂಡಲ್ಲಿ ಪ್ರಾಣಿ ಹಿಂಸೆ ಕಾಯ್ದೆ 1960 ಅನ್ವಯ ಪ್ರಾಣಿಗಳ ಮಾಲೀಕರ ಹಾಗೂ ಅಪಯೋಜಕರ ಮೇಲೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು.
This is the only
ಪ್ರೊಟೆಸ್ಟ್ ಅಂತಂದ್ರಿ ಮತ್ತೆ?
ಅಲ್ಲ ಅದೇ
ಪ್ರೊಟೆಸ್ಟ್ ಪ್ರಾಣಿ ಯಾಕೆ ಬಳಸ್ತೀರಾ?
Protest is in relation to Hori Habba, which they want to prohibit. We have all kettles and that is the way we want to protest. My lord, and kindly have a look at this Prevention of Cruelty Act. It is absolutely not applicable at all, even in terms of this. This is only a pressurizing tactic, my lord. So therefore, we have given a representation along with bulls and bullock carts. We want to protest.
Along with bulls?
and bullock carts. Yes,
Bulls and cows. Yes.
on 6th, day after tomorrow. So with that condition, my lord, we may be allowed, and the organizers will take care of all the animals which have come there. It is our responsibility.
ಬುಲ್ಸ್ ಅಲ್ಲದೆ ಬೇರೆ ಏನ್ ಅನಿಮಲ್ಸ್ ತಗೊಂಡ್ ಹೋಗ್ತಾ ಇದೀರಾ ಈಗ?
ಇಲ್ಲ, except bulls and bullock carts, nothing else.
ಸರಿ.
Because the whole agitation is for bulls, the festival, bull festival and bull competition. So far as Kambala and Jallikattu, they support. When this issue comes up, we are facing this issue. So therefore, the lordship.
ಲಾಸ್ಟ್ ಇಯರ್ ಪ್ರಾಬ್ಲಮ್, ಲಾಸ್ಟ್ ಇಯರ್ ಇತ್ತಾ ಇದು?
ಇಲ್ಲ, ಈ ವರ್ಷದಿಂದ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Though the circular is of 2022.
All right.
We are ready with the circular also. We have requested few changes. That's all.
All right. I'll pass out this tomorrow at 10:30. ನಾಳೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ತಗೊಂತೆ.
Grateful, my lord.
Grateful.
Number 4, Saurabh Hegde.
Lord, petitioner avails.
We'll post it on 5th January.
No, my lord. Attachment warrant is issued. That's it. Lord, the petitioner avails a loan of rupees 4,50,000 for our education.
ಎಲ್ಲ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದೀರಾ?
Entire amount is cleared. 4,50,000 is
Petitioner shall serve on the council who represents the respondent in the trial proceedings and file an acknowledgement of such service by the 12th of December, list the matter on 8th January. There shall be an interim order as prayed for till the next date.
Great.
On the score of the submission that the petitioner that against the 4 lakhs loan of educational loan of against educational loan of 4 lakhs
50,000.
4,50,000, the entire amount along with interest is long ago paid. Yes.
Under joint memo before Lok Adalat.
Under a joint memo before the Lok Adalat, to which the decree holder is also a signatory.
Great.
And notwithstanding, the same has sought to initiate proceedings against the petitioner. Yes.
Interim.
ಅದು ಫಸ್ಟೇ ಕೊಟ್ಬಿಟ್ಟೆ, ಆಮೇಲೆ ರೀಸನ್.
Great.
Kiran Kumar Chettimat.
Vota.
Please,
Take it. Yes.
for hand delivery models.
Take it. Yes. Next.
I may be directed to take notice for this.
ಅದು ಮಾಮೂಲಿ ಮಾಡ್ತಾರೆ ಬಿಡಿ, ಅವ್ರಿಗೆ ಗೊತ್ತೀಗ. ವೋಟಿಂಗ್ ರೈಟ್ಸ್ ಅಂದ ತಕ್ಷಣ ಅವ್ರು ಯಾರ್ಯಾರು ನೋಟಿಸ್ ಅಂತ ಅವರು ಮಾಡ್ತಾರೆ. ರಾಕೇಶ್ ಗೊತ್ತಾನೆ? ನೋಟಿಸ್ ವೋಟಿಂಗ್ ರೈಟ್ಸ್. ಇನ್ನು ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ, ಆಗ್ಲೇ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿನ. ಅದೇ 4:30 ತಗೊಳ್ಳಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್.
Matter pertains to principal bench, serial number 2.
Yes. Appearing for the
Yes, sir.
association.
Yes, sir.
Please. Mr. Regla is there. So,
yes.
Basically because the challenge is to the virus of an amendment which has been made.
Yes.
So we understand the limited scope with which we can challenge it.
No, correct.
We are
But
challenging it.
earlier I had passed an order.
Lordship.
Of course, this would help scores and scores of advocates, and but we had done it. Apart from
Yes.
legality of the issue.
Yes, my lords.
Now, the
Lords,
earlier,
the
the
practicality of the issue is also this, my lords.
Yes.
Now, the expediency with which the registration of births and deaths, which requires to be which has to take place, has been emphasized, my lords, by various courts, including the Supreme Court.
Yes.
Now, without having the empirical data as to the extent of the proceedings or the time consumed by the executive magistrates in disposal of the matters of the kind, Lords, if this amendment is brought about, Lords, it infests itself with manifest arbitrariness, because the purpose with which the provision is made under 13(3) stands, Lords, virtually violated and vitiated and stands foul of the requirement of an
expedited. A detailed interim order in this while.
Yes, Lords have passed a very detailed order. Lords, the other question, my Lords, of course, is that at least this honorable court, my learned senior friend is having that one judgment, my Lords, they refer to the division bench judgment of Orissa High Court and another judgment of Madras High Court to say the procedure to be followed in respect of the matters under 13(3). Lord, that is reiterated at least in another 3 more judgments, my lords, of the coordinate bench, the latest being 2020, which said, in the nature of the procedure to be followed, though it does not expressly say so, this is a judicial order. This is a judicial order. Not the order which is being passed has to follow certain procedures, including notifying persons who may be likely or who may be interested in the outcome of the application filed under 13.3. That is the procedure which has been contemplated. This order has become final. This order, my lords, is not challenged. And as long as 13.3 is held, at least by this honorable court, as also, my lords, the various other coordinate benches and the division bench of Orissa High Court takes the view, then another question arises, my lords, if the nature of adjudication or the nature of orders to be passed is a judicial order, as has been held in the nature of the proceedings which is undertaken, then again the situation would arise, my lords, as to whether the judicial functions or per se a judicial order could be permitted to be passed by an executive magistrate. So these are the two questions which is arising for your lordship's consideration while considering the varies.
In addition to, please, in addition to what my learned friend put it, my lords, this honorable court coordinate benches, my lords, at the very inception, my lord, this when the act came, my lord, the question was the ambit of section 13.3. It was banned there, my lord, throughout. It was the power entrusted to the judicial magistrate. Initially, the first question came up for consideration. There was an attempt, my lords, despite the specific specification as judicial of the magistrate word, magistrate, my lord. They said we can entrust to executive magistrate.
Executive magistrate.
Please, my lord. And that question fell for consideration, my lords. May I pass on with kind permission, my lord, the various views of this honorable court and other high courts, my lords. This honorable court, way back in 1994, B.G. Gangadharappa, my lords, laid down the very wording in section 13.3. It wants a decision-making process, my lords, adjudicatory process, which is judicial act that can only be done by a judicial magistrate. It cannot be done by anybody else. This was with reference to the enactment as such. But one wording, my lord, in para 12 is it involves decision-making process, same is required to be decided by judicial magistrate, not by executive magistrate. The function to be exercised by a magistrate in section 13.3 involves appreciation or sifting of evidence. In this view of the matter, it has to be held that the magistrate of the first class referred to therein, it's only a judicial magistrate. So, my lord, a sifting of the evidence is involved in this process. And later, my lord, a second decision your lordship may kindly see, Munyamma, 2013. Munyamma versus Devegowda, my lords. There the question was, what is the procedure? Kindly appreciate, my lord, the act doesn't provide for the procedure.
Yes.
And therefore, this honorable court laid down, having regard to other decisions, my lords, of other high courts where procedure was laid down, my lords, they laid down that it should be after verification. And verification involves determination or testing the truth or the accuracy of the statements made in the petition. Therefore, magistrate cannot blindly direct entry of date of death. That was the case, my lords. What is the guideline was also set out. Since then, this guideline is being used, my lords. And it further said, all the interested parties must be notified. They should be heard. And a decision must be taken. And this process, my lord, of taking the decision, the word used is passing the order. It can only be a judicial order. And adjudication is involved, sifting evidence involved, my lord, and also.
So you mean to say it is not quasi-judicial, but
no,
judicial.
It's completely judicial, my lords. But at this moment, my lords, I should also say, my lord, it includes birth and death, involves a status of a party. Birth and the status regarding the date of birth, my lord, date of death, etc., my lords. There are several civil consequences involved. That's what this honorable court held on that case. Therefore, my lord, it's a serious matter to be decided not by any other executive magistrate. It can only be by a judicial magistrate. There is a judicial process is involved and a detailed procedure is involved. And also kindly appreciate, my lords, in some of the cases, revenue officers are given the power of practically that of some civil courts regarding attendance of witnesses, summoning the witness, etc. That power executive magistrate doesn't have, which only the judicial magistrate has. And recording evidence, etc. is there, my lords. It is not, that power itself not there in the scheme of CRPC or in the present BNSS, my lord. That scheme is not there. Kindly see, my lord, there afterwards, one more decision I have produced is list number 3. My lord, the Constitution bench of the Honorable Supreme Court, my lords. I am referring to this because is it an administrative act or is it a executive decision or a judicial decision, my lords? What is the parameter to be decided? There kindly see, it starts, my lord, from page number 16.
That was answering the role of a conciliation officer
Exactly.
and
exactly.
industrial tribunal.
Exactly, my lords. Exactly, my lords. But the judicial decision process, what it is,
Correct.
etc., is laid
See,
down.
FOC,
Yes,
it's a quasi-judicial procedure.
please, my lords.
Whether he calls the parties, talks
Yes.
to them, conciliation
Please.
happens, doesn't happen. The report of FOC is sent to the government
Exactly.
refers the matter to the industrial tribunal.
Please.
So that is the procedure. This
Please.
is quasi-judicial, that is obviously judicial.
Please, my
That is
lords.
what is said in this.
Exactly, my lords. In the process, my lord, their lordships laid down, my lord, what is meant by judicial. Some maybe has some trappings of judicial, but it's not judicial. I am using
It's
these.
quasi-judicial only.
Please, my lord. Now, my lord, this should be necessarily an order. Now, I am referring all this to again going back to section 3 of CRPC, my lords, which it says what can be done by an executive magistrate. It's only, my lord, executive acts or something which is administrative in nature or in the nature of administrative nature. It cannot be judicial at all. I have produced.
But what to do with Gujarat division bench?
Yes, now my lords, I have produced the decision of serial number 4 Gujarat, where they have
Division
taken
bench has
divergent. There are two decisions, my lords.
Judgment has dismissed, I mean, like Gujarat High Court has dismissed the challenge.
Please, 4 and 5, my lord, these are two decisions, my lords, where they are dismissed. It's my duty to bring to my lords kind.
Madras and
one is Mumbai, my lords.
Mumbai. Correct.
Mumbai. 5 is Mumbai, my lords. 6 is Gujarat. Both. And now kindly see the Gujarat reasoning, my lord.
Gujarat, there is no reasoning.
No reasoning. And kindly see the Mumbai reasoning also, my lords.
Mumbai has reason. Gujarat has.
Please, my lords. There, the reasoning I will beg to submit, my lord, is on a different plane. Now, my lord, before I venture into go to those reasonings, my lords, let us see the statutory provision itself, my lord. Your lordship has dealt with in the Sudarshan Biradar case in the first challenge, my lords, of the section 3 of the CRPC itself. That language has not changed, my lords, even after the BNSS.
BNSS language is not changed.
Not at all changed, my lords. So, my lord, the language is clear, my lord. What can be entrusted to executive magistrate is, they say, like licensing. This is what they say. And, my lords, law and order problems, impending danger, very imminent danger of law and order, those situations of 107 security proceedings, my lords, these are entrusted to executive magistrate. And now kindly appreciate this act. The legislature specifically used in section 13 shall pass an order, and order pertaining to birth and death registration. And that's only, my lord, a delayed exercise. Then they have to hear why there is a delay. Is it correct or not? And also, my lords, various courts and even the coordinate bench in the second decision which I laid upon, my lords, they say there may be fraudulent cases which has to be filtered.
But you tell me these two courts have negated the challenge.
I humbly beg to submit, my lord, that is this distinction between the powers of the executive magistrate and judicial magistrate not considered. And the
because the Bombay High Court notices my judgment in Sudarshan.
Yes, my lord. Yes.
My lord, may I submit on that point, my lords? In fact,
go to para 10 of Bombay High Court.
Please. It considers, my lord. But my lord's consideration at that time, my lord, the state amendment.
I said tail can't wag the dog, so I.
The state amendment. So what was considered that time was, my lords,
state cannot amend this government of India's regulations.
At that time, my lords, there was this question, my lords, of the import of section 3, executive magistrate, judicial magistrate, having regard to the Parent Act, and the power to amend that was never an issue.
No, that's all.
It was only.
See, that was an open and shut case.
Please,
but now the amendment is in place. Now,
please.
It
Now, my lord, I will come to one more aspect, my lord, at this stage. Before I proceed further, my lords, if my lord is pleased to permit me, my lord, that as far as the section 3 is concerned, the language, how it's very clear, that it doesn't permit any judicial function to be entrusted. The act itself does not. The procedure CRPC, which established the executive magistrate.
All right. Now we have challenged the vires of the act.
Please.
Now on this score, that it runs counter to what the CRPC indicates. Can it be held to be manifestly arbitrary? See, arbitrariness is one thing. Arbitrariness of a provision ipso facto cannot, can't say that I render the provision unconstitutional just because it is arbitrary. To undo or annul a constitution, it should be a little beyond arbitrariness, that is manifest arbitrariness.
Please.
So what is manifest arbitrariness? If the very look of it, you feel, yes, this is a provision that cannot be sustained sway the constitution. That is manifest arbitrariness, bigger arbitrariness.
Please, please.
So what is manifest arbitrariness here? See, Gujarat High Court holds, yes, it is not. The Bombay High Court holds, it is not. Task is Herculean. Now you should assist.
Please, my lords. May I submit like this, my lord? Shara Bano, the Honorable Supreme Court blazed a guideline, my lord, about manifestly arbitrariness, my lord. Please, there the question is.
Manifest arbitrariness is considered in that also.
Please, please.
If you go to Shara Bano,
please.
What is manifest arbitrariness is several paragraphs are dedicated to that. What is manifest arbitrariness? I have myself considered in the phone, the Xiaomi.
Yes.
And I have held it does not amount to manifest arbitrariness, those whatever the provisions that were sought. Now you should tell me.
We pray the Honorable Court to kindly look at this from this angle, my lords.
Can you import another statute into this to say that it becomes manifestly arbitrary?
First, our submission is this, my lords. The parent enactment which establishes the executive magistrates, it defines the powers.
Right.
Now, by virtue of another enactment, this power cannot be extended and which cannot go beyond the parent.
Now, which amendment is this?
This is under the Registration Act, Central Act. Registration Act.
It's amendment by the center itself.
Center itself. Without amending the original enactment, where the executive magistrate have been set up, my lords, and the powers are limited therein. And that provision, you lords may kindly see right from 73 and prior to also, and even now. Those powers are limited.
Fair enough. Can that be the reason for manifest arbitrariness?
No, my lord, we will straight away put it like this. This power cannot be entrusted to executive magistrate because the executive magistrate cannot conduct those proceedings under the parent statute. Their powers are limited. They cannot. There's one more, my lord. One more on this point, my lord. Apart from this, my lord. This question we also wish to canvass before, my lord. The principle of separation of powers, though in directive principles under Article 50, my lords, separate executive should be separated and the state shall take steps for separation, my lords. It has been consistently held that it is the duty of the state to see that they are separate. And that scheme also runs in CRPC, also in all the enactments pertaining to dispensation of justice. And this question fell for consideration, my lords, because there were divergent views of the Chennai High Court, my lords, on this point, whether the executive magistrates, my lords, they can punish in the powers under 117, and whether those powers can be given again to the police officers, etc., was the question, my lords. And there, the Honorable Court did refer to the division bench, my lords. Of course, it's persuasive. I beg to produce this because there is a discussion on this separation of powers, to what extent executive magistrates can be entrusted with the powers, my lords. May I pass on? I did not because it's little voluminous, therefore I have not appended to that list, my lords.
Yes.
It discusses, my lords, I will refer to the relevant page number with page 39, it starts, my lords. About after referring to the magistrate and executive magistrate, page 39, please, my lords. Page 39 refers to Ghulam Abbas, my lord, the decision of the Honorable Apex Court in page 43 about the intention, my lords, the how executive function, my lords, etc. And then
come to 46,
please. I'm grateful, my lords. Page 46, please, my lords.
Para 46.
Para 46, my lords, please. After separation powers, my lords, please, my lords. I'm grateful, my lords. The basis for the principle separation of powers is separation of functions, my lords, of judiciary from executive. And I will not read it entirely, my lords, and other Supreme Court decisions are quoted herein. So I beg to submit, my lords, and to one extent, the reasoning of the division bench is, my lords, if it's held that, my lords, there is the power of the judiciary or the judicial making process is sought to be entrusted to execute in any manner or to executive magistrate in any manner, that would be held to be arbitrary under Article 14. And that itself is sufficient to quash such a legislative exercise, my lords.
Yes.
And Article 50 is discussed there afterwards, my lords. And this Supreme Court's rulings on executive and judiciary, etc., my lords, etc., is given, my lords. Para 51.
That was interpreting 107 CRPC.
I do concede, my lord. I do.
107 CRPC, whether the power of the executive magistrate in drawing up orders would be akin to judicial or quasi-judicial.
Please.
The court, though 107 curtails movement and or imposes certain conditions,
Please.
the division bench holds it as quasi-judicial.
Please, my lords. Please, my lords.
So the power in separation of powers also, this executive magistrate, whoever has now been entrusted with, he cannot perform judicial functions.
Judicial functions.
That is your submission.
Please, my lords.
So if he cannot perform judicial functions, registrar of birth, the power should be with the court, because court obviously will perform judicial functions and all things akin to judicial functions.
Please, my lords.
That is his submission.
Exactly, my lords. Exactly. So judicial function is ought to be given to somebody who is powerless to do it.
No.
Please.
In one line, your submission is
yes.
Judicial powers cannot be given to a quasi-judicial authority.
Exactly, my lords. I would also make a distinction. Of course, there are a piece of legislation, my lord, where, for example, revenue authorities are entrusted with certain functions, my lord. But in those cases, those revenue authorities held to be courts. For example, the Karnataka Land Revenue Act provides it's a court.
They are held to be courts with power under CPC.
Yes, CPC, my lord.
So now this executive magistrate under this act is he given the powers of the CPC? No. For examination of evidence.
No.
In certain cases, examination of evidence also becomes imperative in register of birth and deaths. As you said, it creates a right or destroys a right.
Exactly.
Because there are many scores and scores of cases where, on the basis of the birth certificate or the death certificate, properties are changed, exchanged, everything. So it does constitute a right of some semblance.
Please, my lords.
So it should be a judicial or
please, my lords.
Judicial work.
And my lords, please, may I add also one more facet, my lords.
Yes.
As far as now it's laid down, my lords, established by series revisions the apex court. A piece of legislation, my lords, can be annulled by the honorable courts, my lords. But the legislature cannot annul the decisions of the courts, but foundation can be set aside. Please, my lords. I beg to add like this, my lords. The foundational facts, my lord, the honorable courts are consistent held. The power under section 13 involves
legislative invalidation is definitely permissible exercise.
Please, my lords.
Whether it amounts to contempt or not, or whether to undo a judgment or not, we'll have to see.
Please,
but you can't say the legislature has no power to invalidate an order. It should not be invalidation or undo the decision of a court. That is power of the parliament, sir.
Please,
power of the parliament and the legislature, which they can definitely
may I put it in this way, my lords? May I put it in this way, my lords?
Please. Invalidation should not touch upon it should not fringe on the borders of contempt. That is all that should be looked into. Power of the legislature, we can't take away to undo an amendment or whatever.
Please, constitutional amendments can be made, my lords.
Amendment, by way of an amendment, they can definitely undo a judgment. But it should, two things in that. One, it should not become contempt of court.
Please.
And the other is, it should not take away the rights that are already crystallized.
Please.
There are only two aspects where it has to be considered. Whether
please. No, I do put on, my lords. I was trying to
prospective invalidation.
Please, may I put it like this, my lord? In the considering the amendments to the tribunals, my lords, in Madras Bar Association.
Yes, Madras Bar Association.
Please, my lords. The Honorable Supreme Court laid down. We have already said it should be like this. You cannot, by amendments, you can do it, undo what we have said. But
let's see. Let's
please, my lords.
Hear the other councils.
Please.
Yes, Ravi Shankar.
Please.
Lords, Lords, there is something which is very conspicuous to the language employed under section 13(3). Lords, if your lords were to see the unamended provision as it then stood, Lords, the reference as it then stood, Lords, is that it shall be registered only on an order made by the first class magistrate or the presidency magistrate. Lords, now the word magistrate, as what was being dealt with, Lords, was conspicuously not referred to in the definition clause, but now by means of the amendment, what they did, they substituted first class judicial magistrate and the presidency magistrate with district magistrate, subdivisional magistrate or executive magistrate, and added a very specific explanation. This is very important, Lords, to say executive magistrate means the executive magistrate appointed under subsection 1 of section 20 of the CRPC. So now, the reason why I am submitting this is, there is a conscious effort under the parliamentarian legislation which clearly says that the authority or the entity to which these powers is conferred in terms of 13(3) is an entity or an authority which is referable to the Criminal Procedure Code or the authorities constituted under the CRPC. Now, further, my lords, if your lordships were to see the rule making power, which is very, very conspicuous in section 30 of the rule making powers, very critically, though it says that the state government may, with the approval of the central government by notification, make rules to carry out the purpose of this act, and in particular without prejudice to, does not make a specific reference to the procedure under 13(3).
So this is what I have written while
Yes.
granting the interim order.
Lordships, Lords, the moment there is a exclusion, I will not say that there is an express exclusion, but this is an implied exclusion where the state is not given the powers to contemplate the procedure in terms of 13(3) for the reason that the procedure to be followed in turn would be the procedure under the CRPC. The scheme of the entire statute as it was originally framed in 1969 itself was to be regulated by an authority or a judge who is constituted under the CRPC. Procedure also to be followed by following the same procedure as has been provided by, under the CRPC. Now, section 4.2, though deals with section 4.2 of the CRP says that if there is any other power vested with the magistrate for the purpose of inquiring or any other purposes, then the procedure under the CRPC has to be applied. What has not been considered, my lords, by the Gujarat High Court as also the Madras, as also because there are three judgments as your lordship said. One is the Madras High Court, the other one is Madras and Bombay. So far as Madras High Court's judgment is concerned, my lords, it proceeds on the basis that it is not necessary to follow the procedure under the provisions of the CRPC. If the order which is made is not deemed to be an order, then it is not permissible to maintain a revision petition under section 397. And then it goes on to say that it would not be therefore a judicial order in the strict sense. But if your lordships were to see, my lords, Muniyamma's case, which has been referred to by my learned friend, he has produced that judgment in Muniyamma's case. Lords, Muniyamma's case deals with a particular aspect, my lords. If your lordships were to see Muniyamma's case, this is followed, my lords, at least in three judgments of the coordinate benches. But in Muniyamma's case, there is a reference under para 17 to 13(3). Then para 18 makes a reference to what should be the contents of the application, but this is important. If the application contains the particulars, I'll just read, my lords, para 17. Therefore, the applicant has to state at least the following particulars in the application filed under section 13(3) of the Act. Entering the date of death, reasons and grounds, purpose for which he wants the entry, wife and children of the deceased should be made as parties, particulars of the persons who are likely to be affected by the entry in the death register. The magistrate can also direct the applicant to furnish such other particulars. If the application contains the above particulars, magistrate should not only issue notice to the respondents, but also to the persons who are likely to be affected by the order. He should also direct the issue of notice in two local dailies newspapers. One of them should be in vernacular language having wide circulation. Magistrate may also issue such other directions as he deems fit and proper depending on the circumstances. He should hold an inquiry and pass appropriate orders thereon in accordance with law. If there is a serious dispute with regard to the date of death, magistrate has to dismiss the petition with liberty to the parties to approach the civil court for appropriate reliefs. As has been noticed above, the first respondent is 5 minutes. I'll skip this. And can I pursue your lordship? May kindly come to para 16. Notes where the division bench of Orissa High Court says that it is an onerous duty on the magistrate to verify the correctness of an order and pass an order.
Oh, that's what I
there are
also.
two more judgments of the
I feel.
Yes.
But two high courts have held otherwise after referring to my judgment also.
Yes, my lords. As a matter of fact, para 15, if your lordships were to see, my lords, this is of course by a learned single judge as it appears, refers to a judgment of a Gujarat High Court. Lords, where
Other division bench. Bombay High Court is also a division bench.
Please. So this Gujarat High Court judgment referred to in
one
para 15.
Factor is,
lordships.
Bombay High Court judgment did not deal with this. It was dealing whether at the fag end of service one can.
Yes. One can get yes.
Yes, that was the issue before the Bombay High Court. These incidental observations are made.
Yes. Even the Madras High Court, Milords, which did it, was considering as to whether 397 could be maintained or not. In that context, it said that it can't be treated as an order.
High Court. Gujarat High Court.
Even there is a judgment of the Madras High Court which dealt with this issue in 2020, which said that you cannot file a revision petition. But now there are certain orders which are passed by this honorable court, my lords, at least 4 judgments I have, which clearly indicates, my lords, that this is the kind of powers which are
No,
exercisable where it
last
may even
time,
become adversarial.
no, last time what happened was, there was an illustration, I think, in the file. The assistant commissioner had issued a certificate, birth certificate of a person who had died 10 years ago.
Yes.
Or a death certificate
Death
of
certificate, my lords,
whom the person was
was
still
still
alive.
alive. Yes,
He
that
was
was
still
the one, my
alive,
lords. He was
and
still
his
alive.
son, on the basis of that death certificate, goes on
Had already
converting
got, yes.
properties to himself.
True.
That was one of the
That was the
illustrations that
illustration.
I found. Yes.
Yes. Lords, now the reason why we are submitting this is, if your lordships were to see the scheme of the act as has been understood by the coordinate bench of this honorable court, first, there is a requirement of the registration section 10, section 13(1). If there is a delay, they will have to go to the magistrate. Then what is that the magistrate is going to do? He is going to ask for all these particulars and give notices to those parties who are likely to be affected by the virtue of a direction
No,
being
Ravi
issued under
Shankar sir, it is
13(3).
as simple as that, whether it should be a quasi-judicial function or a judicial function.
Yes.
If it is a
Now,
quasi-judicial function, yes, the executive magistrate can do it. If
yes.
if the court was of the, to be of the opinion that it's a judicial function, obviously a court should hold.
Because the moment it is a judicial function, then the doctrine of separation of power comes in. Para 151 millards of the 4th judge's case, it said
Yes.
that separation of powers is a basic structure of the constitution which cannot be
Correct.
meddled with by a parliamentary action. Lords, if your lords were to see section 20 millards of the act, because the executive magistrate under the explanation is the one who is appointed in terms of section 20 of the CRPC. Lords, it only says in every district and every metropolitan area, the state government may appoint as many persons as it thinks fit to be executive magistrate and shall appoint one district magistrate. Then, whenever in a consequence of the district magistrate becomes vacant, I'm sorry, Lords, the state government may place an executive magistrate in charge of a subdivision and may relieve him of the charge of the occasion requires the magistrate so placed in charge of a subdivision shall be called subdivisional magistrate because it's a subdivisional magistrate. Now, the state government may by general or special order and subject to control and directions may fit impose delegate powers under subsection 4 to the district magistrate. Lords, if your lordships were to see the scheme of the act of the executive magistrates and the nature of the powers conferred under the scheme of the CRPC, the reason why I am submitting this is there is a purpose with which the executive magistrates are conferred with these kind of powers and the constituted under the CRPC. Lords, now if this is virtually like an incorporation, there is a reference to the provisions of the CRPC which enables this honorable court to look into the provisions of CRPC by means of incorporation, which clearly spells out the dichotomy between the manner in which the executive magistrates has been constituted to function under the CRPC and the judicial magistrates. Wherever there is an adjudicatory process which is involved, sifting of evidence, even to the extent of issuance of the notices to the adversaries and deciding the questions. This is something which will be a judicial exercise of power, which is not there, Milord, so far as the only where there is an issue of law and order. Milord, as my learned senior friend said, 107 proceedings. See, these are the kind of matters where there is some semblance of powers vested with an executive magistrate, but the object is to ensure that the law and order situation is taken care of, not for the purposes of ensuring that there is some dispute is resolved. Resolution of a dispute of the kind is essentially and always a judicial function. The moment we say it's a judicial function, then the second
No,
aspect,
that is
which I
precisely
said,
what I had held in my
yes,
judgment.
that's not the second aspect which I wanted to bring to your lordship's notice is, lords, no, the manifest arbitrariness, what your lordships is referring to, my lords, I would put it this way, my lords. If they are the object of the statute under 13(3) is to ensure that there is an expedited adjudication or expedited disposal of the application seeking registration of births and deaths. This is having far-reaching consequences and having civil and evil repercussions in the event of there being a delay. The
No,
latter being, yes.
that I'm aware.
Notes, the reason why I'm submitting this is, if they did not have the empirical data, notes, manifest arbitrariness is on account of the fact that if you don't have the
No,
relevant data
Ravi
for the
Shankar sir,
purposes of,
manifest arbitrariness cannot be presumed.
no,
The whole
certainly
issue
not,
is
my lords.
that.
Not a question of presumption, but the basic foundational data which was required for the purposes of instructing or ensuring that such an amendment is brought about is not with the government. then where is any question of the government's application of mind for such substitution, more particularly judicial power? Arbitrariness is essentially lack of application of mind, which is required for the concerned act.
No, non-application of mind cannot become manifest.
Non-application of mind for the concerned act, if this is completely lacking, then where is any question of a legislation being justified by the government? Because the government should come and justify the reasons for which it has been done.
We'll hear the government.
Lots.
Vivek Reddy sir, ನಿಮ್ದೇನಿದೆಯಾ?
One
just
sentence
one
my lords, to
point.
add there only. One sentence to what my learned friend Shri Ravi Shankar is adding, my lords. Subsection 4, one sentence in section 3, subsection 4, my lord. CRPC, it says, where under any law, word used any law, where under any law other than this code, the function exercised by the magistrate relates to matters A, which involves the appreciation or sifting of evidence, or the formulation of any decision, etc., which exposes him to any punishment, etc. So, under any law means, even the subsequent enactments are also included in this. This is the source of power, my lords.
Any law, subsequent act.
Yes, under any law. Now, under this law, my lord, the power is now
Any law
given to
under existing law.
Now, my lord, this is by amendment, my lord. The only change is section 13. The foundation, everything is same. Scheme is same, my lord. And may read one sentence in subsection 3 as it should earlier and now. Only thing is about judicial magistrate and executive magistrate.
No, that I have seen.
And subsection 3, my lords, it says he shall give the decision, my lords, by an order. By now, earlier judicial magistrate is now by the executive magistrate, having jurisdiction over the area so and so, comma, after verifying the correctness of the birth or death, etc. Now, my lord, decision, then verification. All these have been subjected to judicial decisions, my lords. Effect is laid down. That has not changed. Only thing is, executive magistrate is incorporated into that, which cannot be done. It runs counter to section 3.
We'll hear the.
Please.
Lord, only one point I'd like
Vivek
to add.
Reddy sir.
Yes, only one point I'd like to add to what Ravi Shankar sir and PP Hegde sir stated. Now, Lord, in all circumstances, the decisions made by, when we read Muniyama case and the Orissa case, the decisions made by these, the officer under section 13, whether judicial or executive, would be decision made in adversarial circumstances also, because
Could be sometimes, yes.
Yes. Now, Lord, in those circumstances, can these decisions be made without evidence or without basic understanding, without permission to cross-examine? Because the true test of trial is where there is cross-examination and the trappings of a court are there. And only then in those circumstances can we say that there is a judgment by judicial courts. So in circumstances of adversarial models, which we have adopted, which is the basic structure, concept of courts that we have adopted, adversarial models, where each party is allowed to contest and make adversarial challenges, then apparently such decisions can only be made in judicial courts, and it cannot be given to assistant commissioners. Now, not for simple, even in revenue courts, can an assistant commissioner ask a party to read evidence and prove a point of fact? He cannot. He will only have to refer it to a civil court for decision on civil issues. This is what was contemplated in Muniyama's case, because one person died in 1979. Point was, when did he die? Because sale deeds were executed after his death or before his death. That was the issue that was
I
involved.
also gave you an instance.
Yes.
That a death certificate is issued.
Yes.
Of the man who is alive.
Of a man who is alive.
A man who is alive by the assistant commissioner.
Assistant commissioner. And
when it was asked, they say it was a mistake done by them. ಅದನ್ನ ವಾಪಸ್ ಏನೋ ತಗೊಂಡ್ರು ಅಷ್ಟೊತ್ತಿಗೆ 10 hands change ಆಗಿತ್ತು ಪ್ರಾಪರ್ಟಿ.
10 hands change ಆಗಿತ್ತು. Therefore, my lord, they are not the persons who can decide these point in facts. I would just make one reference to the Madras Bar Association case, where apparently this position has been contemplated, and what they have stated is really relevant to the questions here. It says, take for example, where the executive was in charge of administration acts to a prejudice of citizen, and a question arises as to what are the powers of the executive and whether the executive had acted within the scope of his powers. Such a question obviously cannot be left to the executive to decide for two very good reasons. Firstly, because decision would depend upon interpretation of the constitution or the laws,
which are preeminently fit to be decided by the judiciary, as it is the judiciary alone which would be possessed of the expertise in decision making. And secondly, because the legal protection afforded to citizens by the constitution of the laws would become illusory if it were left to the executive to determine the illegality of its own actions. Take, for example, a case where legislature makes a law, not all this can be left. So finally, what was reiterated in this judgment is that tribunals and members in the tribunals, or if they are given to individual members in the administration for decision making, they will not be impartial renderers of judgment. They will not be impartial persons who can give judgments on these aspects, on these points of fact. Therefore, if we look at the conclusions in the Madras Bar Association case, it is clearly evident, para 63(7) lot. It says the members of the tribunals discharging judicial functions could only be drawn from sources possessed of expertise in law and competent to discharge judicial functions. Technical members can be appointed to tribunals where technical expertise is essential for disposal of matters and not otherwise. Therefore, it was held that where adjudicatory process transferred to tribunals did not involve any specialized skill, knowledge, or expertise, a provision for appointment of technical members would constitute a clear case of the encroachment upon the independence of the judiciary and rule of law. The stature of the members would constitute the tribunal would depend on the jurisdiction which was being transferred to the tribunal. In other words, therefore, Lord, on the question as to whether this is a quasi-judicial function or a judicial function, if determination of these facts involves judicial application of mind based on evidence, and there is a need to take evidence, then it is purely a judicial function. And there are gray areas between quasi-judicial functions and judicial functions. Where they overlap, I think the judiciary must jealously protect the
Quasi-judicial
city.
functions, determination of rights of parties is a judicial function.
Yes, absolutely.
Now, does the executive magistrate under the Act determine determine the rights of parties there, or just issues a certificate? Now, issuance of that certificate, if it cascades into destroying the rights of parties, will that provision become arbitrary?
It will.
For it to be held to be unconstitutional.
Yes, Lord, because as you Lord, if suppose determination per se involves certain other legal heirs who raise a different dispute on the date of death, this honorable court has said that even children can be.
If this document itself becomes a foundation for determination of parties before any court of law,
yes,
whether this should be a judicial process or a quasi-judicial process,
this should be a judicial process.
Is what is to be considered.
Yes, this should be a judicial process, and sometimes rights flow direct. It does not go to courts on this point, blood.
No, there are two things.
Retired employees or employees who are the legal representatives. Yes.
No, there are two things. Both Ravi Shankar sir and Vivek Reddy. There are two things.
Yes.
See, a provision in its interpretation snowballing into a problem later within the contours of the Act will not make it arbitrary.
Correct.
Now, a provision having cascading effect outside the provisions of the Act, intruding into the rights of the parties,
absolutely.
Then yes, it will. It perhaps can have the color of arbitrariness.
Yes.
Then we'll have to consider that.
Yes, and the second scenario, Lord, which your lordships pointed out, it clearly overlaps, intrudes into the judicial function, because a determination made by the executive magistrate here will have a cascading effect, number one. Second, will have immediate civil consequences of rights, of various other rights. It may be pensionary rights, rights of properties, various other rights that could ensure. Unless, Lord, we are a country like China where there is no succession. Any date could be determined. So China succession ne illa. Antadidre, it's okay. But here, our whole rights are based on inheritance, succession laws. Just an analogy, Lord. Yes. Just, I just wanted to add this, of course, I don't say that this is something into the, I just wanted to visualize a situation where, for the purpose of compassionate appointment, I want a certificate which I have not registered for some reason within this 1 year. ಅಲ್ಲ ಈಗ 1 ವರ್ಷ ಆದ್ಮೇಲೆ ನಾನು ಏನಾದ್ರೂ ಹೋಗಿ ಈ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ
ನಂದು ಸೂಪರ್ ಅನ್ಯೂಷನ್ ಏಜ್ಗೆ ಅವರು ನಮ್ಮ ಅಪ್ಪನ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾರೆ.
ಅಥವಾ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನೋ ಕೊಟ್ರೆ ಬೇಗನೆ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಅಲ್ಲ ಅದೇ ಈಗ ಸಮಸ್ಯೆ ಏನು ಅಂತಂದ್ರೆ, this is something which I cannot express.
No, that is not, because we are
These are the
like
kind of entities where the process does not take place on a daily basis. This is something which I wanted to emphasize. Yes. An executive magistrate is not sitting on a daily basis to conduct the court proceedings.
If it is before a judicial officer, every day he can take it.
He is sitting there from 10 to 5 minutes. Your Lordship is sitting up to 7 o'clock. Some magistrates are also sitting up to 6:30 to attend to these matters. These are the kind of.
You say everybody should follow, my lords.
So, now these are all the kind of machineries which are available for an expedited hearing, and the magistrate is always available. Now sessions is going on, the assistant commissioner is not available, minister's visit he is not available,
certificate sigalla, death certificate sigalla ಈಗ
ಇಲ್ವೇ ಇಲ್ಲ. ಅದೇ ಹೇಳ್ತನಲ್ಲ, ಸೂಪರ್ ಅನ್ಯೂಷನ್ ಏಜ್ಗೆ ಆ ಟೈಮ್ ನಲ್ಲಿ ನಮ್ಮ ಅಪ್ಪನ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಿಗತ್ತೆ, ಅವಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ ಆಗೋದಿಲ್ಲ. ಆ ಪರಿಸ್ಥಿತಿ ಆಗ್ಬಾರ್ದು. These are the kind of things where it requires an expedited consideration, and the judicially trained mind is the best suited for the purpose of sifting the materials placed before him, because this is having civil consequences as to either the registration of the birth, the date on which the birth is to be registered, or the date on which the death is to be registered. Some consequences flow out of this, and these are the kind of matters, which is best kept with the. Of course, we cannot substitute the wisdom of the parliament in saying what is best suited. I am certainly not saying that. But what has to be considered is that if these basic aspects is not gone into or not taken into account, or this is not the reasoning with which the government comes up with, then this legislation is like a stillborn legislation.
And Lord,
Madhya Pradesh High Court, in 2022 again, there is one more judgment. This is again by a division bench judgment.
The list of authorities ಎಲ್ಲ ಒಂದು compilation
ಮಾಡಿ notes ಮಾಡ್ತೇವೆ. But one last point I'd like to make is that in Madras High Court judgment, first Madras Constitution Bench judgment, Madras Bar Association case, they laid down the constitutional standard laid down was that this area of judicial adjudication must be jealously guarded. And that is why, my lord, it becomes all the more necessary to prevent any sort of an encroachment or invasion by
the parliamentary amendment,
or by independent persons to substitute the adjudication.
Advocates appear alva.
This is the important aspect we wish to canvas, my lords.
Practically,
this is legal point of it. Now there are many advocates practicing before the courts with regard to these issues itself.
Yes.
This emanates from Article 21 and also 14 of the clients also, my lord, to get justice.
Now, I have in one judgment held, interpreting, following other court, interpreting the Senior Citizens Act, where I permitted advocates to appear.
In the, yes.
Advocates
we have
to
the
appear.
judgment. Yes.
There I have drawn from Article 21.
I'm grateful your lordship is going on. Please, my lord.
I have already held.
Please, my lord.
Why right to profession, right to practice flows from Article 20. ಅದೆಲ್ಲ ಬರ್ದಿದ್ದೀನಿ ಅದರಲ್ಲಿ. That is one judgment.
We will
take it out. Yes.
Please, my lords.
I permitted the Senior Citizens Forum, Assistant Commissioner ಮುಂದೆ the advocates were not permitted.
Please.
So I passed an order permitting them. I think government has also passed a circular after that.
Now, my lord, this as far as the executive magistrates is concerned, it's completely zero. Practically it is zero.
ಯಾರು ಇಲ್ಲ.
Well, practically it is zero, no sitting, etc. And my lords, the law also, there is no scheme how they should function. My lords, in addition to what my senior friends submitted, my lords, now we will call out 2 paragraphs, my lords. I was trying to put this point, my lords, that your lordships, my lords, rightly put it, my lord, that legislature can always overrule the judicial decisions by way of an amendment. But one para, my lords, I beg to read the recent view, my lords, as per the Consumer Protection Act, for example, my lords, the tribunals, they went on amending, despite, my lords, the court's verdicts that it should be like this. The persons who man the tribunals must be this.
It is not there. Right from 1995, Supreme Court has gone on telling that to undo the effect of the court's order, if you invalidate, if you bring in a legislation to make this invalid, it amounts to contempt.
Exactly.
That is what the Supreme Court has held. But
Please, my lords.
both ways. If you see,
Please,
now
please.
BK Pavitra 1 came. To undo BK Pavitra 1, an act was notified on 23/6/2018 because this BK Pavitra 1 was rendered on 9/2/2017. 23/6/2018 comes an enactment. That is again subject matter of challenge in BK Pavitra 2 before the Apex Court. The Apex Court upholds it. Yes, it is the power. But rights crystallized between those dates should not be taken away is what is said. That's a detailed judgment by Justice Chandrachud.
Please, my lords. I wish to also put forth, my lords, as for the Consumer Protection Act, the Supreme Court said it should be like this. And they brought certain amendments, my lords, which was again struck down by the Supreme Court. They said is an attempt to overreach our previous orders. The foundation within which judicial process should function, we have laid down. That cannot be defeated. And same principle
What is that to defeat the orders passed by this court? They have
yes, this honorable court, my consistent section 13, my scheme is same, purpose is same, decision making process which they said it's the same. Now all the honorable writ courts laid down, my lords, throughout the country that it is a judicial process as far as 13 is concerned. Now, my lord, that is not undone. What they do is indirectly they undo it, stating that executive magistrate will function, will take over this. They can do it. I respectfully submit. The legislature can do it, provided they amend the original section 3, subsection 4 of the CRPC and say hereafter executive magistrate can also be entrusted with it.
Yes, Suni Krishnan sir, half-hearted amendment arbitrary. Yes.
My lord, Nanu solve martini, then I can complete it. But my lord, I am actually in
Don't
some
worry.
other advocate.
You are in your office. You are in your office.
No, I'm
I
not.
am in the court.
I'm not,
7 o'clock.
No,
Yes.
I'm not in my office, my lord. I'm in another counsel's office. So
Sorry. All right.
I'm using his facilities and my lord, it is like this, my lord. This particular amendment substituting the judicial magistrate with executive magistrate is executive magistrate is not the only amendment brought in by this particular enactment, my lord. My lord, could I take my lord to I'll have to take my lord to section 1, which says the act may be called the Registration of Births and Amendment Act 2023. Then, my lord, in section 3, it says, it shall come into force in all the states on such time as the central government may by notification official gazette appoint. So, my lord, main objective, my lord, is to have a pan-India common birth certificate portal, or rather say a database, my lord. Then, my lord, there's a section, my lord, the insertion of new sections at subclauses in section 2, my lord. It defines what is an abandoned child, the meaning of an abandoned child, an orphan child, a surrendered child, child care institution, adoption, disaster, Aadhaar number, specialized adoption policy, and executive magistrate, etc., my lord. Now, my lord, then 3A, my lord, would be very, very important. It says a Registrar General of India, my lord, for the first time, my lord, a Registrar General of India, my lord, has been appointed. He would be the head of all the registrars of all the states. He shall maintain a database of registered births and deaths at national level that may be used with the approval of the central government to update population register prepared under the Citizenship Act 1955, electoral registers of electoral rolls prepared under the Representation of Peoples Act, the Aadhaar database prepared under the Aadhaar Act, ration database prepared under the National Food Security Act, passport database prepared under the Passport Act, driving license database under the Motor Vehicles Act, etc., my lord. So, my lord, the objective of this, my lord, is not just to take away the powers of a judicial magistrate and confer it upon an executive. The objective is far more reaching because, my lord, there needed a date of birth which could be used by other authorities as well. So, my lord, if one judicial magistrate is given a power, my lord, he will not be in sync with the entire executive chain, my lord, up to the top. One Registrar General of the country cannot ask a judicial magistrate for data, which can only be done by a executive person or executive magistrate. Now, my lord, they say that this executive person, magistrate, my lord, he hardly sits in our. My lord, under the Act and rules, an executive magistrate can be appointed full time for this. They are making comparisons to DC and AC. Yes, it would happen. My lord, the need of the hour.
We will ask the state government to classify Assistant Commissioner within bracket births and deaths.
Is this under section 30, my lord? Under section 30, they are in order to, my lord, implement the provisions of this act, they can also have a full-fledged executive magistrate.
Separate ಮಾಡ್ಬಿಟ್ರೆ ಒಳ್ಳೇದು.
ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದು.
Assistant Commissioner birth, Assistant Commissioner death.
ಇರ್ಬೋದು ಸ್ವಾಮಿ.
ಇದು ಈ ಪೋಸ್ಟಿಂಗ್ ಯಾರು ಬರೋದಿಲ್ಲ ಅಷ್ಟೇ. ಅಸಿಸ್ಟೆಂಟ್ KS ಆಫೀಸರ್, ಸೀನಿಯರ್
what I bring to, what I would like to bring it to the notice of this honorable court is, it is not as if, my lord, now at present, my lord, the DC, AC and all that, I understand, my lord, half the time they are not sitting. I concede everybody, all of us know practicing.
ನಿಮಗೂ ಗೊತ್ತು, yes.
ಎಲ್ಲರಿಗೂ ಗೊತ್ತು. But my lord, there
separate
can
post, AC death, AC birth.
Or probably, my lord, of the same rank as sub-registrar, like how he is also the registrar of firms. A sub-registrar can also be done, or a Cooperative Societies Act, sub-registrar acts also as a cooperative, he was a registering authority. So, my lord, it can also be given to them. Now, my lord, now, my lord, there are a sea of changes, my lord. It is with this objective and not just to have, and then, my lord, there's one other important thing, my lord, the Aadhaar details of parents and informants to be brought forth, then connecting the database all over, my lord, electronic certificates. These are also one of the objectives. Now, my lord, today, as my learned senior friends were submitting, it is so difficult, my lord, to get a birth certificate, death certificate, etc. Now, all that you need to do is sit in your office and just type of a button, click of a button, you will get this database. Now, all these are the objectives, my lord, in keeping in view of the modernity, etc., my lord, that these changes were brought in act. Yes, my lord.
Yeah, the most dangerous thing is adene click of the button, somebody is dead, somebody is taken birth.
Lord's inheritance takes
My
place before death.
my lord, it is like this. We are all humans, my lord. We are all fallible, and then it can happen.
ಈಗ ನಾವು ಕೊಡ್ಬೇಕಾದ್ರೆ ಡೇಟಾಬೇಸ್ ಸ್ಕೀನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ at the click of the button ಬರುತ್ತಲ್ಲ, ಅಲ್ಲಿ ಬರ್ತ್ ಬದಲು ಡೆತ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು ಹೋಯ್ತು.
ಅದೇ ತರ even judicial orders ಅಲ್ಲೂ by mistake ಸರ್ವೆ ಚೇಂಜ್ ಆಗುತ್ತೆ. We have also filed application.
ಎವಿಡೆನ್ಸ್ ಆಗುತ್ತೆ. ಎವಿಡೆನ್ಸ್ ಆಗುತ್ತೆ.
No, my submission is this: evidence ಆಗಲ್ಲ. In fact, the judgment relied upon my senior, my lord, of
evidence ಆಗಲ್ವಾ?
ಇಲ್ಲ, I'll tell.
Disputed. If the magistrate thinks that there is something in this or dispute, evidence ಬೇಕು ಅಂದ್ರೆ he will call.
Yes.
No, my lord. Can I read paragraph 18 of the very same judgment laid upon my friends, my lord? Para 18, the judgment of Muniyamma, it says, if the application contains above particulars, that is all that has to be given for a birth certificate or a death certificate, the magistrate should not only issue notice to respondents, but also to those persons who are likely to be affected by the order. He should also direct the issue of notice in
hold an inquiry and pass appropriate.
Then, my lord, no. The magistrate may also issue such other directions as he may deem fit and proper, depending upon the facts of the case. He should hold an inquiry and pass appropriate orders thereon in accordance with law. That is only when there is no dispute. If there is a serious dispute with regard to date of death, the magistrate has to dismiss the petition with liberty to the parties to approach the civil court for appropriate reliefs. So, my lord, it's only when it's an open and shut case, my lord, he can express. Open and shut case has whether it is for the learned magistrate or to the executive magistrate who will see, okay, why, my lord, section 13(3), the object is very, very limited. He only has to see why there was a delay in not registering within 1 year and nothing more. He is not sitting and adjudicating any rights of any parties. If somebody says, no, he did not die, or for example, he says he's still alive, or he died on so-and-so, or born, then, my lord, it will go to a civil court. So there again, my lord, our High Court says, you don't exercise any judicial function. And in fact, my lord, there's one more judgment of our Honorable High Court, my lord, reported in fact, my lord, in this very same Muniyamma's judgment, there's a reference to that judgment, my lord, of H. Subbarao versus Life Insurance Corporation, wherein it says that an order of a magistrate binds only the registrar and no others. It is not a judgment in rem, my lord. It's not even personam. It is only for the registrar to say, look, I accept the cause shown for the delay, and hence you have it registered, and nothing more.
No, there is no a judicial officer determining birth or death cannot be in rem at all.
My lord, but our High Court says that it binds only one person, that is the registrar. Obviously, and no one else.
If it is only one person.
No, the registrar does not say that he was born on this day. The registrar only, the judicial magistrate would direct the registrar and say, look, now register it. I condone the delay of 1 year, is all that is passed.
Now, my lord, can I
So you
take,
may
my
be
lord?
right in saying that because if there is a dispute, even he would refer it to the civil court.
Exactly, that's exactly. Then, my lord, kindly see section 3.
So there is no question of recording evidence there. If evidence is to be recorded, be it the executive magistrate or the chief judicial magistrate, if both of them would refer it to the civil court.
He will go to civil court. Civil court.
All right.
Now, my lord, I would also read section 3, 2B, which says what's an administrative action, which are administrative or executive nature, such as the granting of license, the suspension or cancellation of license, sanctioning a prosecution or withdrawal from prosecution. They shall, subject to provision of clause A, be exercisable by an executive magistrate. Now, my lord, can I take, my lord, my emphasis on these words, which are administrative or executive nature, such as the granting of a license. Now, my lord, this particular, the meaning of the word such as is actually illustrative. That is what exactly Supreme Court says, my lord, in Goodyear Limited, Collector of Customs would say, when such words like stainless steel, nickel, etc., hosiery, etc., it does not limit itself to only that. It means various metals from which walls can be made. Also, such description also comes under its sweep. Now, here, my lord, what
ನೀವೇನ್ ಹೇಳ್ತಿರೋದು ಸ್ಟೇನ್ಲೆಸ್ ಸ್ಟೀಲ್ಗೂ ಇದಕ್ಕೂ ಸಂಬಂಧ?
ನಾನು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ ಈ ತರ ಒಂದು ಡೆಫಿನೇಷನ್ಸ್ ಬಂದ್ರು ಕೂಡ what it says, my lord, is that it does not confine only to grant of license or cancellation of license, sanction of prosecution. It can also
steel, aluminum, gold ಎಲ್ಲ ನೋಡೋಣ ಆಮೇಲೆ.
ಅಲ್ಲ, ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಲೆಕ್ಟರ್ ಆಫ್ ಕಸ್ಟಮ್ಸ್ ಅಲ್ಲಿ ವೇರಿಯಸ್ ವೇರ್, my lord, the meaning of the word such as in this the meaning ಹೇಳಿದ್ದಾರೆ. So that is what I said.
The word should be judged with the company it keeps, that is nocere sauce. That is what is held by the apex court in that. Yes.
Then, my lord, I'm once again, my lord, my learned friends have been skipping the judgment of the Honorable Bombay High Court. I understand, my lord's judgment has not been accepted by the court. But, my lord, but the thing, my lord, is that what is a judicial function and what is an executive function has been clearly said there. Since my lord is ever, I will not trouble my lord. It clearly says, section 13, subclause 3. Kindly, I would just read that particular provision, my lord. Section 13, subclause 3, it says, any birth delayed so-and-so, any birth or death of which delayed information is given to the registrar after 1 year of its occurrence shall be registered only on an order made by a district magistrate or so-and-so, or by an executive authorized jurisdiction over the area where birth or death has taken place after verifying the correctness of birth or death. Now, my lord, all that this person, the judicial magistrate or executive magistrate would do is to only verify. Verification only means just examine documents and not exercise any judicial function. Because judicial function, yet again, my lord, in CRPC it is said, any action of appreciation of evidence, shifting of burdens, etc., which might end as far as his conviction, penalty, etc., is considered only that. And as my lord was also mentioning, if it decides proprietary rights or rights of his freedom, etc., would come under that definition of what is known as, my lord, a judicial function. In fact, while disposing of this Nagpur bench of the Bombay High Court, my lord, would also examine the judgment of the Honorable Supreme Court, which I will rely upon, my lord, which clearly says what is a judicial function. Though it is nowhere defined, what is a judicial function has been clearly said, my lord. So, my lord, it is like this, my lord. I no doubt understand, my lord, that it might be causing a lot of problem to some persons. But, my lord,
ಅಲ್ಲಿ ಅಸೋಸಿಯೇಷನ್ ಇದಾರೆ ನೋಡಿ ಅಲ್ಲಿ
ಅವ್ರು ನೋಡ್ರೆ ನಂಗೆ ಭಯ ಆಗ್ತಿದೆ.
all not some,
all yes include we have also filed something.
Yes,
all of us, it creates problems to everybody. But, my lord, to strike down a provision as manifestly illegal, my lord,
that we will have to think about. Yes,
I shall refer all those judgments, my lord. There is a presumption in validity and constitutional of a statute.
Because apex court directed within 2 months dispose ಮಾಡಬೇಕು ಅಂತ 4/9 ಗೆ ಮಾಡಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ I have taken it.
Now, what happened there, my lord, is that the Gujarat High Court matter was challenged. They said the
Karnataka High Court has hold, because I was the one who said first that tail cannot wag the dog, that went to Gujarat High Court.
Correct.
After that, amendment took place. amendment was challenged before the apex court, the Gujarat
Yes,
High Court
yes, yes.
judgment. There, the Supreme Court observes that Karnataka High Court is pending there.
My lord, there probably it was not brought to the Honorable Supreme Court that whilst this Honorable Court had passed an order, this amendment was not in place. So, my
That is
lord, the
what
judgment.
they ಹೇಳಿಲ್ಲ, but what to do? Supreme
ಹೇಳಿಲ್ಲ.
Court is directed.
The direction is there. Our
ಅದಕ್ಕೆ.
parties, they would not have gone through in detail, my lord. So, my
that's
lord,
what.
the pith and substance, my lord, is that it is not just a small amendment which takes away the powers of one particular authority, judicial authority, and confer it upon executive. It will have to be read in conjunction and sync with, my lord, the entire objectives, more particularly, my lord, formation of database, Aadhaar card details, etc., connecting the databases, my lord, and my lord, most important, my lord, the use of these birth certificates, my lord. What happens? This bill says this birth certificate would be mandatory and the only document considered for certain things like government jobs, for licenses, admission to education, which my lord, it takes into sweep of all our activities.
Even more serious.
Allah, Only Krishnan sir, Nodi Iga. Now you told Allah that this will be used for so many things.
Therefore, it should be judicial exercise only.
It will be used for that, used for this, used for that. So
we should be thankful.
You know sometimes how it is granted.
Allah, but we cannot presume, my lord, that.
No, I'm not. See, a assumption will not render a provision unconstitutional or even illusory. Also cannot. All these things cannot. We should have some. It should be manifestly arbitrary. What is manifest arbitrariness? We will write.
In fact,
yes.
My lord,
if
the
it is,
Honorable Supreme
if it is
Court,
to be held,
read a paragraph, my lord. Indeed, however great may be the care bestowed in its framing, it is difficult to conceive of a legislature which is not capable of being abused by perverted human ingenuity. As the court must therefore adjudge the constitutionality of such legislation by the generality of its provision and not by its cruelties or iniquities or by the possibilities of abuse by any of its provisions.
No problem, sir. Even with upholding the constitutionality of a provision, this court can iron out the creases. We'll see what is to be done.
Yes. Way back in the year 1990 itself, my lord, wherein even if assuming we all concede that there is a lot of corruption or whatever it is, my lord, it cannot.
No. See that you can't paint that brush to annul provision as unconstitutional.
Legislation.
That's not
the possibility of abuse is
that's
never
not the
a
way
ground
we
for,
function.
yes.
Also, but let's see this.
Not here.
Delicate balance.
Yes, Lord. I just may add one thing. Many of the lawyers practicing here, when the judge asks them about proof of death, usually they get the photographs from the tombs in the remote villages. And that also is made as part of the evidence to just understand the practicality, Lord. I was asking them. So the evidence is based on such delicate details. And suppose there is no proof, there is no tomb. I mean, he is cremated. Then, my lord, how would it be proven? So these are such tangled set of evidentiary facts, which requires judicial application of mind to decide. And if it is a court that decides, then every affidavit filed there is accompanied by some solemnity. The affidavits are liable for perjury. It becomes a court. It has all the trappings of a court. So that's why, my lord, there has to be a judicial power which has to, a judicial mind which has to apply its mind on these delicate issues and then arrive at findings. And if it has to arrive at findings based on evidence, then apparently it is a judicial power. The legislature cannot arrogate it, take it upon itself and say that we will decide these facts. How can these delicate facts be decided by a assistant commissioner abroad? What capacity does he have? What competence does he have?
Delegate assistant commissioner.
Delegate.
ಅಲ್ಲ ಈಗ ಅವರು ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಇಟ್ ಇಸ್ ಸೋ ಇಂಪಾರ್ಟೆಂಟ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ಸ್ ಟು ಸ್ಕೂಲ್ಸ್ ಅಂತ. ಅವ್ರಿಗೆ ನಾವು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ 5ನೇ ಕ್ಲಾಸ್ 10ನೇ ಕ್ಲಾಸ್ ಆಗೋಗಿರತ್ತೆ.
It is not. My submission is.
No. Only Krishnan sir, you're right. You're right. That's all right.
It's in future,
lighter way, sir. 5:45 ಆಗಿದೆ ಅದಕ್ಕೆ.
Just one sentence which I wanted to add to what my learned friend said, my lords. Subsection 3 specifically says, after verifying the correctness of the birth or the death. My lords, after 1 year lapses, there is a very specificity. Your lordships were to see the language employed under 13.2. On an affidavit before a notary public, they will straight away accept and register it. So there is no necessity of verifying the birth or the death itself.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಯಾವ ವೆರಿಫಿಕೇಶನ್ ಆಗುತ್ತೆ? ಏನೂ ಆಗಲ್ಲ.
ಏನು ಆಗಂತಿಲ್ಲ. Here the requirement is to verify
Because
the
ಅಸಿಸ್ಟೆಂಟ್
correctness of the
ಕಮಿಷನರ್
birth
ಮುಂದೆ
and the death.
ಬೇಕಾಗಿರೋದು ನೋಟರಿ ಸೀಲ್ ಅಷ್ಟೇ.
ಅಷ್ಟೇ. And Lord, one another aspect is, sometime in 1930s, 1940s, those who were born in that era, 1950s, 60s, father ಒಂದು ಹೆಸರು ಕೊಟ್ಟಿರ್ತಾರೆ, ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅಂತ. ಮಗು ಹುಟ್ಟಿರುತ್ತೆ, ಫಾದರ್ ಒಂದು ಹೆಸರು ಕೊಡ್ತಾರೆ ಹೋಗ್ಬಿಟ್ಟು, ಒಂದು ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅಂತ. Those details cannot be taken as exact details of birth and death because they were not registered with the authorities. Now the complication is that how will we arrive at the precise date of birth?
ಈಗ ಪ್ರೀ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಯಾರಿದ್ದಾರೆ? ಪ್ರೀ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಯಾರಿದ್ದಾರೆ?
ಅವ್ರಿಗೆಲ್ಲ ಇದನ್ನ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಪೆನ್ಷನ್ ಯಾರು ತಗೋತಾ ಇಲ್ಲ ಈಗ ಅಂತ ಮೊನ್ನೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರು ಗವರ್ಮೆಂಟ್ ಅವರು.
And also, while amending section 13(3), we have not challenged all the amendments. What we say is substitution only of this. And also kindly see, my lord, the legislature, my lord, did not give this power, empower this power to even the revenue officers. Because had it been revenue officer like or the assistant commissioners, etc., my lords, they are endowed with certain judicial powers. They under certain enactments, my lords.
Judicial magistrate, if he decides,
yes,
judicial magistrate,
executive.
Yes, if suppose
Only
the
to
judicial
executive
magistrate, if judicial magistrate decides this, my lord, will there be a problem for the portal? Unni Krishnan ಹೇಳೋದು.
ಅಲ್ಲ ಅದ್ರೊಳಗೆ, my lords, it is only an order which will be passed by the magistrate, and there will be a direction issued to the registrar. Then it gets integrated into the portals. This is the means through which it is going, whether it should be through the executive magistrate or the judicial magistrate.
That we will, if we have to answer if we have to answer something, we will also lay down guidelines as to what to be done. If we have to answer.
And the intentional legislature, my lord, they retain the word order also. What my learned friend Unni Krishnan said is, it is not an order, just an excise administrative act, what they do.
That ಈಗ ಪೋರ್ಟಲ್ ಹೋಗೋದಕ್ಕೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. We can always pass an order to integrate the court which deals with births and deaths with the assistant commissioner's office or it. The moment it is clicked here, it should go there. That is
my lord, it can be only done probably for our state, my lord.
They are all in electronic world, sir. That can be solved.
I just wanted to clarify this, my lords. Once an order is passed by the magistrate, that order goes to the registrar. Yes. Then the registrar is the person who actually will have to register the birth or the death on the basis. So it is automatically integrated.
delay ಆಗ್ತಾ ಇದೆ ಅಂದ್ರೆ we will direct it to
instead of manual, your lords may kindly direct that let it be digital, my lords.
That is we can
please, my lords. That would go a long way. That would harmonize the provision, my lords.
My lord, I would make a submission here. My lord, one submission.
That problem is trivial, not to worry. Yes.
Lord Unni Krishnan has himself filed several 13(3) applications, got registration of births and deaths. ಅದು ಬೇಡ ಬಿಟ್ಬಿಡಿ ಅಂತ ಅಷ್ಟೇ ಸಾಕು.
AC ಹತ್ರ ಹೋದ್ರೆ ಆಮೇಲೆ ಯಾವ್ದಾವ್ದೋ ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ ಕ್ಲೈಂಟ್.
ಅಲ್ಲ, ಮೊನ್ನೆ ಒಂದು ಮ್ಯಾಟರ್ ಇತ್ತು, ಐ ವಾಸ್ ಸೇಯಿಂಗ್ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಬೇಗ ಮುಗಿಸಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ ಮೊನ್ನೆ ನಮ್ಮ ಕೊಲಿಗೆ.
My lord, the state was impeded at a later stage, my lord. We don't have much of a role to.
Banu Prakash, you have nothing to say.
No,
yes, my lord, because we were impeded.
I have a statement to make about this.
Only thing is, my lord, state wanted it to bring that amendment by a rule amendment.
Oh,
I wanted to say this, my lord, the state. Yes, not the state has to give the data.
Yes, ma'am.
AC post create ಮಾಡಿ ಎರಡು, AC death, AC.
I'm sitting right with my officers right here, my lord. I was even suggesting it.
Waiting in the list, my lord. ಯಾರು ಬರಲ್ಲ. ಒಂದೊಂದ್ ತಾಲೂಕ್ ಸಬ್ ಡಿವಿಷನ್ ಗೆ ಎರಡೆರಡು ಪೋಸ್ಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಲ್ಲಿಗೆ ಮುಗೀತು. ನೀವು
ಯು ಡೋಂಟ್ ಲೈಕ್ ಹಿಸ್ ಫೇಸ್ ಅಂದ್ರೆ AC birth, AC death.
Assistant Commissioner
Registration advocates, my learned friend Ravi Shankar says if nobody would come, I would also say add one thing to my learned senior friend Ravi Shankar. All the advocates who have been practicing, they say if it is removed from the courts and given to executive magistrate, many executive magistrates would be interested in this.
No, that's a different thing.
We say because
that's a different thing. And
yes, no advocates would go.
Advocates are not permitted.
Yes, then touts will start, my lords, and all sort of bogus documents
will not get in there.
Please, man, that's
If
why,
it's
my
a
lords,
court under advocate,
that's the one fear with us, my lords, as far as this, the
Milords,
practical fear.
can I just indicate what's the role of the state in this, Milords? The state
Yes.
has a very prominent role because the executive magistrates who are presently working as subdivisional magistrates, etc., they are working within the card strength. The card strength they are not going to increase because say the parliament has never taken into account how many subdivisional magistrates are there and what is. They will have to give the data now. State has to give the data in respect of these assistant commissioners or the subdivisional magistrates. How many matters are pending and for how many years? I can produce proof that there are matters pending for about 10 years, 12 years before these persons. Yes. That data we have already applied for it, Milords. We are getting it. We are getting this data.
You should.
Milords, we are getting the data tomorrow, Milords, from the because the learned additional advocate general is there.
Please, you should produce all the documents. Please, we will.
On his call, they will give it.
See, what happens is.
I thought mute ಮಾಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ಹೇಳ್-
Please. We'll produce.
ನಮ್ಗೆ ಅವಕಾಶನೇ ಇಲ್ಲ.
ಆಮೇಲೆ ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ತಮ್ಮ ಕೊಡೋದಿಕ್ಕೆ 1 ವರ್ಷ ಮಾಡ್ತಾರೆ.
ತಂಬು
ಅದು ಬೇರೆ ಇದೆಯಾ?
ಭೂಮಿ ಮೇಲೆ ತಮ್ಮ ಕೊಡ್ಬೇಕು, ಭೂಮಿ ಆ್ಯಪ್ಗೆ ಅದನ್ನ ಅವ್ರು ಕರ್ಕೊಂಡ್ಬರೋದು ತಮ್ಮ ಕೊಡ್ಸೋಷ್ಟೊತ್ತಿಗೆ ಅದೊಂದು ಅಷ್ಟು.
We will produce those reports.
All that I want.
All reports, my lords.
All that what is there.
Truth is.
Whether I hold it in your favor or not is a different thing, but there should be a considered order.
And also we submit, my lord. A high day has come, my lord, where the honorable courts and especially the honorable superior rate courts, etc., have been taking judicial notice of the misuse and corruption at various levels, my lords. And you kindly take judicial notice the full bench of Karnataka High Court.
One more case I tell you. This in a POXO case,
please.
This assistant commissioner had given a certificate saying that the victim was beyond 18.
18 years.
Yes. Beyond 18. Then I quashed the proceedings. State filed a recalling application saying the certificate that is given is wrong. At the time of incident, she was 13. So he had raped a 13-year-old minor. He certificate in the close agobit proceeding and recalled the order. So such things happen.
So that's why, my lords, I beg to submit.
No, it's not that allo agalla antalla. Mistakes happen, but these glaring mistakes won't.
But my lord, while interpreting a provision, my lords, the honorable writ courts would always consider the experience to interpret. This is the experience, my lords. Now, if it is left to the executive magistrate, number 1, no lawyers. Number 1, no sittings. Number 3, no definiteness. Number 4, and all of the local act, everybody is saying, we will produce.
Everything.
Please.
Yes.
Lords, I just wanted to say this.
On compilation.
We'll file Lords, the right to information applications were filed and various informations were sought for. Advocates are going to the Tehsildar's office and the Assistant Commissioner's office, waiting for their arrival. They are waiting to meet them. For even to get this information, they are not available. This is the problem.
My lord, in revenue mutations also, the honorable High Court full bench, my lord, considered it and gave certain guidelines, my lord. It's having regard to experience.
And guidelines have remained guidelines.
Jayama case, please.
No, as a matter of fact,
have remained guidelines.
To be on the lighter side, my lords, I should say that this Khata proceedings has become Kate proceedings. We are so happy, my lords, that it is giving so much of work to the courts as also the lawyers. President is here.
Appellate jurisdiction is filled with cases.
Some decisions, my lords, and now, my lord, separation of powers has been maintained and should be definitely maintained, my lord. This would amount to, my lord, if this for any reason is upheld, my lords, order can be passed by an executive magistrate. There are many areas, my lord, where the legislature wants to give it to other wings. All right. It will be diluting the judiciary.
One submission. My lord made a suggestion that there would be a linkage with the magistrates. My lord may kindly see the objective of the act, my lord, is that it is now known as it shall come into force in all the states, my lord. So, my lord, even if such orders are passed, it can only link, my lord, the judicial magistrates probably to that of Karnataka. But it's a pan-India, my lord, registration.
I understand. That's why I said there's a delicate balance now which has to be struck. I don't know. Yes, we'll see.
My lords, the
When was making a mention, I thought
it's also pan-India. Fairness where executive magistrates and judicial magistrates are defined, my lords. It's also pan India, my lords.
No, it's.
Central government
That's why, in fact, my lords, that's the, in fact, my lords, we are grateful because of the first order, my lords, many continued their practice. Many, throughout
But,
Karnataka, my lords, many of the advocates are practicing because of my lord's first order, Sudarshan Biradar case.
That's when Mr. Unnikrishnan
And
was making a
secondly, because
mention
of my
that
lord's
he
interim
wanted to
order.
request,
And it's only in Karnataka, my lords. that
but I
advocates
want
are
to say
able to
that
practice.
when Mr. Unnikrishnan was about to make a request, I thought that he was requesting your lordships to defer this matter to pass the order till he
No,
gets his 13th
Supreme Court has
allowed.
directed
That's
closure,
right.
sir.
But his 13th threes are still before the magistrate. He was keen to get it disposed before your lordships would get it disposed of. So I thought he's making a special request pertaining to his
Illೊಂದು
matter.
mandamus ಹಾಕ್ಬೇಕು.
Lord, so
For my
grateful,
lords,
Lord, for your lordship's time.
For my lords, probably that order is there, Supreme Court, the same direction.
Well, I know it.
Very easy.
No, that I did
reference.
not know it at all. It came to the chamber from the Supreme Court saying that it should be disposed immediately. Then I took it up here. Otherwise, I would have taken it up in January. I had to dispose this to. It said 2 months from 4/9. It's 2 months for 4/11. It's over.
No specific date is
No,
fixed for my
ನೋಡಿ.
lord. ಇಲ್ಲ, only that the state should give the compliance.
28/9/2025 ಇಂದ 2 months ಒಳಗೆ ಮುಗಿಸ್ಬೇಕು ಅಂತ.
They should give the report. That's all, my lord.
ಅದಕ್ಕೆ ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಕೊಟ್ರೆ
Please. We are bound.
ಇಲ್ಲ ಅದಕ್ಕೆ ಭಾನು ಪ್ರಕಾಶ್ ರಿಪೋರ್ಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ ಈಗ.
That's why before 28/29/11 I had to finish it. I'm crossed 4 days, so I took it up.
Very well.
Third reserved.
Obliged.
We are most grateful. We will.
Urgent ಆಗಿ ಹಾಕ್ಬೇಕು.
We will do it.
By
All of
tomorrow
you
we'll do it.
compilation ಒಂದು ಹಾಕಿ everything should be on record. ಉನ್ನಿಕೃಷ್ಣನ್ ಸರ್ಗೆ ಒಂದು ಸರ್ವ್ ಮಾಡಿ.
ನಾನು ಫೈಲ್ ಮಾಡ್ತೇನೆ.
ನೀವು 2 ಪೋಸ್ಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬಿಡಿ.
Punishment post.
AC death, AC. Yes.
We are so grateful, my lords, for my lords.
Yes.
Kind consideration and valuable time spent, and also patience with
No,
which
this has
your
to be
lordship
answered.
has
Will
done.
answer. Yes.
Obliged.
So grateful.
Yes. Who is Naganand sir waiting?
My lord, I'm waiting, my lord, for an item which is of some urgency at serial number 77, my lord. It has not reached. It's a very simple issue relating to ethanol. The produce is ready, my lord, and the contesting respondents are refusing to lift it, my lord. The reason why we could not, my lord, give it in time is because of a state government order.
I know, the yesterday, ಯಾವ್ದು amendment ಹಾಕಿದ್ದು, it was in fresh mat.
Yes, my lord, I filed a amendment application.
ನಿಮ್ದೆ.
All that I'm saying, my lord, is
ethanol ban.
Any date, my lord.
Tomorrow
Please,
ಆಗಲ್ಲ,
ma'am.
Monday is
Please,
fresh
please.
matter.
Monday fresh matters, please.
IA for amendment, IA 1 of 2025 along will be considered along with the main matter. List the matter on Monday in the fresh matter.
My lord, can I make a submission, my lord?
Yes, sir. ಎಲ್ಲಿ ಪೋಯ ಸರ್ ಇದ್ದಾರಾ?
I'm here, my lord. But I am also here, my lord.
Yes. Let me just give some dates and then get back to you. All of you, Iri. Yes. Jay Kumar is 122. Na yadu? 122. Which is that?
Till he was here, my lord, online. And now
He has gone offline.
122 are
Supreme Court ನಿಂದ ಅರ್ಜೆಂಟ್ ಇವತ್ತು ತೀರ್ಮಾನ ಮಾಡಬೇಕು ಅಂತ ಕಳಿಸಿ, ಅದಕ್ಕೆ I had to do it.
one earnest request, my lord.
Monday. Yes. Monday 2:30.
Till then, my lord, they should not announce a calendar of events.
ಯಾರ್ದು ರೆಸ್ಪಾಂಡೆಂಟ್?
ಅಂಗಡಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ. Or any 2 days ಇಟ್ಕೊಂಡ್ರು calendar of events
ಆಗಿದೆ ಗೊತ್ತು. ವಾಯ್ಸೇ ಹೋಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಎಲೆಕ್ಷನ್ ಆಗೋಗಿದೆಯಾ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ. ಇನ್ನ ಅನೌನ್ಸ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲ, ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ನೋಟಿಫೈ ಮಾಡಬೇಡಿ.
They are seeking for infusion of
ಒಂದ್ ನಿಮಿಷ, ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಆಗಿದೆಯಾ?
administrative appointment.
ಸೊ ಇವ್ರೇನಿಲ್ವಾ?
Board is not.
ಒನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಎಲೆಕ್ಷನ್ ಮಾಡ್ಬೇಕಾ?
Please, ma'am.
ಕರೆಕ್ಟ್. ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಡೋಂಟ್ ಅನೌನ್ಸ್ ಟಿಲ್ ಮಂಡೇ.
Please.
ಆಲ್ ರೈಟ್?
Please.
ಎಲ್ಲಿ ಗಂಗಾಧರ್ಗೆ ಹೇಳಿ. ಎಸ್.
ಮಚ್ ಗ್ರೇಟ್ಫುಲ್.
ಡ್ಯಾಮೇಜ್ ಅವಾರ್ಡ್ ಎಲ್ಲ ಮಂಡೇ. ಮೇಡಮ್ ಮಂಡೇ. ಬರೀ ಡೇಟ್ ಮಾತ್ರ, ಬೇರೆ ಏನು ಹಾಕ್ಬಿಡಿ. Shankar.
Yes, yesterday I moved.
Here only. You said you'll go back.
No, my lord, yesterday I moved the memo. I stayed today. Yesterday.
You should have told me at least at 2:30. ಇವತ್ತು ಕಾಫಿಗೆ ಹೋಗಿದ್ರಾ? ಇಲ್ವಾ?
So, I thought it will reach today, my lord.
Do not. No, there are many matters. Supreme Court remitted matters.
Right,
Difficult.
at least admitted amount, let them release, my lord.
ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ?
1,22 lakhs ಅಂತ ಮಾಡಿದ್ದಾರೆ.
1,22 lakhs.
1 crore 22 lakhs.
ಹಾ.
That's the admitted amount. Subsequent.
Who pays for the response?
PNN Limited.
Chetan.
I appear.
Admitted amount ಅದು?
ಇಲ್ಲ, that is not
But
admitted.
subsequent to filing petition, they said they issued endorsement, solemnity will not be paid.
That's
But this Supreme Court judgment, solemnity has to be paid, my lord.
what had happened.
Subsequently, they have issued an order.
Monday fresh matters.
Yes, not sir. In this case.
Monday fresh matters.
I will appear through EC.
Please appear. Who asked you to come here? CC 11. Monday fresh matters.
Please.
I'm filing a memo in this. Right?
115.
ಕೊಡಿ. ಅಲ್ಲ ಮೆಮೊ ರಿಜಿಸ್ಟ್ರಿ ಹಾಕದ?
It shows it's a corner.
ನಾಳೆ ಹಾಕು ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ಬಿಕಾಸ್ ಟೈಮ್ ಆಯ್ತು. ಆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಚೇತನ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಡ್ತೀನಿ.
ಕೊಡಿ.
124 minutes.
ಎಲ್ಲ ವಿಲ್ ರಿಪೀಟ್ ಇಟ್. ಮಂಡೆಗೆ ಬೇರೆ ಯಾವುದು ಎಕ್ಸ್ಟ್ರಾ ಮ್ಯಾಟರ್ಸ್ ಇಲ್ಲ, ಇನ್ನು ಇದನ್ನೇ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ಡೋಂಟ್ ಮೂವ್ ಮ್ಯಾಟರ್ಸ್.
Interim order may kindly be extended.
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
117. Though it is on direction by this honorable court, the committee has formed before the appointment.
ವಾಟ್ ಕಮಿಟಿ?
ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ Lord.
ಅಷ್ಟೇ ತಾನೇ, ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಮಂಡೇ ಟೂಸ್ಡೇ ಹಾಕೋಣ.
Covered judgment Lord.
ಈಗ ಮಾಡಕ್ಕಾಗತ್ತಾ? ಇಲ್ಲ ತಾನೆ.
Fresh matter Monday.
Monday fresh matter.
Please.
That is reasonable.
Serial number 122, my lord. Serial number 122. I need 2 weeks time to file a statement of objections, my lord.
ಆಯ್ತು, ಆಮೇಲೆ ಬರ್ಲಿ.
Serial number 6.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು.
Serial number 69.
ಅಭಿನಯ್ ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ.
103 minutes. May I seek on 12 minutes. Senior PPA grade is going to appear in this matter.
ಯಾವ್ದದು?
Serial number 103 minutes.
ಯಾವ್ಯಾವ್ದು ಬೇಕು ಹೇಳ್ಬಿಡಿ, ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಬೋದು.
Please.
ಮತ್ತೆ ಎಕ್ಸ್ಟ್ರಾ ಯಾವ್ದು ತಗೊಳಲ್ಲ, ಇದನ್ನ ಮಾತ್ರ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ ಇರೋದೆಲ್ಲ. ರೆಗ್ಯುಲರೈಸೇಷನ್ ಮಾತ್ರ ಯಾವ್ದಾರು ಇದ್ರೆ ವಿಲ್ ಟೇಕ್ ಇಟ್, ಅದರ್ವೈಸ್ ಯಾವ್ದು ಬೇಡ.
Permission, Lordship.
ಟೆಂಡರ್
ಇಲ್ಲ 79, your Lordship has directed me to place synopsis also.
ಯಾವ್ದು?
79.
ಎಥನಾಲ್ದ?
ಇಲ್ಲ, ಹೆಲ್ತ್ ಎಜುಕೇಟರ್ ರಿಡೆಸಿಗ್ನೇಷನ್ ಆಗಿದೆ. Lordship has heard for some time. ಅದು
ಅದೇ ಬೇರ್ ಫುಟ್
ಇಲ್ಲ barefoot ಅಲ್ಲ. Health educator has been redesignated as a lecturer as per the MCA regulations. He has been redesignated and given promotion. Thereafter it has been withdrawn. That was what Lordship has.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎಲ್ಲ ತಗೊಂತೀನಿ. ಇಲ್ಲಿರೋ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋದೆಲ್ಲ ಹಂಗೆ.
11th at least, 11th on fresh matters.
11th ಯಾವತ್ತು ಆಗುತ್ತೆ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೂರ್ತಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಂದ ಬಿ ಗ್ರೂಪ್ ಇದೆಲ್ಲ ತೆಗೆದ್ಬಿಡಿ, ಬರೀ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ಲೇ ಬರುತ್ತೆ.
On 11th.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅದನ್ನ ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ.
That is the reason I am asking for 11th.
Serial number 65. Last time interim order extend ಆಗಿಲ್ಲ sir. 65
ಆಗುತ್ತೆ. ಅದರಿಂದ ಏನು ತೊಂದರೆ ಆಗಿದೆಯಾ? ಇಲ್ಲಲ್ಲ.
Lord.
56, the case of Lords have directed doing of IO. Lords were seeking compensation. Lords may have it on Tuesday.
ಆಯ್ತು, ಇಟ್ ಕಮ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ. ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಹಾಕೊಳ್ಳಿ. ನಿಮ್ದು ಯಾವತ್ತು ಬೇಕು?
Serial number
ಎಷ್ಟನೇದು ಬೇಕು?
Serial number 63, my lords. I'm challenging Lok Adalat decree. The only grievance is petitioner is of 84 years old, my lords.
No, the 84 years Monday fresh matter. Yes.
Serial number 60, my lords. I am appearing for respondent number 2. They have challenged, my lords, the grant order wherein now they want to delete my name. Now, my lords, have subsequently have filed today challenging the same grant order, my lords. May I request both the matters to be listed on Monday, my lords?
Monday ಕೊಡಿಯದು.
Highly obliged.
106.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಎಲ್ಲ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಲೇ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಂದ. ಮತ್ತೆ ಇಂಟರ್ಲೋಕೇಟಿವ್ ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ಕೇಳಬೇಡಿ, ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
Serial number 117. Same direction will continue the Monday, my lord.
Yes, everything fresh matters.
Direction is there.
Lordships, kind permission, my lords.
From Monday we are left with only 10 or 11 days, so everything only fresh matters.
Great.
Lordships, kind permission.
Serial number 60.
Yes sir.
Lordship, serial number 57 is already other matters are reserved for judgment, my lords. So it may be tagged along with that, my lords. Greenco, my lords. Serial number 57, my lords.
ಏನು ಮೇಡಮ್?
It's relating to Greenco solar project, my lords. Lordships have already reserved the other matters.
ಯಾವುದು that Panindra and Pramod Nair appear ಆಗಿದ್ದದ?
No, my lords. Sangram Kulkarni sir had appeared, my lords.
ಯಾವ್ದಪ್ಪ ಅದು ಗೊತ್ತಿಲ್ಲ. ನೋಡೋಣ, we'll see. Let it be there.
Please. Dharwad sir has appeared.
May I make one submission, my lord? Serial.
That's it.
Damage
My
over.
lord, damage over.
Let it be there. Yes.
Please.
May I make submission, Your Lordships?
Yes, Abhinay, heli.
Serial number 69. It's a matter pertaining to arbitration, Your Lordship. The arbitration proceedings
CMP
have
na?
been...
CMP?
Yes, Your Lordship. It's
Illa,
under...
WP, madam. It will come, madam, next week. All
Your
fresh
Lordship,
matters.
this is the third time the matter was listed before Your Lordship, and due to paucity of time, it hasn't
What
been
to
reached.
do, madam?
Lordship,
Yes.
arbitration proceedings have been stalled for more than 9 months.
Monday it will come, madam.
May I request Your Lordship to kindly have it in the
Fresh
fresh
matters.
matters?
Yes.
Lordship.
Serial number 59, my lord. Monday, man.
Wait.
Lordship, serial number 60. Interim order may be extended.
Thank you, sir. Don't.
Request for Monday or Tuesday.
It will come next week in all fresh matters only. Ee list alli yavadu miss agalla. Right? Yes.
Please, much of
Yes. Tali. All of you can go then. Now we'll kutkobeku innondiದೆ. Yes, sir.
Beloved, serial number 122.
Yes, my lord.
2 weeks time I can take.
2 weeks time ನಿಮ್ಗೆ ಯಾಕೆ?
For filing of statement of objection.
ನಿಮ್ಗಲ್ಲ ಸರ್ ಕೇಳಿದ್ದಾನೆ ಸರ್ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಹೇಳಿದ್ದೆ. ಎಸ್ ಐ ಥಾಟ್ ಸರ್ಜನ್ ಪೋ ಇಸ್ ಆಸ್ಕಿಂಗ್ 2 weeks time.
No, my lord. I wish I could ask, my lord, but not.
See, Raghavan sir is
No, but there is a genuine difficulty we are facing.
No, don't worry, sir. Yes,
Sorry,
don't worry.
I feel extremely delicate to put this.
Don't worry. No, that was a matter from Apex Court which I directed disposal before 29 November. I am 1 week beyond that.
I heard that.
Yes, sir.
My lords, if I could request your lordships, my lords, in the petition, I had, my lords, on the last occasion showed to your lordships one paragraph of the previous order passed by my lords in writ petition 1. No, going back to your lordships order, my lord, just 2 minutes of rephrasing and I'll come to Justice Chandra.
Yes, sir.
My lords, in paragraph 19 of that order, your lordships had indicated that the issue as regards locus raised against me will effectively blur into insignificance because of the seriousness of the issue that was raised. That is a substantive issue of multiple charges having created on a public asset without the consent of the board. The asset, my lords, was about 5,000 crores or a little more than that, my lords, 5,500 crores worth of 78 acres of land in Whitefield. Charges, my lords, for about 1,500 crores in terms of liability was created. Charges were effected in terms of third-party financial institutions, and it was our allegation that there was no consent of the board taken. But that order of your lordships, which directed that there must be an investigation by the board, and that I must participate also because I would have a right to have my say before the board, was taken up in appeal. In that appeal, my lords, the division bench indicated that there is no need to issue a mandamus because the board, for the first time in those proceedings, admitted that it will conduct an investigation because at that point of time, the board said they're not aware of the charge. Consequently, the division bench said, in the light of the fact that there is an undertaking to conduct an investigation, a mandamus need not be issued. My esteemed senior friend, Mr. Raghavan Melots, as a sequitur, therefore raised an argument saying no mandamus is issued by the division bench, which effectively sequitorially indicates that these chaps who knocked on the doors of the court have no locus. My lords, one other observation made by the division bench was that there is no need for me to participate in that inquiry which the board will be conducting. However, the division bench specifically indicated that all other rights, my lords, will be available with me in terms of challenging it. Please see 2 paragraphs of that order, my lords, and then I will straight away come to the subsequent order, my lords, of Justice Chandanagowda. My lords, please see in the writ appeal order, it starts, my lords, at Annexure G at 182. I will only trouble your lordships with 2 paragraphs, paragraph 6 and paragraph 8D. My lords will find paragraph 6 in my lords 19.
This is Hemant order.
No, my lords, the division bench order, my lords.
Division bench order, yes.
The division bench order.
Yes, sir.
My lords, in paragraph 6 of the division bench's order, which is at page 191 of this writ petition paper book. I read, my lords, 3 lines. It says, in view of the specific stand taken by the board to inquire into the matter regarding violation of the terms of the lease on its own, the question of issuing a mandamus would not arise. That apart, in our opinion, there is no need or necessity for the petitioner to participate in the inquiry proceedings conducted by the board. It was in this background, my lords, no mandamus is issued. Paragraph 8D, it's a short order, my lords. Paragraph 8 of that division bench order specifically, my lords, indicates that the learned senior counsel appearing for the appellant, that was, my lords, my esteemed senior friend Mr. Raghavan, made a statement before the court that till the inquiry is completed by the board, the appellant will not create any charge without the permission of the board. This statement is taken as an undertaking to this court. In that light, my lords, there was a direction issued, and I read, my lords, direction B. The respondent board shall conclude the inquiry expeditiously as possible or at any date within 4 months. In that very order, my lords, towards the last, 8D said this, and I read, my lords, those 4 lines. It is made clear that the respondent board will carry out the exercise of inquiring into the matter without being influenced by the findings or observations made by the learned single judge in the impugned order. Full stop. And this, my lords, is the emphasis I place. This, however, shall not affect the rights of the parties. I was, my lords, the petitioner, and they were the appellant. Parties seek appropriate remedy as may be available under law before a competent legal forum. If the question is that my locus, my lords, was actually diluted by the division bench, where is the question of the division bench, my lords, reserving my rights, that is, rights of the parties, to seek appropriate remedy pursuant to, my lords, an order that may be passed by the board after conducting an inquiry? And the operative part, my lords, I am at 191 of the paper book. The operative part of the order is clause Roman 3 and clause Roman 4 of the operative portion of the order of the learned single judge are deleted. So what is deleted? Clause Roman 3 was petitioner's participation in that inquiry. That is deleted. Clause Roman 4 was the interim injunction.
Except saying you need not participate in the inquiry,
Yes,
there was no decision of the division bench on the observation regarding locus of my order. Is your submission?
Respectfully, yes, my lords. And if I can wordsmith that in one sentence, my lords, observations in paragraph 19 of your lordship's order was not in any manner directly or sequatorially diluted by the division bench, my lords, either in para 6 or para 8 of their order.
Yes.
The fact that a mandamus was not issued to the board was a function of the board undertaking that they will conduct an inquiry, and not a function of my locus, my lords, being in question.
Yes.
My lords, in that light, I go forward, my lords. There was an inquiry conducted by KDB. The KDB inquiry, my lords, pursuant to an inquiry, an order was passed. Please permit me to come to, my lord, just one page in the paper book. Your lordships will find, my lords, the operative portion of that order in 207. And I'll make just 2 points, my lords, in that regard. The KDB inquiry order indicates the series of violations that are alleged against, my lords, the respondents herein. It then passes an order indicating, however, the respondents are now telling KDB that in another 1 year they will develop the property. In the light of their undertaking to develop the property, they extend the time for development by another 2 years and say precious little against any of the violations that have been committed, and therefore offer, my lords, a complete clean sheet to the respondents herein. The second aspect of that order is that order, my lords, was after hearing parties reserved, my lords, in March of 2024. An order was pronounced, my lords, on 3/9/2024, and reasons were added to that order on 10/9/2024. So we challenge it.
Yar Nanda.
No, my lord.
Justice Hemant.
No, my lord. KDB's order.
KDB order. Yes. No, I see. KDB order I have seen. Now KDB 34B. It undertook before the division bench that they will do a 34B inquiry, and in furtherance of the inquiry on 34B, they have issued a notice also to the respondents. In the notice, the tenor is that notice is somewhere annexed. I saw while reading the paper. Is that correct? Is that the notice issued to you?
Yes, there is a notice, my lords.
34B notice issue ಮಾಡಿದಾರಲ್ಲ? correct. ಅಲ್ಲ 34B notice issue ಮಾಡಿ ಆಮೇಲೆ they have
ಆಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. Thereafter this order was passed.
ಅದೇ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಆಮೇಲೆ the impugned order is passed.
Yes, my lord. And
Now,
in
my
fact,
lord,
I'm sorry. In fact, in the just answer your lordship's question, my lord. In fact, in the division bench order, the division bench directed that the KADB can issue fresh notice and proceed further in the matter.
Oh, that the division bench wrote. Yes.
Yeah, that's pursuant to that all this happened.
Yes.
my lords, in that light, please see, my lords, 2 paragraphs of the order that is passed by KDB. Your lordships will find, my lords, the order starts, the KDB order, my lords, begins at 196. Please glance through, my lords, 196 for 1 minute. Please see, my lords, the date of the order. Lords, it says 10/9/2024.
Yes.
My lords, your lordships will see at 196 on the top right-hand quadrant. The date is 10/9/2024. In this order, my lords, paragraph number 1 to 26 are all facts, saying whatever allegations are. Please see for a minute, my lords, paragraph number 20 at 201. This is the point that your lordships, my lords, just mentioned. Please see para 20 at the bottom of 201. As directed by the High Court, comprehensive notice under section 34B1 was issued on 31/8/2023, calling upon to remedy breaches. Now, please underline that, lords, calling upon them to remedy breaches and submit. Now, please see, my lords.
After this, I think the KADB heard both the parties and has and has passed the order at 207.
That's correct.
My lords, can you see 204 bottom, my lords?
Yes.
Notice under 34B was issued on so and so to the LRT. Now, please see, and please see in that 226 over the leaf in 205.
Yes.
Please see, my lords, B. The response is the company will be able to commence construction within 1 year. They respond to this notice not by saying that my charges were not created or created with your permission, etc. That is all, my lords, put under the carpet. They simply turn up and say, I have cleaned the site, I can start construction. It says company will be able to commence construction. Thereafter, my lords, in D, they say they have borrowed certain monies. Please see E, the following pre-construction activities conducted, site clearing, etc., etc. Now, please see, my lords, paragraph 27. This is the findings, and I will just read this paragraph. In the inquiry, having considered the statements by the LRT during the hearing and the report submitted by the executive engineer and the records, etc., etc., submitted the following so and so. Please see B. The LRT has submitted that the applications, etc., board was approved, etc., etc. Please see, my lords, 2 lines thereafter in 206. Further, LRT undertakes to commence construction within 1 year if plan sanction is issued by the board. However, plan sanction is pending with the board. My lords, in this light, please see paragraph number 28. And this was the fulcrum that we challenged. In view of the foregoing, I am of the considered view to extend 2 years' time for the commencement of the project by the LRT on the condition that an undertaking will be given by the LRT that the all monies taken as loan against this property will be utilized for completing the proposed project. Hence, I pass the following order. Please turn on to 207, my lords, now.
Yes,
all the
sir.
voice, not an observation.
Yes.
Now, please see 207 and, my lords, the scenario in terms of the date. The operative part of the order is in 207. Please see the last line. This order is pronounced today on 3/9/2024. The operative portion of the order is pronounced on 3/9/2024. Reasons for it, my lords, which are the 5 pages prior, my lords, is given on 10/9/2024. We turn up and say even the Supreme Court does not do this. It's not that I will give you reasons, etc.
Reasons to follow.
Reasons to follow. This is, my lords, an executive officer is now saying reasons to follow. I will pass an order, so everybody is guaranteed that there is an order passed. Now I will give my reasons. For what consideration, my lords? Certainly not for judicial consideration, because the order is passed. Now, my lords, we challenge something as egregious as this.
No. This is signed on 10/9/24, but the operative portion is on 3/9/24.
Operative portion is signed on 3/9/2024. And, my lords, your lordships will find 10/9/2024 in page number 114. The order is dated 10/9/2024. My lords, we raise this. We raise 3 grounds, my lords, before the learned single judge in a fresh writ petition. 1, that the grounds of violation named in the 34 notice itself have no explanation in the order. Second, the admitted violation that loans are taken, that violation is not cured because the notice said please cure it. Third, their time is further extended. It is like in my petition, I'm worse off. By challenging it, they get further 2 years time to build, number one. Number two, they say whatever money you have taken in breach, please use it for construction.
So,
And
who appears to the KIDB?
That's in this proceedings. The Advocate General appeared then, Melots. I do
No,
not know
appearing,
his-
my lord.
Yes. What is the reasons to follow, Advocate General?
My lord, I must tell you about this, Lord. Kindly
How
permit me
can
to say-
this
No, Lord,
executive
this has
officer
been-
say reasons to follow?
This has been considered by, this has been considered in the second round of writ petition by His Lordship Justice Hemant Chandan Gowda.
I am coming to that, Mr. Raghavan. No, no, Mr. Raghavan, let me have my say.
It has been considered.
This order is not under challenge before your lordship, my lord.
I am,
Mr. Raghavan doesn't appear for KIDB either.
Lord, this order.
Page
was
245 may be
under-
kindly seen, my lords. My
This
lords,
order was under challenge before Justice
Hemant has considered this already, is it?
I will come to that. I do not know why my friends. Mr. Raghavan, please let me argue. Otherwise, I will stop arguing. Let this matter come up another day. I can't understand this. I have been patient when Mr. Raghavan argued. Sir, for heaven's sake, let me have my say. Whether I win or lose is a different matter.
Oh, yes, sir. Continue. Yes.
can I answer, my lords?
No, wait. If it is, if Justice Hemant has considered it, we will consider. Let Poe sir complete. Yes.
He seems to be a little angry today.
No, I am not angry at all. I am assertive. There is a difference, my lords, being angry and assertive.
I've
And
never
being
seen
assertive,
Poe
I have
sir
learned-
angry.
My anger lies elsewhere.
He's over assertive today. All right, I will change myself.
Yes, Poe sir, continue. Yes.
Therefore, my lords, these were 4 grounds on which we challenged the order.
Yes.
And the last of the grounds being that reasons to follow is really a capricious exercise of power. My lord, that matter comes up before the learned single judge. Now, my friends here are using the subsequent order of the learned single judge as a fulcrum to say I have no locus, and because we are on locus now. Please see what the learned single judge does, my lords. The learned single judge in that writ petition, in that round, that is my lord Justice Chandana Gowda, as he then was of our Honorable High Court. Please see, my lords, that order starts at 245. My lords, first observation against me in that order, your lordships will find at paragraph 19 at my lords 263.
It is noteworthy.
Yes, please, my lords, and please permit me to read this. My lords, before I read 19, just one word in dilation. This is juxtaposed to my lord's findings in paragraph 19 of the first order where my locus is protected and the division bench's order which does not touch my locus. But now please see the finding in 19. It is noteworthy that the observations of the learned single bench's order dated 16.5, that was my lord's previous order, which stated that the question of locus standi of a party bringing an instance of state inaction regarding a breach of a lease cum sale agreement by the allottee of a public property is secondary to the issue of illegality presented to the court, was diluted and modified by the division bench in writ appeal number so and so connected with so and so dated 26/7/2023. I don't see where, and therefore I am in appeal over this order. I read further. In that order, the division bench clarified that the petitioners were not necessary parties before the KIDB inquiry proceedings and permitted KIDB to take appropriate action without being influenced by the single judge's findings and observations. Accordingly, please see the next page. Accordingly, the petitioner's locus standi, if any, was negated by the division bench order dated 26/7/2023. With utmost respect, my lords, to this order, English, my lords, the simple reading of the 2 orders, my lords, do not demonstrate it. But anyway, we have now suffered an order, my lords, at the hands of the learned single judge. Now, please see one other paragraph, my lords.
Now,
the other paragraph.
Poe sir, I went through this order. There is no consideration of these reasons to follow aspect in this.
Not one line, my lords.
Yes, not one line. Yes. There
And
is
my lords,
paragraph 18 only, the reference is there to 3-9 order. It is passed later, all that is not considered.
Absolutely not, my lords. And it was raised in the petition and it was argued before this honorable court. My lords, please see paragraph.
All right. Yeah, we'll hear it. And you continue, Madi. Yes.
My lords, please see paragraph number 31 at my lords page number 268. I will not trouble your lordship with the rest of the order, my lords. I'm conscious that we are holding my lords back at this late hour, my lords. I'm sorry about that, but I'll be very quick. Please see 31, my lords. In conclusion, where the locus of the petitioners herein who are disputed shareholders of the allotee before the proceedings in the KADB against the allotee in respect of violations of the lease agreement dated so and so was negated by virtue of the order dated 26/7/2023 passed by the division bench, the petitioners herein do not have locus standi to lay a challenge to the order passed in pursuance to the order dated 26/7/2023, that's division bench, under the garb of espousing public interest by calling to the attention to state inaction qua unjust enrichment. Furthermore, it is well settled that interested parties cannot file public interest litigation. In that light, the finding, my lords, is against me to say two findings. That your lordship's finding of locus is diluted by a division bench's order. I don't see where. Second, the scenario that because in the light of that division bench's dilution, I cannot maintain a challenge to the subsequent order of the KADB after inquiry. This finding is in direct contradiction to the finding in the division bench's order, my lords, where it said that my rights to challenge that order is preserved. Rights of the parties to challenge it in a subsequent proceedings is reserved. My lords, we take this order also in appeal, my lords, before the division bench. The division bench, my lords, considers it. There is an interlocutory arrangement made, my lords, that there will be no breach of the lease deed, etc. I will just show that interlocutory arrangement. The matter is pending before the division bench, my lords, as we speak. My lords, your lordships will find in the order sheet, my lords, in the writ petition paper book, my lords, please come to page number 311, my lords. I'll just show 2 lines of the division bench's order.
I have seen that.
Well, that is, there is an undertaking that all conditions contained in the lease deed will be abided by the parties pending, my lords, consideration of that writ. Now, that is where we stand. When things stood thus, my lords, and I have to straight away now I respond to one legal submission and then I will come to the merit separately. I challenge, my lords, a subsequent action by the very party where about 1/4 of the property, my lords, is further sublet to a third party. And that sublease is on the basis ostensibly as a sublease, but effectively giving the right of that part to that third party to build on this asset and all buildings on this asset to be ownership of the third party straight away, even before a sale deed is executed, my lords, to the primary party who is giving that sublease. And therefore,
board is a party to all this?
Board is a party to all this, my lords. Even in the subsequent petition, board is a party, and that's why the learned advocate general appears for the board even in these proceedings. That's what my esteemed friend Mr. Shetty, my lords, indicated.
Does he have any objection, my lords?
Certainly not. I welcome him, my lords. We have grown up together in the corridors of Nagarbavi, so why will I object, my lords?
Yes. Why, sir?
Yes, my lords.
Can we continue it tomorrow?
Please, my lords. May I make one request, my lords, subject to my seat.
And I'm exhausted.
Monday, my lords. Friday after.
Monday.
Yes.
Monday will take it. Whatever the time, Monday will finish it.
Yes, please. I'm great.
Yes. Raghavan sir. Monday Magusten.
I do not even want to raise my voice now because of the warning given by Mr. Sachin Puvaya to me.
No, Melas, who am I to warn my guru? I only learned from him.
Including on how to give warnings.
Heard so and so. List on Monday at 4 p.m.
Please, Melas.
Great.
I'm grateful for the late evening hearing. Great.
Yes.
Grateful to
sorry to make this establishing.
Next Friday.
Serial number 1, sir.
Monday, madam. Friday. Friday.
So my serial number 1.
Serial number 3, my lords, in the Bangalore list.
We'll have it Monday. Next week, I'll come and then put it there, madam.
Tuesday, I'm there, my lords, in Dharwad.
Then Tuesday, we'll take it. Yes.
Please,
Dictation of order, serial number 1.
A damage award.
All orders ಇದೆ serial number 1. Bangalore bench.
ಅದು ಗೊತ್ತು ಸೇಮ್ ಅಲ್ವಾ ಫ್ರೈಡೆ
ಧಾರವಾಡ ಬೆಂಚ್
ನೀವು ಯಾರು
14%.
AGS.
which serial number?
20, my lord.
Serial number 1.
ಯಾವತ್ತು ಬೇಕು?
ಬೆಂಗಳೂರು ಬೆಂಚ್. Dictation of order ಇತ್ತು.
Yes.
Court officer.
Yes, sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಡಿಕ್ಟೇಷನ್ ಆಫ್ ಆರ್ಡರ್ ಇತ್ತಲ್ಲ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಯಾವ ಡೇಟ್ ಹೋಯ್ತಮ್ಮ?
ಸೀರಿಯಲ್ ನಂಬರ್
1 ಬೆಂಗಳೂರು ಬೆಂಚ್
1 ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಅಂದ್ರು ಸರ್.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಹೋಯ್ತಾಯ್ತಾ? ಓಕೆ
ಮೇಡಮ್ 3 ನ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿದ್ರಲ್ಲ?
3 ಟ್ಯೂಸ್ಡೇ ಮೇಡಮ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಡೇಟ್ ಹೇಳಿಮ್ಮ ಕೋರ್ಟ್ ಆಫೀಸರ್. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಯಾವಾಗಮ್ಮ?
ಹಾ ಸರ್ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 12.